ಸಾಹೇಬ್ರ ಜೊತೆನೆ ಬರ್ತಾರೆ. ಸಾಹೇಬ್ರು ಯಾವ ಡೇಟ್ ಹೇಳ್ತಾ ಹೋಗ್ತಾರೆ ಸೈಡಲ್ಲಿ ಎಲ್ಲರೂ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಯೂಶಲಿ ರೆಡ್ ಇಂಕ್ ಅಲ್ಲಿ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. ಆಮೇಲೆ ನಾನು ಬರ್ತಾರೆ ಅದೆಲ್ಲ ಮಾರ್ಚ್ ಇರ್ತದೆ. ನಾಗರಾಜ ಸೋಮೇಶ್ ಅದೇ ಅವ್ರು ತೀರೋದ್ಮೇಲೆ ಗೊತ್ತಿಲ್ಲ ಈಗ ನೋಡಿ ಇಲ್ಲೇ ಬಂದ್ರಲ್ಲ ಅವ್ರನ್ನೇ ಕೇಳಿ ಅವ್ರ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಅಲ್ಲ ಮೆಮೊ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ನೀವು ಪಿಟಿಷನರ? ಇದೇ ತರ ಹಾಕ್ಬಿಡಿ. ಫ್ರೆಶ್ ಇದ್ರೆ ಕೊಡಿ. ಆಯ್ತಾಯ್ತು ಇಟ್ಕೊಳ್ಳಿ. ಫ್ರೆಶ್ ಅಂದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರುವಂತದ್ದು. ಹೌದು. ನೋಟಿಸ್ ಅಂದ್ರೆ ಬಿ ಗ್ರೂಪು. ಹಂಗಂದ್ರೆ ಪಾಪ ಇವರೆಲ್ಲ ಯಾಕೆ ನಿಂತ್ಕೋಬೇಕಾಗಿ? ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಆತರ ಫ್ರೆಶ್ ಸರ್ ಅದು ನೋಟಿಸ್ ಆಗಿದೆ. ಹೇಳಿ ಅದೇ ತರ. ಅಲ್ಲ ನಿಮ್ ಕಷ್ಟ ಏನಿದೆ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ. ನನಗೆ ಹೇಳಿರೋದು ಅಷ್ಟೇ. ಫ್ರೆಶ್ ಅಂದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರಬೇಕು ಕೋರ್ಟ್. ನೋಟಿಸ್ ಆಗಿರೋದೆಲ್ಲ ಫ್ರೆಶ್. ಬಿ ಗ್ರೂಪ್ ಕೊಟ್ಟು ಫೈನಲ್ ಇಯರ್ ಸೀನಿಯರ್ ಬರ್ತಾರ. ಫ್ರೆಶ್ RSA matters ಕೊಡಿ.
Fresh matter ಕೊಡಿ.
That's 2018 matter, my lords. Pension is not settled.
Yes, 16th.
16.
Yes, 18th.
My lords, pro rata pensionary benefits have not been given.
Yes, 18th.
My lords, they are connected matters, both of
Yes.
them. Please.
ಅದು 18 ಕನೆಕ್ಟೆಡ್ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಕೊಟ್ಟಾಗ 18 ಹೇಳಿದ್ರೆ ಸಾಹೇಬ್ 19 ಮುಂದಕ್ಕೆ
Yes, 23rd. Yes,
23rd.
23rd.
My lord, 2023 matter. Kindly listed in B3.
24th. Yes, 24th. Yes.
My lords, it was a date given matter for Monday, my lords, 23rd. However, the matter is not listed. My lords, may I kindly have this matter?
What is that matter?
My lords, the urgency is, my lords, the transfer order is passed without notifying the place of transfer, my lords. My lords had heard this
Date
matter.
ಕೊಡಿ.
ಮೂವ್ ಮಾಡಿದ ಮ್ಯಾಟರ್ ಅದು
Illa, date.
ಕೊಡಿ ಆಯ್ತು.
Verify. Yes.
ಕೊಡಿ ನನ್ನ ಕೈ.
Yes.
ಬೇರೆಯವ್ರು ಹೇಳಿ ಮೆಮೋಸ್.
Fresh matter ಕೊಡಿ ನಾಳೆ ಬರ. 24th. Yes.
24th.
Yes. Yes, list number 2 refer to Loka Adalat on 14th.
Serial number 12 minutes, list number 2. ಅಷ್ಟೇ ಹೋಗಿತ್ತು ಕ್ಯಾನ್ಸಲ್ ಆಗಿತ್ತು.
ಆಯ್ತು ಬಿಡಿ, ಅದಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ನೋಡತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ ಸಪರೇಟ್ ಆರ್ಡರ್. ನಿಮಗಿದ್ರೆ ಹೋಗಿ ಸೆಟ್ಲ್ ಆಗಂಗಿದ್ರೆ ಎಸ್, ಇಲ್ಲ ಅಂದ್ರೆ ಎಸ್.
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಇಫ್ ಎನಿ.
My lord,
number
serial
1 adjournments.
48, my lord, serial number 48.
48.
I am appeal for the petitioner in second matter, my lord. I will intimate the other side. Kindly have it done next week, my lord.
Yes, at the request, the request of counsel for petitioner, leave this matter after 2 weeks.
My lord, the date may be fixed, my lord.
Yes, 23rd.
Much.
62.
I have to seek instructions on that. So So kindly have it first week of March.
You are for respondent.
No, I'm for petitioner.
Petitioner. At the request
Yesterday they
of
served an objection copy.
Council for the petitioner, leave this matter after 2 weeks.
No, date may be given.
Yes. 24th. Yes.
24th.
24th.
Please. 24th of March.
Yes.
Date it. Because it is a guest lecture matter, my lord.
Over silent.
Remote may kindly.
Yes. Serial number? You are appearing for respondent number 2. Have you informed other side? Yes. At the request of council for the respondent. 23rd. Yes.
Number 1 for preliminary hearing, serial number 1.
I appeal for the petitioner. Lord,
Yes.
Lord, dismissed Lord personnel from Lord the BSF force. Lord is requesting Lord for a compassionate alliance or a medical pension, Lord. Your Lordship may kindly turn to Annex H, Lord, page 56. This was the earlier writ petition. A representation was kept pending, Lord, by the department. That was directly considered. Now the same is considered and rejected, Lord, by Annex A.
Annexure?
Annexure A. That is, Lord, page 30. Relevant paragraph, Lord, is at page 16 with regard to granting of Lord the compassionate Lord alliance. 10 onwards.
You take notice.
My lords, I appear for the respondents in this matter, my lords.
Yes.
My lords, kindly see, my lords, he was dismissed in the year 1992. There's serious delay and laches, my lord. He's asking
Yes.
now for medical pension. He's not even entitled, my lords. The Annexure A order, my lords, is reasoned. The representation is considered and through a speaking order rejected, my lords.
Yes. No, that is also in 2024.
Please, my lords, that also there's a delay.
Yes, you are taking notice. You are already taken notice to R1 to
My lords,
yes.
I was on advance notice, my lords. My lords, your lordship may consider whether
Yes.
this is a matter that requires notice, my lords. 1992, he was dismissed.
Yes. No, you
And
post it for
he's asking
B
for
group and
medical
take it.
pension now after 30 years, my lords. There's no entitlement for a person for medical pension after dismissal.
And you taken up, Lord, for B group.
Yes, you take so and so is directed to take notice for 1 to 3. Leave this matter in B group. We'll hear in B group and dispose of. Yes.
My lords, your lordships may give me a short date and here at this level itself, my lords, on this stage, because my lords, it's a 1992 matter, my
No,
lords.
if I start hearing this stage, I can't reach other matter. Therefore, it should be in B group. Yes. We'll have it on 17th. Yes.
Very well,
Please,
very
this
well.
B group. Yes.
Serial number 2, Samir Sharma for petitioner.
Dispensation with production of certified copies of the Annexure A. 4 weeks. Yes.
Annexure dispensation are filed.
Yes. 4 weeks you have to produce.
Please.
Yes.
Annexure A, lordship finds at page 40. My request for according grant in aid status to the post and respondent number 4 comes to be rejected by virtue of Annexure A. Now, there is no appeal mechanism under the Act. There is a revision provision under section 131. My respectful submission is that is not an efficacious remedy as what a coordinate bench has held.
Which,
So
where is that?
Sir, Ganesh Rao mic mute ಮಾಡ್ಕೊಳ್ಳಿ. Mic mute ಮಾಡ್ಕೊಳ್ಳಿ.
Could your lordships please come to page 13? In the context of this very legislation, at page 13, para 28. Now, what remains is whether petitioners can file a revision before the state government as provided under section 131. Then 131 is extracted. Proviso appended to 131 says that the order under so and so request to be made only after so and so. Then if a lordships were to turn overleaf to page 14, petitioners are working as so and so. They can be said to be agreed persons when ordered by the private education institution. They may question the said order before the state government by filing an appropriate revision petition. The question is whether that remedy provided under section 131 of the Act is effective and efficacious. A division bench of this court in the case of so and so has observed that revision is not a right and it cannot be at all equated to the right of appeal, and therefore failure to invoke revisional jurisdiction or avail the remedy of revision by itself would not disentitle a party aggrieved to invoke the jurisdiction of this court under 226 and 227 of the Constitution. Nor such failure is a bar for exercise of jurisdiction under 226 or 227. Here again, it is felt, it is left to the discretion of the court either to
That is what,
entertain-
who said that writ is not maintainable?
Yes.
It is maintainable.
Yes.
But it is for the discretionary power. Court
Yes,
can
in-
say that. Yes.
In fact, on the previous occasion, what had fallen from your lordships was, is there no appeal is what your lordships had asked when this matter was listed. In fact, the authority who has passed the impugned order is the very appellate authority under the concerned rules.
No, not appellate authority, revision.
Revision, my respectful submission is,
Who has passed this order?
the order is passed by respondent number 2, which is the director.
File an appeal to that.
Appeal provision falls with
No, revision.
revision. My respectful submission is, lordship may consider what has happened in this case. The petitioner was already in 2 rounds of litigation before your lordships, wherein on
I
the,
thought it has been rejected in 2022.
Impugned
What are
order
you
is
doing?
in the year 2022.
it was not rejected. The endorsement comes to be rejected, yes, in 22. In fact, this again fell from your lordship from the previous occasion as to why have you filed a writ petition in 2025. My respectful submission is, lordship may come to my list of dates at page number 5 for a moment. Sorry, page number 4.
Yes.
Page number 4, serial number 18. That particular writ petition, I was before this court, that comes to be disposed of. At serial number 20, 28, 2022, the impugned order is passed. Then at serial number 21, your lordships were to please see, I in fact made representations to seek redressal of my grievance. Then your lordships were to please see at page 5, serial number 23. This is where the problem begins. What I am really aggrieved by, in addition to the impugned endorsement, is the fact that I've been terminated from service without any notice at all. Now that termination comes at serial number 25. That is in September 2024. I was functioning in a fully functional sanctioned post for 19 years. And after putting 19 years,
Where is your termination order?
no, there is no termination order. That is
Then-
my exact grievance.
How can you say that they have terminated? Who has terminated you?
The respondent number 4, they have stopped paying me salary. They are not assigning any work at all. Now that happens in September 2024, which is what drives me to this court at serial number 26 at page 5.
September 2024, you have been not allowed to come to that.
Yes.
Then what are you doing for till?
No, 2024, that happens 30th of January 2025. An order is passed by this court in another writ petition that I filed, and this court was of the view that you please avail appeal under the Act. Now, under the Act, after this order was passed, I come to realize that the appellate authority is the same person as who has passed the impugned order, which is why I'm again before your lordships. That is what has happened.
No, where is that appeal, writ petition which is directed you to file an appeal?
Please, could your lordships please come to page 130, 130. 11th portion is at page 133. When petitioner is provided with alternative remedy and when the matter requires examination of factual aspects, so and so, appeal remedy under section 130, accordingly writ petition stands disposed of. Then I in fact avail my appeal remedy. Now that order comes to be passed at page 134. 134, 11th portion is at 135.
What they said?
Now they have rejected my appeal.
131 ಅಲ್ಲಿ ಹೋಗಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes. Now 131, my respectful submission is, revision is not an efficacious remedy for me.
No, that is for the court to decide.
Please, I am placing it for your lordship's consideration. My only respectful submission is, given the fact that
No, earlier order, this
Yes.
court instead of saying
yes,
file in a revision,
Yes.
court has said that appeal.
yes, I am not casting aspersions or calling that into question.
Yes.
What was the wisdom of this court? It fell from this court. I then went in appeal. I was not successful, which is why I am before your lordship. They have said you avail 131. 131, my respectful submission is, it again goes before the state government. The authority who has passed this order, that is respondent number 2, there is not going to be much difference between that particular entity, that particular authority and the state government, which is why I'm coming before your lordships. If notice may be issued, I'll...
No. We go file in a revision. Why you want to spend again
No,
time here?
can I just take your lordships to my prayer?
No,
then
very
for-
same order, this court said that you have an alternative remedy.
Yes,
Instead of that 131, court said 130.
yes.
Now that appellate authority has also directed you to go to revision.
Yes.
Why can't you go that revision? They
Now,
will
could your
decide.
lordships, just in the peculiar facts of this case, could your lordships please come to page 36?
Yes,
Lordships may kindly see my prayer at prayer C.
yes.
Issue a writ of mandamus or other appropriate writ order so and so
Hmm.
to the respondent number 4 to resume the assignment of regular work to the petitioner. Now, my grievance was there was no hearing that was conducted, no misdemeanor of mine, there was no penalty imposed.
Hmm.
Summarily, without any notice, I have been discontinued from service. Now, I was in a fully sanctioned post. If I was in a deputational or some temporary post, I understand. I bow
No,
down.
you have been, appointment has been approved by that.
Yes, yes. The appointment order is also to please see at page 52.
Hmm.
This is my full-time appointment before the respondent number
I
4.
think take notice, please. Yes. Let us.
May I also seek for one indulgence? Respondent number 4, can I take out hand summons?
Government advocate is directed to take notice to 1 to 3. Counsel for the petitioner is directed to serve 3 sets of copies on government advocate. Issue emergent notice to respondent number 4. In addition, petitioner is also permitted to serve hand summons.
I'm grateful.
Yes.
Cell number 3, Chandrakant Argavale for petitioner.
That's for the petitioner in this matter, my lords. My
Yes.
lords, my prayer before my lords is that to release of full family pension arrears to the petitioner herein, my lords. Initially, my wife was working as a teacher, my lords.
Hmm.
She passed away on 11/5/1994, my lords. After which I approached the civil court for the succession certificate, which came to be dismissed. MFA was preferred and remanded back, after which the parties arrived to a compromise, and I am entitled for the said pensionary benefits, my lords. In spite of so many representation, my lords, the authorities are not releasing the family pension. Annexure H may kindly be seen, my lords.
Yes, government advocate is directed to where you are working.
Working in a government lower primary school teacher, my lord, was.
Then you have to go to that KT, madam.
My lords, we have approached the
They
KAT
are not-
since this honorable court already took a decision with respect of releasing of the said amount, my lords. The KAT did not entertain my application, my lords.
Where is that?
My lords, kindly, my lords, page number 37, my lords.
Application applies out the direction restore or release the family pension so on so civil court. Permanent council applied file memo Chikmalapura. It is pertinent note subject matter of the grant of family pension has been subject court in the expedition circumstated since the matter stands settled.
If my
Order
lords
of the
come
High Court
to
in the matter of settlement of pensioner benefit decision government servant in favor of the second person rejected the same issue before that.
page number
For seeking direction
41,
to
my
release the
lords.
pension of pensioner benefit application should not arise. ಅವ್ರೇನೋ ಬರ್ದಾಕಿದ್ದಾರೆ ಬಿಡಿ ತಗೊಳ್ಳಿ ನೋಟಿಸ್.
My lord, it has go to.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ
go
ಸೆಟ್ಲ್
back to the
ಆಗಿದೆ ನಾವು
KT.
ಎಕ್ಸ್ಪ್ಲೇನ್
KT itself, my lord.
ಅಲ್ಲ,
Previously, they have approached this honorable court, my lord, and order was obtained. Thereafter, they made an application before the KT. That application, they have wrongly dismissed as a res judicata.
not
That's
just
what they
judicator.
create-
Court
what-
said
already-
matter is settled between the matter was settled in the High Court, therefore we can't entertain. Again, they will send it back. Yes. Government advocate is directed to take notice for respondent. One ಗೆ ಮಾತ್ರನಾ? District Treasury ನೀವೇನಾ?
ಎಲ್ಲರಿಗೂ ನಾವೇ
1 and 3. And Amaresh for respondent number 2. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate, 1 for Amaresh. Yes.
Serial number 4, Vivek Raj M for petitioner.
Petitioners in this, my lord. I have filed, my lord, seeking for a writ of mandamus, directing the respondents, my lord, not to harass me in the guise of conducting illegal counseling sessions. Petitioner, my lord, working with the respondents for the past 36 years in the department. Certain misdeeds in the department, my lord, I pointed
Where you are
out.
working?
HL, my lord, respondent number 2, Hindustan Aeronautics. I was working with the finance department for the past 36 years. There are certain discrepancies in my payslip, which I pointed out, my lord, which my lord would find at Annexure B. Now, thereafter, I had also marked a copy to the Vigilance Department. Thereafter, my lord, at Annexure D, page 20, my lord, instead of being appreciated, my lord, I get this Annexure D, my lord, which says, at serial number 2, that is the petitioner, my lord, last 2 lines, all payroll-related work allocations relieved from the responsibility with immediate effect.
No, if they are harassing, go and give in a police complaint. What is that mandamus you are seeking?
I send them a statutory legal notice, my lord, that my lord will find at annexure L, page 30.
Where
Stating that because I was transferred, after this I was subsequently transferred. And my lord, I was put to immense mental trauma and pressure. So I send them a statutory notice seeking, I was stating that I will, my lord, approach honorable CAT and other relief. For that, my lord, they start conducting this illegal counseling sessions at annexure M, N and O, my lord. Thereafter, they harass me and get me, they ask me to write a letter stating I will withdraw, my lord. It is my constitutional right, my lord.
No, go and give in a police complaint. What mandamus can be issued to not to harass, mister?
Because now they're not letting me,
If they are harassing you, give in a police complaint. If any order passed by harassing, then you can challenge that order. Not to seek that, not to harass. This is not that we are.
They've got a letter returned for me stating, my lord, at annexure O, my lord, page 45. They asked me, after the harassment, they even got it in writing stating that the legal notice sent is withdrawn.
No, for that you give in a police complaint if they are harassing you.
So because I have to, my lord, it is not only about the harassment.
No,
is one
show me
aspect.
any judgment under mandamus, you can seek your employees to not to harass.
You know, they are in the guise of
You
conducting.
show me that law, mister. I have to decide on law or on your convenience.
Because
Show me
now,
that any judgment.
Because by way of this, by way of.
No, you can understand what I am saying.
Please, yes, my lord.
Convince
My
me and
only
by
grievance-
showing that judgment.
My only grievance, my lord, I have sent the legal notice stating I will approach CAT and even file a recovery before the civil court. Now they got that said letter withdrawn, my lord. That is the only thing.
What is that?
At annexure O, they have taken it in writing for me stating that
No, directed you to withdraw that case.
They've got-
Go and file an application in the case where they are pending.
there is no pending. I only sent them a statutory notice. Instead of replying to the said notice, this
No,
is
Mr.
the conduct.
Counsel, you convince me your prayer is to direct that employer not to harass.
In the guise of conducting counseling.
Show me any judgment on that point.
Please.
Yes.
Thank you.
Mandamus can be issued to not to harass. Yes.
Please.
Yes. You get that judgment and convince. When do you want?
Next week.
Yes, leave this matter next.
But date me.
Any date, if you are ready, you move that matter. Yes.
Serial number 5, Suhas CS for petitioner.
Yes.
For my lords, on a limited prayer seeking for mandamus against a respondent number 2 to consider my representation and to pass an order in a time-bound manner, my lord.
Lord, I will take notice for respondent 1, 3 to 6, my lord. Respondent number 2 is Karnataka residential.
Prayer is at page number 34.
What is that prayer you are seek for?
Page number 34, my lord. If I may. Mandamus directing the respondents, particularly respondent number 2, to consider and dispose of the petitioner's representation dated 13/11/25 in a time-bound manner within a period of 4 weeks from the date of receipt of a copy.
What is
of
that
the
representation?
Now, my lord, the service weightage under the recruitment regulations was not extended to me. Series of writ petitions came to be filed. I also was a beneficiary of the order of this court.
No, have you filed the earlier round of litigation?
Oh, yes. Now, may I just point out?
Government advocate is directed to take notice for respondent number
1, 3 to 6, my.
1, 3 and 6. Issue emergent notice to respondent number 2.
2, my.
4. No, 4 ನೀವೇ ಅಲ್ಲನ್ರಿ?
3 to 6 ನಾವೇ.
3 to 6. 2
2
emergent notice. Yes.
Serial number 6,
Directed to serve 3 sets of copies on government advocate.
serial number 6,
I
Basavaraj.
request for any date to be fixed.
Service ಆಗಲಿ ರೀ, service ಆದ್ಮೇಲೆ. Yes.
The petitioner is working as a Hindi teacher in the respondent institution. As per the annexure J, page number 42. The dismissal from service without an issuing a notice or without issuing an article of charges, my lord.
Who, where?
Respondent number 1, my lord. Yeah, the petitioner was appointed as in the year 2010, my lord, as a Hindi teacher.
Where?
Certain allegation against the petitioner, my lord, the suspension order came to be issued as per the annexure D, my lord, page number 30 on 19/6/2025, my lord.
Without, then you have to file an appeal or this thing under 95.
ಅಲ್ಲ 19 ಇಲ್ಲ ಅವ್ರದ್ರಲ್ಲ ಪ್ರೆಸಿಡೆಂಟ್ ಬಂದು ಬರುತ್ತೆ ವಿತೌಟ್ ಇಶ್ಯೂಯಿಂಗ್ ನೋಟಿಸ್ ವಿತೌಟ್ ಆರ್ಟಿಕಲ್
ಆಯ್ತು ಎಲ್ಲದಕ್ಕೂ ಅಷ್ಟೇ. You file an appeal.
Earlier, my lord, this honorable court has entertained the writ, my lord. page number 16.
No, that cannot be.
ಯಾಕಂದ್ರೆ apply
Alternative remedy, where you are working?
respondent, my lord. First respondent.
First respondent, police,
Public
school, education management committee, Koramangal. ಇದು ಎಜುಕೇಶನ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಬರಲ್ವಾ?
ಇಲ್ಲ. ಪ್ರೆಸಿಡೆಂಟ್ ಮುಂದೆ ಬರುತ್ತೆ, ಪೇಜ್ ನಂಬರ್ 14 annexure A, ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಪ್ರೆಸಿಡೆಂಟ್ ಮುಂದೆ ಅಪೀಲ್ ಇದೆ.
You go and file that.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಪ್ರಿನ್ಸಿಪಲ್ ಆಫ್ violation of the principle of natural justice.
All this private, mister, we have so many.
Earlier, my lord, page number 16.
That is not the ground, mister. I
Earlier,
don't think why that education act is not applicable to this case.
ಇಲ್ಲ ಬರಲ್ಲ.
ಯಾಕೆ ಬರಲ್ಲ? ನಿಮ್ದು ಏನು ಸ್ಪೆಷಲ್ ಏನು? What is the special? Where you are recognized, mister?
CBSE.
CBSE. CBSE ಇದಾದ್ರೆ society.
ಸೊಸೈಟಿ ಇದ್ರಲ್ಲಿ ಪ್ರೆಸಿಡೆಂಟ್ ಮುಂದೆ ಬರುತ್ತೆ. Earlier, my lord, page number 16, annexure B, my lord. Earlier also they have dismissal from service without inquiry, my lord. This honorable court has entertained the writ, my lord.
That is not the ground. You go and file appeal. Yes. Learned. In this order, petitioner has sought for challenging the termination order issued by first respondent. As per that, respondent bylaw nado.
Bylaw.
As per that bylaws,
President of the education.
As petitioner has a remedy of appeal, reserving liberty the petitioner to avail that alternative remedy. The above petition is disposed of.
Original certified copy.
Office is directed to return that original certified copies of that. Which annexure?
Annexure J, my lord.
Annexure J to the petitioner forthwith.
Time fix ಮಾಡಿದ್ರೆ appeal file ಮಾಡ್ತೀನಿ ಅಂತ.
File ಮಾಡಿ time ಯಾಕೆ fix ಮಾಡಬೇಕು?
ಲೇಟ್ ಆಗುತ್ತೆ ಅಂತ.
ಅಲ್ಲ, ನೀವೇ ಫೈಲ್ ಮಾಡಲ್ಲ.
ನಾನು ವೀಕಲ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ ನಾನು ಅದಕ್ಕೆ. Disposal of the appeal.
No, I didn't understand. You had to file an appeal.
Appeal ಆಗ್ತದೆ within 1 week ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ. Dispose the appeal within 3 months.
Disposal of the appeal. ನೀವು ಅಪೀಲೇ ಹಾಕಿಲ್ಲ, ಇವು ಹಾಕು ಬನ್ನಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಎಸ್, ನೀವು ಅಪೀಲೇ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ವೇಸ್ಟ್ ಅಲ್ರಿ.
within 1 week ಒಳಗೆ
ಹಾಕಿ. ಎಸ್, ಆಮೇಲೆ ನೋಡೋಣ.
Serial number 7, ಶ್ರೀನಿವಾಸಕ್ಕೆ.
Petitioners, my lord, represented, my lord, to declare his probationary period. Since, my lord, as per the appointment order at annexure A, my lord, the probationary period is only 1 year. The petitioner was appointed, my lord, in 2018. Lord, the other employees, my lord, appointed along with the petitioner, my lord, there's the probationary period has been declared, my lord, in the year 2020 itself. During that period, my lord, there were no allegations, and the petitioner had also undergone the requisite training as per the regulations. He has passed the departmental examination. And in spite of that, my lord, though there were no the allegations or the inquiry as on date.
Who is your respondent?
Lord, the BESCOM, my lord, is the
yes
permitted to take. Rakshita.
CJ is directed to take notice for respondent. Counsel for the petitioner is directed to one set of copies. Please.
Serial number 8, Ravindra VS.
The petitioner seeking quashing of the annexure L as well as the consideration of representation. The petitioner is appointed during 1990 as a part-time lecturer. Thereafter, as per the recommendation of Kuampu University, some of the part-time lecturers are ordered to join in the duty itself.
Yes,
but during 1997, absorption rules came into force.
Yes.
But during 1997, absorption came into force. Some of the part-time lecturers who are same batch, but they have been observed, though petitioner name has been shown in the very same list. There has been observed on 1/3/2004 itself, some of the 7 part-time lecturers. During that period, 1/4/2006, the university has taken consideration of with respect to adopting the new pension scheme. I have been observed on 2011 itself. In the meanwhile, the Supreme Court has directed some of the all part-time lecturers has to pass NET. I have taken the NET itself. I have passed as per the direction of Supreme Court. I have given a representation to them to consider to the new to the old pension scheme. Now it has been rejected. Before the division bench court, December court has held. Though they have been appointed subsequently after the new pension scheme, the old pension scheme has to be adapted to them. In the meanwhile, I will produce that document. Notice may be kindly issued. I have only sought for no interim order has to be.
ಆಯ್ತು, annexure L ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು 2021 ಅಲ್ಲಿ.
2021 in the meanwhile I have corresponding is to that, but those document I could not produce.
Corresponding and giving in a mandamus will not cure that.
But I am not seeking for mandamus as well as the sum court division bench has passed an order.
That is not the reason. Change of law or that any judgment will not give in a.
But I do admit no. In the
What's
meanwhile,
subject in that?
I made recommendation to the university itself.
Yes.
Carry the error, sir.
Government advocate is directed to take notice for respondent number 1. Council is directed to serve one set of copies, issue emergent notice to 2 and 3.
Please.
Government, really? State Secretary Public School now.
Serial number 9, Suvarna Lakshmi ML for petitioner.
For the petition. The challenges, my lords, to the communication of the ITI board regarding my marks card and its approval.
Production of Annexure D. For a
There
period
are
of 4
identical
weeks.
circumstances, my lords, your lordships as well as the
Dispensation, typed
coordinate
copy
bench
of
is
that
granted.
Annexure A, B and 6. Typed copy is dispensed. Yes. Yes, madam.
My lords, challenges to the certification of the ITI saying, my lords, my marks card is not genuine. Under identical circumstances, my lords, the coordinate bench has granted an order not to precipitate.
Where is that?
Page number 2
Counsel
there, my
for the
lords.
petitioner submits that. In identical matter, this court in writ petition 37491 of 2025 on, what is the date? On date and process.
The next page, 12/12/2025.
On 12/12/2025 has directed the respondent to not to precipitate that matter. Petitioner also seeking a similar relief on the ground of parity. In view of the above, to maintain parity, respondents are directed not to precipitate the matter till next date of hearing. Who is appearing for?
It's government for one, respondent number 1 to 3.
Government
And
advocate is directed to take notice for 1 to 3.
Mr.
Directed to
Pawan
serve
Kumar
2 sets
for
of-
R4 in the connected matter.
Who has taken?
Pawan Kumar Antata.
Pawan Kumar is directed to take notice for respondent number 4.
Great.
Council is directed to serve one set of copies.
For order, serial number 10, Shrikant NV for petitioner.
I appeared for the petitioner. Filed a memo for dispensation of notice to respond number 1, my lord.
Memo for dispensation of notice to R1 filed by that advocate for a petitioner. Who is R1?
Lords of the trust, my lord, I am not claiming any relief against the respond number 1. Since, my lord, the writ petition was filed for a writ of mandamus to consider the representation of the petition, my lords, as per Annexure A. The respond number 2, my lord, the principal of the college. To consider my representation, my lords, and pass
What
appropriate.
representation?
My lords, regarding, my lords, rejoining of the duty, my lords, to the college. The petition has given a representation, my lords, at Annexure A, my lords, page number 10.
Who are you?
My lords, I am the clerk of the, my lords, the college. Initially, my lords, I was appointed as a clerk, my lord. Subsequently, my lords, in the year 2006, I was been removed from the service. Subsequently, I filed a writ petition, my lord, before this honorable court. My lord, this honorable court, my lords, has given the liberty to approach, my lord, the district court under the, my lords, Karnataka Education Act. My lords, subsequently, I filed in the, my lords, appeal before the district court, my lords. The district court, my lords, has allowed my miscellaneous appeal. Lords, Annexure C, my lords, is the order. Thereby, my lords, directing the respondent college to reinstate, my lords, the petitioner, and given the back wages, my lords, of a sum of rupees 6,720. The page number 47, my lords, is the operative portion. Challenging that order, my lords, the college management has prepared a writ petition before this honorable court, my lords. The writ petition order, my lords, Annexure D, page number 50, my lords. The writ petition, in the writ petition, my lords, there was some modification, my lords, in the order passed by the district court. Subsequently, my lords, the writ appeal was filed by the management itself. As per Annexure, my lords, E, my lords, the writ appeal was dismissed by this honorable court, my lord. Subsequently, my lords, the petitioner has given a representation to comply the order, my lord, passed by the district court, and to take back the, my lord's petitioner to the duty, my lord. To the respondents have not been considered, my lords, my representation. At annexure A, my lords, is a representation.
No, that you are seeking executing that order. There is no provision for execution of that
No,
order.
I am not seeking execution, my lord.
Then
My grievance, my lords, is only to consider the representation, my lord, as per annexure A by the college, the respond number 2. That has not been considered so far, my lord, by the respond number 2 college, my lords.
No, what is that representation?
My lords, regarding
In
my
terms
lords,
of that order, you have to give an this thing. Is it not executing that order? There is no remedy for execution of that EAT order.
lords, that has been confirmed, my lords, in the writ appeal.
The writ appeal order, ultimately you have to execute that order of that EAT. Or if this court order, you have to file an contempt. How that writ is filed?
My lords, the district court order, my lords, was passed in the year 2010, my lords. Lords, subsequently, that order was challenged by the college.
Division bench then limitation is start for executing. You can't file a writ for against the or you go before that this thing under 131.
For the, my lords, district court, my lords, Karnataka Education Act, under section 94 of the act.
Any court order which is not obeyed by that, you can go and ask under 131. Under Education Act, they will direct the management, either comply it or we will close that management. Yes, we can't issue provide management to direction for execution. Will permit you go under 131. State government may either so much or an application of any person interested call for examination, education institution or other any authority. Any education institutions, they can.
That is covered, madam.
Yes, you go under 131. Permit. Yes. In this petition, petitioner sought following relief. Petitioner has a remedy of revision under section 131 of Education Act. Accordingly, in view of the above, the writ petition is disposed of, reserving liberty to the petitioner to approach appropriate competent authority under Education Act.
The limitation period, my lord.
Adike revision limitation illa. Yes. I dispose of. Yes.
Serial number 11, Shiva Yogesha for petitioner.
My lord, sir, for the petitioner in this case. My lord, sir, Jilla Panchayat Tumkur, Somayaji.
Somayaji illa yaar idare?
I think Devraj initial.
ಇದರ ಕೇಳ್ಕೊಳ್ಳಿ ಮತ್ತೆ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಬಿಟ್ಟು ಅವ್ರು ನಾಳೆ ಬಂದ್ಬಿಟ್ಟು ಇನ್ನ 3 ವರ್ಷ ಆದ್ಮೇಲೆ ನಾವಿಲ್ಲ ಅನ್ನೋದು. You verify, mister, or you take notice, or you will issue a court notice.
ತುಮಕೂರು ನಾಗರಾಜಪ್ಪ ಇದ್ದಾರೆ. ತುಮಕೂರು
ನಾಗರಾಜಪ್ಪ ಇದ್ದಾರಾ? Yes.
ದೇವರಾಜ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
No, one of them has to say who is there. Yes.
I will take fresh notice, sir.
ಯಾವ್ದ್ರಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಗಿರ್ತದೆ ನಡೀತಾ ಇರೋದು 2024 ಇಂದ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿಲ್ವಾ? You have not paid the court fee.
I think I paid.
What are that office objection, mister? ಅದಕ್ಕೆ office objection complaint ಮಾಡಿದ notice
last time my colleague complained. I will check and I will.
In court, so and so. You complain office objection, mister. Pass over. And also verify who is appearing for. Please. Yes.
Serial number 12, Bola Vedavasa Chennai.
Lordship, appointment to the post of junior assistant.
Steps to be taken in respect of notice issued to the respondent number 12, written with postal chair unclaimed. In service of notice to R12 is held sufficient. Yes, mister, what is this?
Lordship, in the year 2022, the Karnataka Legislative Assembly Secretariat released the notification for several posts, my lord.
Yes.
This case number 18 may be seen.
Along with serial number 50, my lordship. Same circular they have challenged.
Not circular, I'm not challenging
For 6/2022.
I have challenged the list in the particular post. That is a different post. That, my lords, when the matter gets called out, I will argue that. This is for the post of
serial number 50,
junior assistant, my lords. This is for the post of junior assistant. That is for Dalai. That is a different appointment. My lords, may kindly see page number 18. This is the notification released in 2022, Lord. There are 10 posts for junior assistant. In that, my lords, in the current year vacancy, there is one for 2 for rural, 1 for Kannada medium under GM, general merit. and one under 2A, my lords. I'm entitled under 2A, GM rural and Kannada medium, my lords. I write the written examination, my lords. The provisional list is at page number 29. Annexure F.
Yes.
I secure 57.5 marks, my lords. I'm placed at serial number 7.
Yes.
My lords, thereafter, my lords, what they do is they appoint on 1st of April without issuing the final list. Belatedly, they release the final list, my lords, which is at Annexure J. Annexure page number 54, my lords. Annexure M. Annexure H, my lord. That is the final list, my lords. Thereafter, I get to know, my lords, that annexure, according to Annexure J, which is at page number 56, that is how they have allotted the reservation, my lords. May kindly see serial number 3, my lords, and page number 56.
No, this is what the similar matter we have disposed.
My lords, similar matter, but in this case, my lords, what has happened is they issue. I constantly follow up with them, my lords. They issue an endorsement to me, a letter, my lord, which is Annexure M, page number 75, my lords. Last paragraph may kindly be seen. I keep following up with them. They say that, my lords, once writ petition number, that's the last paragraph. Once writ petition number 14388 of 2023 is disposed of, we can consider your post for junior assistant, my lords. This is what the endorsement they issue, my lords. The writ petition is disposed of. What has happened in that case, my lords? Supreme Court has held, first GM posts have to be filled up. Once that is exhausted, they have to give reservation. In this case, they have done the opposite, because of which candidates who have got less marks than me have been selected under GM, my lords. This court in Aruna KP's case, 14388 of 2023, has set aside the entire selection list, set aside the appointment, and remitted the matter for fresh consideration to redo the list, my lords. They give me an endorsement saying once that writ petition is over, we will consider your case.
No, anyhow, we will post it for B group. We'll hear in that B group. Yes.
Those are different appointments.
50 ಬಂದಾಗ ನೋಡೋಣ. Yes.
Grateful.
Yes, lease this matter. Unclaimed health sufficient. The IA 1 for dispensation of certified copies of H and J is dispensed for a period of 4 weeks, subject to condition to produce that certified copies. Lease this matter B group on 16th. Yes.
Serial number 13, L. Srinivas for petitioner.
Now, PF what process issue notice to respondent number 2? Who is it? It is not served. Yes. Now, after service only we can, yes. Week's time is granted to pay the process issue notice to respondent number 2. In addition, petitioner is also permitted to take out hand summons to respondent number. Yes.
Serial number 14, Dheeraj JK for petitioner.
Okay, for the petitioner.
Yes.
I've given a representation at page 103.
Objection.
My lords, office objection has been raised now that pertains to, my lords, the date in one of the annexures, which I can't, my lords, comply. Annexure E
Petition to be stitched properly. What has happened? Date of annexure C stands to be clarified. What is that annexure C?
Annexure C, nam High Court decree ಇದೆ.
ಏನದು? ಏನ್ ಡೇಟ್ ಏನಾಗಿದೆ annexure C ಅಲ್ಲಿ?
11th March 2022 ಅಂತ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಅದು ಪೇಜ್ 88 ಒಳಗೆ ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
88 ಒಳಗಡೆ
88 ಒಳಗೆ 4/4/2022.
ಏನಿದು RSC ಅಲ್ವಾ?
RS ಇದು. ಇದು ಡಿಗ್ರಿ ಕಾಪಿ ಇದು. My lords, anyway, this is not relevant for.
Let me decide. If you say not relevant, you decide and it.
ಹಾಗೆ ಹೇಳಿಲ್ಲ ನಾನು.
Take it and decide. Yes.
I'm sorry, my lords.
Let me see, Mr. It's a High Court order. Why that mistake has been happening? I am
Very well.
searching that.
Very well.
Yes. If you say it is not relevant, why do before this court then? And you are so difficult for you to submit before the court are convincing that. See, High Court order, we are seeing that trial courts, this is mistake is happening. Why this is happening in that High Court? It can be set right. Yes, you are always showing that this thing against the trial court, they are not giving in a proper dates in that orders. Now High Court has making a mistake. Therefore, I am verifying that. What is that mistake?
Page 87, your lordships will see.
Yes.
Last line, my lords.
87. Yes.
11th day of March 2022. Page 88.
Yes.
4/4/2000 left hand side, my lords.
4/4/2022
and 11/4/2022.
To date, see date. I think that is something different. Yes, 11th March 2022 is the date. Yes, what is the date you have mentioned? March 2022. Oh, yes. Yes, what is your case?
My lords, the case is that my lords have given a representation based on this compromise decree. My lords, I am entitled for 65% of the pensionary benefits, family pensionary benefits.
Yes.
My case is now pending, my lords, with the Accountant General at Annexure F for the past 1 year. I have given a representation, my lords, about on 31st of July 2025 at Annexure G, page 103.
Yes.
Said representation is pending.
Yes.
Consideration. My only request, my lords, is that let there be a time-bound disposal of this representation by respondent number 2.
Yes, government advocate is directed to take notice for respondent number 1. Amresh is directed to take notice for respondent number 2. 1 and 3 government advocate. Council is directed to serve 2 sets of copies on government advocate, 1 set on Amresh. Yes. Submission is accepted. Office objection is over.
Any date, my lords?
You serve a copy, then move that matter. Yes.
Service agide.
No. That other council is there. Amresh, yes. He is standing counsel for this thing. Yes.
The prayer is only against R2.
R2 ne. R2.
Accountant General State of Karnataka. State of Karnataka. Accountant General State of Karnataka.
No, he has been given a standing counsel for that. Amresh N. Amresh, yes.
Hearing interlocutory application matter, serial number 15, P. Rajshekhar for petitioner, Santosh S. Nagarale.
Petitioner. Continuation of delay filing in a petition, recalling that why petition is dismissed, Mr.
Dismissed for non-prosecution, my lord. I pleaded medical grounds, my lord. During that period, I have mentioned the name of the hospital. A surgery was undergone, urinary tract infection.
What is this matter?
This matter is, my lord, very simple, my lord. The petitioner who was working as Sirestha in the Principal Senior Civil Judge Ramnagra on 2011, vigilance squad of High Court when came and it was survey was trap was laid, alleging that I was receiving a gratification of 100 rupees and I had kept the money more than this amount prescribed by the circular of and it's contrary to the circular of High Court of Karnataka. An inquiry came to be held against me, my lord, on 2 charges. First charge is that I was receiving an illegal gratification of 100 rupees, which is not proved. And
IA1 of 2024 is filed for continuation delay of 33 days in filing an recalling application to recall order dated 20th/9/2024. Respondent has not filed any objection. For the reason stated in that application, delay of 36 days in filing an recalling application condone. IA1 of 2024 is allowed. Consequently, 2 of 2024 is allowed. Order dated 20th/9/2024 is recalled. Petition is restored to the file.
Only one limited point. Withholding of promotion anta madidare. Period should be specified. Only that point I am.
Recall agide ivat barli post. Yes.
Serial number 16.
Date 2014.
Bharat. Yes. Post adag barlila ನೀವು. Yes.
Sorry, sir.
Serial number 16, Gururaj R for petitioner, Ashok N. Nayak.
Yes.
I am for the petitioner, Vela. This is regarding a filling up of 10 backlog vacancies.
pertaining to 1997 to 2021. So there are 10 backlog agencies and petitioners were working as bill collectors. Before October 2021, it was a common seniority list between the clerks and bill collectors.
ಏನು rule issue ಆಗಿದೆಯಾ ಇದರಲ್ಲಿ? ಆಗಿದೆಯಾ? Why rule has been issued? Now who is your opponent? Yes,
Nayak and government.
Seniority list according to the old rules. Then RDP has addressed a letter to us to
Yes, what
send
is
the
this
list
matter,
with.
Actually, there was a common seniority list before 2021 and the backlog vacancies of 10 pertains to previous to 2021. Till even in spite of so many reminders from the government, the backlog vacancy has not been filled. On the other hand, Gulbarga Jilla Panchayat, they filled all the backlog vacancies according to the old rules. That is in Annexure F. And in the meantime, when this Jilla Panchayat came into being,
Who is
they
appealing
asked,
for government in this case? Ready?
it is covered under Supreme Court judgment, sir. It's covered by judgment.
Verify, mister. We'll have it. Yes, we'll have it on 10th. In the same stage, we'll hear. Yes. Is this matter on 10th?
But if it posted in preliminary B group, it will be in the end. If it is posted in preliminary B group, it will be in the end. And it
No,
will
I
not
said
be.
in the same stage.
Oh, please.
Cell number 17, MS Nagaraja for petitioner, government advocate.
Last time, your lordship directed the government has to secure the records.
My lord, in fact, the government has got the documents, my lord, and I have filed the same in an order, my lord.
Yes, you
Just
give
take-
that.
I will verify it.
Well, I'll just take your lordship to the documents, my lord. It's only interview. Your lordship wanted to know whether they were called for interview. My lord, kindly.
No, just give that brief facts. I forgot about.
Yes, my lord. My lord, affidavit ನೋಡ್ಬಿಡಿ ಅದ್ರಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಯಾವ
My lord, ಇವಾಗ ಹಾಕಿರೋ affidavit ಅಲ್ಲಿ
Yes.
I have covered everything, my lord. The facts of the case, my lord, para 2, my lord.
Yes.
The petitioner has called into question the permission granted by the third respondent changing the reservation roster for the post of assistant professor of geography, and she has sought for a direction directing respondents 2, 4 and 5 to consider the request made by her for regular appointment to the grant in aid post of assistant professor in geography against the vacant post.
Yes.
Further, I sought for a direction to the management to continue her services. And my lord, in para 2, my lord, I have extracted the first interim order passed. That I'll read, my lord.
Yes.
Heard the learned counsel appearing for the petitioner. Learned High Court government pleader is directed to take notice for respondent 1, issue emergent notice to respondent 2 to 5. Respondent number 4 shall not precipitate the matter for the purpose of selection process in filling up the assistant professor of geography. Petitioner is permitted to continue the work in the said post without disturbance. List this matter. My lord, thereafter, it is submitted that respondent number 4 and 5, myself, my lord, entered appearance and filed statement of objections and application for vacating the interim order. This honorable court, upon hearing the application for vacating stay, was pleased to pass the following order. Learned counsel for the petitioner seeks time. Learned counsel respondent 2 and 4 submits that selection to the post of assistant professor in geography is challenged in this petition and an interim order is granted staying the selection to the post of assistant professor. She contends that though the petitioner claims that she was appointed as an assistant professor in geography, her appointment is not approved by the state government. She contends that no selection process was followed at the time of alleged selection of the petitioner to the post of assistant professor. She contends that the petitioner had applied pursuant to the notification which is impugned herein, and therefore the petitioner is also entitled to participate in the selection process. She therefore prays that pending disposal of the petition, the selection process may be permitted to be continued and the outcome of the selection process may be kept pending subject to the result of the petition. Having regard to the fact that the petitioner had also applied for selection to the post of assistant professor in geography pursuant to the impugned recruitment notification, it is only appropriate to modify the order dated 24/12/24 and accordingly it is modified. The respondent number 4 is permitted to proceed with the process of selection of an assistant professor in geography as per the impugned recruitment notification. However, the selection, if any, shall be subject to the result of this petition and no appointment order shall be issued to the selected candidate without the orders of this court. Till an appointment order is issued to the selected candidate, the services of the petitioner shall be continued.
Yes.
Your lordship stopped it at this point, my lord. Rest, my lord, I'll just explain this paragraph, my lord.
Yes.
It is submitted that the interview committee has been constituted by the Vice Chancellor, Mandya University, and the same was communicated to the petitioner via Annexure R4. The committee has been constituted in terms of the notification dated 18/7/2018, issued by the University Grant Commission via Annexure R6. The selection process was continued in terms of the order dated 25/4/2005, passed by this honorable court. The interview committee consists of the following persons in terms of the notification issued by the UGC and nominated by the Vice Chancellor via Annexure R4 and R4, which is as under.
Yes.
I've explained, my lord. The first one is chairperson of the governing body, that is college, my lord, college. The second one is principal of the college, fourth respondent college, head of the department of the college, two nominees of the Vice Chancellor of the affiliating university, of one should be a subject expert, Professor Sannappa. Then Dr. Srinivas. Then two subject experts from some other college, my lord. Totally 8 persons, my lord. Committed. My lord, they are the interview committee members. Then, my lord, the interview letters, my lord, were issued, my lord. My lord, to maintain sequence, I have said Annexure R7, my lord, I have produced. My lord, the R7 shows, my lord, the marks, how it has to be awarded. My lord, then the interview letters I have produced, my lord, 1:5. There is a list of 18 candidates, one post, 5 persons were called. R9, R10, R11, R12, 13 are the interview letters, my lord.
Yes.
Out of the 5 candidates, my lord, attendance slip is produced. 2 candidates did not turn up. And, my lord, the marks allotted to 3 candidates separately by the committee, consisting of 8 members, my lord, I have produced. The consolidated marks also I have produced, my lord.
Yes.
Now the proceedings were drawn and sent to the state government, my lord. The state government, kindly come to the last one, my lord, page 30. In page 30, my lord, the regional joint director, my lord, after recording all these proceedings, my lord, has permitted, my lord, the management, my lord, to appoint Dr. Sidraju, who has, my lord, merited, who stood first in the list, my lord, which is at page 33.
Yes.
This is your lordship only wanted to know because my learned friend said no interviews were held.
Yes.
Nothing was done. Well, I myself was surprised if your lordship could see the mark sheet of 8 the committee members, my lord, and
Yes, I have seen that. Yes.
are 18 onwards.
Yes,
my lord.
Mr.
And she
Your
stood
case.
in, my lord, 1 minute. She stood in serial number 14, my lord.
Yes.
In
Who?
the list.
Petitioner.
Petition.
Yes.
My lord, my submission. 1:5 we have sent. There are 2 candidates have been observed. And there are 3, we have given mark the selected candidate.
No, I will hear him and I will dispose of. Yes, what is this?
My lord, the petitioner, my lord, is a permanent employee, my lord.
Yes. Where is your appointment?
Yes, my lord. At Annexure A, your lordship.
What is that? Read.
Annexure A is an appointment order.
Read.
ನವೀನ TM ವೈಫ್ ಆಫ್ ರವೀಂದ್ರ HM ಇವರನ್ನು ಪ್ರಸ್ತುತ ಜಾರಿಯಲ್ಲಿರುವ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ವೇತನ ಮತ್ತು ಭತ್ಯೆಗಳೊಡನೆ ಮಂಡ್ಯ ಜಿಲ್ಲೆಯ ಮಳವಳ್ಳಿ ತಾಲೂಕಿನ ಕೂರಿಕಾಲು ಗ್ರಾಮದಲ್ಲಿ ಸ್ಥಾಪನೆಯಾಗಿರುವ PLN ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜಿನಲ್ಲಿ ಪೂರ್ಣಕಾಲಿಕ ಪರ್ಮನೆಂಟ್ ಫುಲ್ ಟೈಮ್ ಭೂಗೋಳಶಾಸ್ತ್ರ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರಾಗಿ ನೇಮಿಸಲಾಗಿದೆ. ಸದಸ್ಯರು 2/1/12/18 ಒಳಗಾಗಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗಿ ವರದಿಯನ್ನು ಮಾಡಿಕೊಳ್ಳತಕ್ಕದ್ದು. The probationary period is 2 years. From there, my lord, she is appointed. Her appointment is, my lord, against the vacancy. Your lordship is kindly look into the government order. At Annexure E, in page 24, your lordship kindly. My lord, the vacancy was taken place on the account of retirement of Mariswamy. Is a professor of in geography. The institution is an aided institution, admitted into grant in 2011. By that time, my lord, there is no reservation because that who are all working, they are all admitted into granted aid. My lord, the reservation policy will start only after retirement. My lord, this post has been vacant on the account of the retirement of Mariswamy on 11/5/2015.
Yes, ಭರ್ತಿ ಮಾಡಬೇಕಾದ ಹುದ್ದೆಗಳ ಮೀಸಲಾತಿ ಪರಿಸ್ಥಿತಿ ಜಾಸ್ತಿ.
Yes. ಇದನ್ನ ಏನ್ ಮಾಡಿದ್ರು ಈ ಪೋಸ್ಟ್ ಅನ್ನ ಇಸ್ ಮೈ ಲಾರ್ಡ್ this is the post is ಪರಿಶಿಷ್ಟ ಜಾತಿ lordship as column number 3. The post has been reserved for ಪರಿಶಿಷ್ಟ ಜಾತಿ, the SC scheduled caste. My lord, for that reason, my lord, they have appointed the petitioner as a full-time faculty for the vacant post in 2018. My lord, thereafter, my lord, in the government also, my lord, next Annexure F. they seek a permission to continue with the selection process for the vacant post. Government has issued a notification, the order, Lord, the post is reserved for scheduled caste. That annexure E also same, the government is directed to proceed with the selection. Granted, permission is granted to appointment, proceed with the appointment, reserving the post for scheduled caste.
Yes.
Lord, they are appointed in 2018 institution. They are not forwarded or the appointment to the government. That is their mistake. Lord, that being the circumstances, my lord, in 2024, my lord, the reservation is being fixed by the government is only to the scheduled caste. For that reason, she has been appointed as a full-time bucket. In 2024 Annexure G, that's what I am questioned this before this court is. They have changed the reservation. The management is approached the government to change the reservation under the guise of a single post. Government is accorded the permission in 2024.
Yes.
That Annexure G.
Yes.
That's what, that is I have questioned here. Based on that, they are invited the applications for the post of this, filling up that post. I have approached this court and challenged this Annexure G, but the reservation cannot be changed. That is our contention, my lord. This court is considering the fact on record, my lord, as the appointment process has been held, has been stayed by this court by granting an interim order. Subsequently, by the manager has been approached this court and by filing an IA number 1 for stay the vacating. This court, my lord, by order dated, the respondent 4 counsel has quoted this order 25/4/2025, where they said that, my lord, the petitioner is also entitled to participate in selection process.
No, if it is a general candidate, you can also participate.
Yes, why they are not invited me for interview.
No, you are participated. They said you are in that 5th.
18,
My lord,
serial number 14.
14.
That is a different aspect, my lord.
What
They are
different?
said when she has applied, they said that she is also entitled to participate in the selection process. Means that they have to selection process in the sense it is that they have to call for an interview also. That's what I am telling. That's what I am filing an application, my lord. They are violated the order and they are called somebody, some 5 persons.
Participated in the interview and you are in that 14th. No, they said on the merit list you are in 14.
That is not their case, my lord. They said that she's also applied for the post
they
of
want 1:5. You are not in that range, therefore you have not been called for an interview. That is your case.
That is there, my lord. Why they are made a submission there before the court?
First is that, is it reserved for SC?
Yes, my lord.
If it is changed.
My lord, it's, may I submit this, my lord? It was by the
Government
minister.
has to answer why.
Wait, mister.
The
ಯಾರಾದ್ರೂ answer
Allala,
ಮಾಡಿದ್ರು.
government, my lord, they are not
No,
paid an
you
objection
don't-
to this.
No, it is for me.
Okay,
I wanted.
Government or they are not paid an
No,
objection.
Mr. Council, I want assistance from
Yes,
that. Proper assistance. Even person sitting outside also, if they properly assist, I want to correct order from this court. It is not that who has to answer and he has to answer. Court has to be decided on that law. If they are not assisting, somebody is assisting, why do you worry?
Yes, I am not
Then-
like this.
then
I
why
said
you
that,
are
my lord,
attacking
government,
others?
they are not paid any reply to that till this time.
We'll see
Why
that.
they are reserved staying the reservation?
Yes, Mr.
My lord, if your lordship could see Annexure A, my lord. Annexure A is the appointment order dated 1/1/2018. My lord, this appointment also says number 3, my lord. ಉಪನ್ಯಾಸಕರ ವೃತ್ತಿಯು KCSR ನಿಯಮಗಳು ಹಾಗೂ ಕಾಲಕಾಲಕ್ಕೆ ಸಂಸ್ಥೆಯು
No, see, this appointment.
When this was done.
No, this is not an appointment in terms of that because they are not, she can't claim any rights.
Yes.
Now the seat which is reserved for, if it is for an SC, he can be filed that because he will be only a
My lord,
competitor.
it's
That's
not
what.
that. It's not that, my lord. Kindly see annexure. What he is trying to say is that, my lord, in 2019, an order was passed, my lord, stating that this post may be reserved for the scheduled caste.
Yes.
That an order has been passed, my lord, which is under question in Annexure G, page 29. The commissioner, my lord, is the competent authority. My lord, he brought to the notice that when there is one post, my
See,
lord.
there are so many cases pending before this court. Therefore, I am asking the government. So many management has come before this court that these are all single post. You can't reserve. Their government has reserved and contesting. Therefore, they can't dual stand. Now they have to be answered.
My lord, kindly
In
see
so
annex-
many, you should be very careful when you are answering. There are so many cases pending before this court. Your directions has been challenged, saying that these are all the single post. There cannot be reservation. Now, if you are taking this contention, it will applicable to all also. Therefore, you should be very careful.
My lord, that is altered, my lord, in Annexure G.
No, that is what that.
This order is no longer there, my lord. This order was placed before the commissioner, who is competent, my lord, to take a decision. The commissioner takes a decision. Kindly see
No,
Annexure
commissioner
G.
has to take a decision in accordance with law.
Yes, he has taken. He has
No,
taken.
that's what I am asking.
Annexure,
Eka Vyakti Vibhaga Mishalati Anvaisudilla, he said.
yes, my lord.
Therefore, government has to be confirmed that because there are so many cases which is pending. I put it because in rules to regulations ali, you said if the post which is vacant because of that SC which is reserved for SC, it has to be filled by that SC.
My lord, Idu Mariswamy is not an SC, my lord. He
No,
was
no,
a
no, but
general candidate.
they have-
The person who retired, wherein
No,
vacancy
madam.
arose.
No, madam. What he is saying that it is correct. You are overtaking the government. See, government has taken a decision that it is for an SC. Why they have taken a SC or on the influence of your management they are changing? I want to know from
No,
the
no,
government.
no. Manager, it's
Let
not.
them say that why they have
It's
changed.
the petitioner who influenced.
Is it that stand of the government saying that in all single post in the institutions, the reservation is not applicable? Let them make a statement. It will helpful for me to decide other cases also. They can't change the stand.
In fact, I'll pass
Because
on the
somewhere you
judgment
are
of.
saying that, yes.
My lord, I'll pass on the judgment of the Supreme Court, my lord. Supreme Court says.
No, there are so many other things.
Uh,
See, if there is post has to be clubbed together and reservation has to be applied. There is also in a law.
My lord,
Otherwise, in all that subject, there is only one post. You cannot apply that reservation. See, in the universities matter, somewhere the Supreme Court said, in all cadre has to be clubbed together, then apply that. Now that what is the stand of the state, I want to know.
my lord, in Chakradhar Paswan case.
That's why we know that. Yes.
Your lordship would be knowing.
Melody.
Yes.
But in this case, my lord,
No. What is your stand that in that colleges where there is one post, most of the colleges there are only one post for each subject.
and here in
You
the
said
annexure-
that there is no reservation, then he is out of the court. You file that affidavit, then he has no case because he can't direct the government to do like this and all. If government says that it cannot be reservation, then he is out. Yes. What is your stand on that?
then I will file statement of objection.
No, you say that you have given that annexure G.
Yes, my lord.
You have to say that.
My lord,
Yes, ask your.
annexure G is concerned, my lord, as the committee has taken a decision.
No, mister, you forget about committee or a chief secretary.
Please,
It should be in accordance with law.
yes, ma'am.
You said, Eka Vyakti Vibhaga Misalati Anvaisudilla. This is your stand.
Yes, ma'am.
You file an affidavit, then we'll see that in all other cases also, same thing will be applied. Because in other cases, I think you have filed a direction to see that it has to be resolved. That cannot be conflicting.
My lord, in some cases, my lord, the
No,
management.
we'll have it tomorrow. Verify and make submission.
Please.
Yes. And also see that in that Education Act.
Please.
Education Act, you also verify
Yes,
what is
ma'am.
the.
And the rules also.
Yes, madam. Yes.
If I may be submitted. Lordship, the government has taken the stand in case of all individual autonomous institution that the post, usually the professor and associate professors will be a single post. So they are in 2005 or 2006, the government has issued a circular stating that the roster and the reservation should be applicable.
Applicable. Now that.
Medical colleges, that decision is been implemented, and there was a case wherein this honorable court has set aside the order appointing, making that reservation applicable for single post. It was quashed in one of the writ petition, and it has gone up to Supreme Court, and Supreme Court has stayed it. This is the batch matters are pending.
Now that you verify from that. Yes. If you are stand saying that no, there is no reservation, then he is out. Yes, tomorrow.
My lord, no, my lord, can you have time? 2-star witness tomorrow.
Yes, Tuesday.
Can it be on Friday? Since your lordship has heard, my lord, the matter.
Tuesday. Yes. Tuesday we'll hear. Yes. We'll also see in that
Yes,
Education
my lord,
Act.
that is the higher education rules will applicable, collegiate education rules.
Yes, you see that. What, is there any such this thing? Yes. Because in that university, I think somewhere government has issued each faculty's this thing. There is only one post is there. Therefore, they said club all lecturers as in a one this thing, then apply that
But this is
reservation.
an aided school, my lord. It's yet to be, yet to come under the aid, my lord. It's still one more year is there, my lord. for the-
No, it is not admitted to the grant in aid.
My lord, it's not yet, my lord.
If not admitted to the grant in aid, then
And,
they,
but it will come, my lord, in 1 year, my lord, it will be admitted, my lord. One more year, my lord, for this.
No.
What I'm
no,
informed, my
if
lord.
it is not admitted to the grant in aid, if they want to admit the grant in aid, then they will see that whether reservation is followed or not. Then your institution will not be admitted to the grant in aid.
My
You
lord,
should
one
be
more
very
thing has
careful.
happened, my lord. The petitioner had got that order, my lord, done, my lord, at the level of the government, because this post was never reserved for, my lord, the reservation was never there, my lord. Then, my lord, the commissioner, if your lordship could ask the government.
Who has issued that earlier order for?
But at the behest of the minister. The order has been
No,
made.
therefore they
Then
have to
it
say-
goes before the commissioner, my lord. The commissioner was dare enough to quote the provisions and say that this is never, this cannot be reserved for the post.
No,
my
no,
lord.
no. See, the wording is that, that's why I'm asking. They said this post is never reserved for that, therefore it can be gone for a general. The word is used, since this is a single post, it cannot be. Therefore, I am asking.
I understood, my lord.
That is what. Otherwise, it is for, they can say that this is not any resort for that, therefore we are calling. The reason given is that single post. Therefore, I am saying.
I understand.
Because some other cases is also there. Yes. Tuesday.
Till number 18, Suvarna Lakshmi ML for petitioner, A. Chandrachud.
That's for the petitioner. My lord's matter has to be heard. I'm ready.
Yes. What is this matter, madam?
That's a transfer matter. my
Vacating.
lords.
Yes, ready. Vacating interim order. Who has filed?
I filed, madam.
Ready.
Yes, madam.
All are ready.
No, my lord, we seek in,
Has to
file objection, my lord.
Yes.
My lords, records may be necessary.
My lord, the only ground, my lord, 2 years was not completed as on the date of passing the impugned order.
What is that, this thing, madam?
He was working.
What is that order
My
you are
lords,
challenging?
order under challenge is Annexure F, my lords, which is dated 30/6/2025. The name of the petitioner
Yes.
and the fourth respondent is as serial number 4 and 5.
Yes, you are in which place?
My lords,
Hassan.
please, my lords, Hassan. I am posted to the place of the fourth respondent. Fourth respondent is brought to my place. As on this date, my lords, on
No,
third.
which, he was in which place?
Both are in Assam, madam.
ಕಾರ್ಯ ಮತ್ತು ಪಾಲನಾ ನಗರ ಉಪವಿಭಾಗ
Hassan.
ಹಾಸನ್ ಅಲ್ಲಿಂದ HT ರೇಟಿಂಗ್ ಉಪವಿಭಾಗ ಹಾಸನ್.
Now,
The
when
fourth
did you,
respondent is a serial number 4. She is brought to my place. I am posted there.
you are Tulsi Prasad.
Please, my lords.
Yes, when did you come to that place?
My lords, my transfer order, my lords, is at Annexure A, page number 17.
Next year?
A.
Yes.
I took charge, my lords, in page number 19 on 18/1/2024.
18/1/24.
Please, my lords. My lords, minimum tenure would complete, my lords, on 18/1/2026, which is 2 years.
Yes.
The order, my lords, which is impugned herein, was issued while I had 6 months for completion, which is 30/6/2025.
Now that we
Today,
want-
my lords, I have completed my minimum tenure. But, my lords, in the next 1.5 years, I'm due for retirement. My retirement date is, my lords, on 30/9/2027.
30?
30/9/2027. 1.5 year is there.
Yes. Yes, who is appearing for that KPTCL?
Yes, my lord.
Yes, madam.
R1 torte, my lord.
He is verge of retirement. We cannot transfer.
But as
File
on
objection,
the
my lord.
date of passing the impugned order, my lord, he was left with the more than 2 years of service.
Our order illegal. That order is without jurisdiction.
Inception itself
Now
was
that
bad.
order has been ratified by today because he has completed 2 years.
But
Now search out the judgment, madam. What is the intention not to transfer when the verge of retirement for seeking for an or claiming for his pensioner benefit? He is transferred within the same Hassan. Is it effect?
within the
Is
same
there any-
compound, my lord.
I
one
agree,
bit into
judgment
another.
ಹುಡ್ಕೊ ಬಂದ್ ಕೊಡ್ರಿ. Law is something, mister. We have to assist the court on that. ನಾವೇ ಹೇಳ್ಬೇಕು ನಿಮಗೆ ಹಿಂಗ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೋದು.
Next week.
ಮತ್ ಲಾಯರ್ ಯಾಕೆ ಎಂಗೇಜ್ ಮಾಡ್ತಾರ್ರಿ? You search out, mister, what is the intention for not to transfer when that verge of retirement?
Only, my lord, only for the reason. that,
I
my
thought
lord,
judgment ಕೊಡಿ. Otherwise, law says that she cannot be transferred when verge of
Retirement
retirement.
Justice Raghavendra Singh Chauhan ಅವ್ರದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ತಾವು ಹೇಳ್ತಿರೋದು.
retirement benefits, my
ಯಾವ್ದು
lord,
ನೋಡೋಣ,
they
ಅವ್ರು
cannot
ಬರ್ಲಿ,
be
yes.
delayed ಅಂತ ಹೇಳ್ಬಿಟ್ಟು from one place to another place
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬಾರ್ದು ಲಾಸ್ಟ್ 2 years ಒಳಗೆ ಅಂತ ಹೇಳಿ. That is the only reason. But here my lord is in the same city, within the same
No,
headquarters.
if you are assisting me with the judgment, otherwise I will decide and pass on. Yes.
Next week.
Next week,
When do you want, madam?
next week, any day.
Yes, at the request of respondent number
1 to 3.
1 to 3, leave this matter on 10th. Yes.
Well, it's interim order may kindly.
Interim order granted earlier is extended till next date of hearing.
Grateful.
Still number 19, Panduranga Nayak for petitioner, Giri Kumar K.
Petitioner, my lord, second division assistant, my lord is in the Ambedkar Development Corporation. Alla, one nimisha, impugned order without jurisdiction, my lord, that authority ne CCA rules adopt madilla. Ambedkar Development Corporation. Annexure LES, your lordship's divisional bench judgment. Ambedkar Development Corporation, my lord.
Ambedkar Development
Atalli
Corporation, CCA
implement.
I filed my objections.
Where is that order?
Annexure L, page 169, my lord.
169?
Annexure L, divisional bench order. Lordship.
Yes, we have decided.
Adರಲ್ಲಿ is admittedly till today, they have not adopted the provisions of KCS CCA rules, my lord. The entrustment is under 14A.
Managing director, disciplinary authority 5, ಯಾರು appear ಆಗಿದಾರಲ್ಲ ಗಿರೀಶ್ ಭಟ್.
Appear ಆಗಿದ್ದಾರೆ, contested matter ಅದು.
Yes, sir.
If it is not adopted, then it has to go.
ಅದು ಇಷ್ಟೇ ಪಾಯಿಂಟ್ ಇರುವುದು.
Last 2 days ಅಲ್ಲಿ he has filed an application for amending the prayer.
ಅಲ್ಲ, ಪ್ರೇಯರ್ ಅದು incidental prayer.
So what is that order you are challenging?
Annexure J, my lord.
What is that annexure J?
They had the punishment order.
What is that punishment?
Dismissal from service, my lord.
Then we'll stay that, mister. We'll
ಅದೇ
stay that order.
ಅಷ್ಟೇ, ಯಾಕಂದ್ರೆ second division assistant.
If that is covered, then you have to say
Till
whether
date-
it is rules is applicable or not. If you are not adopted, then the entire order has to go day after tomorrow. You verify and submit. Yes.
ಅಲ್ಲ, ಅದು ಅದಕ್ಕೆ ವೆರಿಫೈ ಮಾಡಿದಾರೆ ಅವರು ಆಸ್ ಆನ್ ಡೇಟ್ ಇಲ್ಲ ಅಂತ ಮೊನ್ನೆ ಹೇಳಿದ್ರು, ಬಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ, Tuesday.
ಅಲ್ಲ,
Tuesday.
Friday.
ಅವ್ರು ಏನಾರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕದಿರ
ಅಲ್ಲ, ಅವರು ಮೈ ಲಾರ್ಡ್ ಕೈಂಡ್ಲಿ ಟಿಲ್ ಡೇಟ್
representing the corporation. If you want to file objection, let him
ಅಲ್ಲ,
file.
ಒಂದು ಸ್ಟೇ ಕೊಟ್ರೆ ಅವ್ರು ವರ್ಕ್ ಮಾಡ್ತಾರೆ second division assistant.
Tuesday I will dispose of that matter.
In the meantime,
Nanದೇ judgment ಇದೆ.
ಹೌದು,
Either
ಹೌದು.
unless their counsel is not brought to the notice of the court saying that.
No, that is okay.
Now if it is brought to the
Even
notice,
till
then
date, if they produce that, it is law.
otherwise it is
ಹೌದು,
covered by.
that is the position. My lord, my prayer, ಅದು ಒಂದು prayer ಹಾಕ್ಲಿಕ್ಕೆ IA 2 allow ಮಾಡಬಹುದು.
IA 1 of 2025 ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, one direction, 2 for amendment of prayer.
2 ಎಲ್ಲೇ ಐತ್ರಿ?
ಕನೆಕ್ಟ್ ಆಗಿದೆ.
ಈ ಎರಡನೇ ಮ್ಯಾಟರ್ ಅಲ್ಲ? Yes, 2 of 2026.
Maybe allowed, my lord.
For amendment, for the reason stated in that so and so is allowed. The petitioner is
Today itself
permitted
will
to file an amended petition, permitted to amend and file an amended.
Today
petition.
itself.
Yes. leave this-
Oblige, my lord. ಮಂಗಳವಾರ ಹಾಕೊಳ್ಳಿ ಸರ್.
Yes. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಹಾಕ್ಬೇಕು.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅಲ್ಲ, ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್.
ಅಮೆಂಡೆಡ್ ಕೊಡ್ತೀನಿ.
Yes.
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ.
B group matter, serial number 20, PM Nayak for petitioner, connected matter, Anupama Hegde.
Lordship, I'm for the responding. Lord, seek a week's adjournment.
2013 matters, it's pending in my.
ಅದರಲ್ಲಿ my lord, there are 7 matters, HMT. The VRS employees, they formed association and they are fighting for their claim, my lord. ಅದರಲ್ಲಿ 2 issues ಇದೆ. ಒಂದು ಎಕ್ಸ್ಗ್ರೇಷಿಯಾ, inadequate ಎಕ್ಸ್ಗ್ರೇಷಿಯಾ ಕೊಟ್ಟಿದ್ದಂತ, ಇನ್ನೊಂದು ಇಂಟರಿಮ್ ರಿಲೀಫ್ ಕೊಟ್ಟಿದ್ರು ಫಾರ್ ನಾನ್ ರಿವಿಷನ್ ಆಫ್ ಪೇ ಸ್ಕೇಲ್. VRS ಕೊಡುವಾಗ ಅದನ್ನ ರಿಕವರಿ ಮಾಡಿದ್ದಾರೆ. That 2 issues are there. ಅದಕ್ಕೆ 2 ಇಶ್ಯೂ ಬೈಫರ್ಗೇಟ್ ಮಾಡಿದ್ದಾರೆ. It is
Yes, you are ready, mister. 2013 matters, 14 matters.
It may be taken up next week, my lord. We have already informed the petitioner council, my lords, today.
Yes,
Senior
at
will
the
not-
request of, you are appearing for which respondent?
In 2 matters for respond number 1, my lords. In 20 point.
our contesting respondent is HMT.
Anupama Hegdena ಅಥವಾ ಮುರಳೀಧರ್?
Union of India, my lord.
ಮುರಳೀಧರ್. At the request of counsel for respondent number 2. Leave this matter on 11th, Mr. Yes.
Serial number 11th, but 21.
Instead of 11th, any other date, my lord?
11th bitre, then 17th.
17th.
Yes.
Petitioner. Serial number 21, B Ramesh.
Seeking appointment.
Yes.
First
Prakash.
clerk, my lords.
Permission to appear for the respondent number 2.
Yes.
First, well, since he was involved in a criminal case,
Yes.
my lords, his appointment was deferred.
Hmm.
My lords, during pendency of these proceedings,
Yes.
my lords, he has been acquitted. My lords,
Yes.
this is the judgment and order, my lords, sentence.
That has been taken on appeal and rule has been issued against him.
This matter. Yes.
And is pending.
No, against this.
Rule issue ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು, ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅಕ್ಯೂಟ್ ಆದ್ರೂ ಕೂಡ ದೆನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ there is no bar unless
My lords, is a fresh
everything
appointment.
is identical, charges are identical, evidence has been given.
My lords, not
No,
inquiry.
not in this case,
Appointment
my
is
lords. It
denied.
is appointment is in question, my lords, since he was been appointed as a first division clerk in the district court, my lords. My lords, since there was a criminal case,
Yes.
his appointment was deferred. My lords, that has been questioned before this court.
But now that
Now he
appeal
has
is
been
filed.
acquitted.
Appeal is filed.
Appeal is filed. My lords, now he will be age bar, my lords. Let a protective, my lords, any protection may be granted.
No, what is that criminal case?
My lords, is a 498A and 302, my lords. My lords, he has been arraigned as accused number 3. Accused number 4, my lords.
Where is that this thing? When that order has been passed?
My lords, that order has been passed. My lords, annexure. My lords, annexure A, my lords.
ಕರ್ನಾಟಕ ಲೋಕ ಆಯೋಗ ರಾಜ್ಯ
With appointment ಇದು.
ಇಲಾಖೆಗಳು
Annexure C, my lords.
ಸಂಬಂಧಿತ ಜ್ಯೇಷ್ಠರ ನಿಯಮಾನುಸಾರ
End of-
ಪಟ್ಟಿ ಪ್ರಕಟಿಸಿ ಸದರಿ ಪಟ್ಟಿ ನಿಮ್ಮ ಆಯ್ಕೆ ಮಾಡಿ ಈ ಕೆಳಕಂಡ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆ. ಆಯ್ತು.
Annexure C, my lords. 11/4/2017. Page 14.
ತುಮಕೂರು ಜಿಲ್ಲಾ ಪೊಲೀಸ್ ವರ್ಧಿಕರ ಸೋನ್ಸ ವರದಿ ಅಂತ ಏನ್ ಪೋಸ್ಟಿಗೆ?
FTM, my lords.
May I submit one thing, my lords?
ಸದರಿ ಪ್ರಕರಣದ ರಜಿದಾರ್ 4ನೇ ಆರೋಪಿ ದೋಷಾರೋಪ ಪತ್ರಗಳನ್ನು ನ್ಯಾಯಾಲಯ ಸಲ್ಲಿಸಿತು. ಸೋನ್ಸೋ ಹಾಲಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆಯಲ್ಲಿದ್ದು ಸದರಿ ವರದಿ ಅರ್ಜಿದಾರರು ಕ್ರಿಮಿನಲ್ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿಯಾಗಿರುವ ಅರ್ಜಿದಾರ FTA ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. Since you are involved in that criminal case, they have not.
That's all, my lords.
Pending cases.
His contention is that now criminal case have been acquitted with. But criminal appeal is filed by the state and rule has been issued. So adhan mugskobalde because he cannot take the advantage of acquittal when rule has been issued.
Yes.
My lords, it would be always subject to the result, my lords.
No.
Yeah.
Tomorrow, if
Rule issue ಆಗ್ಬಿಟ್ಟಿದೆ.
Yes. Tomorrow, if it is reversed, then you
My lords,
cannot.
now let there be a protection for me, my lords. He will be age barred, my lords. My lords, kindly refer to his age. My lords,
No,
as
that
on
is
the
not-
date of,
That is not because of the fault of that employer. You yourself are committed.
my lords, he have been
For-
wrongly implicated. My lords, there is evidence.
No,
in-
but
in the
they say
criminal
that
case.
if it is in a criminal case, that is 498.
Rule is issued, my lords. That's the.
Lords, merely, my lords, I'll verify it, my lords. Kindly have this matter day after
Get
tomorrow.
it, dispose of that matter early, then you will see.
Then
Even
pursuing
then
this
also, I
would
don't
be-
think. They said, ನಿಮ್ಮ ಮೇಲೆ criminal case ಇರೋದ್ರಿಂದ ನಿಮ್ಮ ಅರ್ಜಿ ನೀವು since
Ten.
criminal case has to be decided, it is not that. They
Because he
said
was
that,
appointed.
yes, when
Lords, he-
person who has been appointed, at the time if there is any criminal case is against you, whether you are entitled for the appointment.
My lords,
that is
I'll
the question.
verify it. My lords,
Like
kindly
list
have
in the
this
ಕೈ
matter.
ಬಿಡಲಾಗಿದೆ. So he cannot claim it as a right unless.
If persons who has applied for that, if there is any criminal case against him, can it be considered for an appointment?
No.
My lords, I'll
Rule
verify.
10.
My lords, I'll verify, my lords.
That's law also you have to verify.
Lords,
If
Friday,
that is
my
the
lords.
case, then you are, even if it is acquittal also.
There is one exception, Supreme Court judgment, my lords, 2019 Supreme Court.
Yes.
Wherein they have considered post acquittal. But here is a case, my lords, acquittal has not happened because rule is issued. So ಅದನ್ನ pursue ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ help ಆಗ್ಬೋದು. So 19 Supreme Court ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ?
You have called for an application.
He should disclose it, criminal case is pending.
Criminal case ಇದೆ. Criminal case ಇದ್ದರ್ನ can it be appointed?
My lords, once it is acquitted, 2019, I'll make available the judgment.
My lords, I'll verify it.
If it is before recruitment, it is acquitted.
No, after completion also, my lords,
Can be kept waiting for that post.
no, it need not be, my lords, because state is a model employer, my lords. State is bound to, my lords, on a criminal case which is not proved, you have left him out. So if it is ultimately is honorably acquitted, then you should consider is the findings given. I'll make available the judgment on the next date, my lords.
Lords, Friday, my lords.
Not Friday. We'll have it on 10th, yes.
Yes, my lords.
Bill number 22, Gururaj R for
Hello,
petitioner. Prashant BR.
My lord, I am appealing for respondent number 4 to 6, my lord. My lord, I want some time, my lord, in this case. Next week, my lord.
4 to 6. Yes,
Please,
Mr.
my lord.
Gururaj, what is this?
This is, they are the ex-employees of Karnataka Milk Producers Cooperative Society. And as per the High Court order, they should be given promotion as well as the consequential effects. So they have not given the consequential effects, only the arrears they have been paid. Kindly refer the order sheet, my lord.
That annexure K.
Annexure K is the promotional order, which they have shown to the contempt petition.
What
And
is that earlier order of this court?
the earlier order of this court.
My lord, I have the, may I
Yes,
make
Mr.
one submission, my lord? May I make-
Yes.
My lord, I have the details, my lord, with regard to whatever we have paid. Kindly have it next week, my lord. Due to some inconvenience, I could not appear today.
Yes, at the
This one.
request
Kindly
of
have it
counsel.
next week, my lord.
Respondent. Leave this matter on
2 to
11th.
4, my lord.
Yes.
Obliged.
Please, my lord.
Number 4 to 6.
Serial number 23, KV Narasimhan for petitioner, S. Vasant Madhav.
Lord, I appear for the petitioner. Lord, Annexure G and Annexure D is the impugned order. But if my lords may remember, this is that section 92, non-compliance of section 92. When a major punishment of termination is imposed on the petitioner, without conducting, my lord, any inquiry, without framing any articles of charge. That is my case, my lord. My lord, 28/2015, the present petitioner, my lord, was appointed in respondent number school,
Yes.
was suspended from service for a
Yes.
period of 7 days.
Yes.
That is at Annexure A.
Yes.
Then, my lord, I reported to duty on 28/10/2015. I was not allowed, my lord, to continue the services. Then, my lord, I approached authorities. Two authorities, my lord, that is BEO issued show cause notice to respond number school on 2 occasions, my lord, 28/10/2015 and 30/11/2015.
Yes.
Then, my lord, on 1/12/2015, I was terminated from respond number school without framing articles of charges.
Where is that order?
Please, my lord, Annexure D.
Small submission. Senior is personal inconvenience, he will not appear at the court. Kindly, only 2 weeks may be granted. Last occasion also, I am also seeking the time. So due to the personal
ಏನ ಕೆ EAT ಏನಾಯ್ತು?
Lord, EATL, my lord, they refer to division bench judgment of this honorable court. This honorable court, my lord, has clearly held that, my lord, in case of non-conducting of any inquiry or non-framing of articles of charges, no major penalty has to be imposed until and unless the same is a termination simpliciter. Lord, EAT comes to conclusion that this is a case of termination simpliciter. But in fact, there were allegations made against me that, my lord, I was abusing the students and teachers. And, my lord, that I was.
Where is that order?
Please, my lord, Annexure D. Annexure G is the impugned order at page 27.
Yes.
Lords may come to.
No. Termination order.
Termination order is a Annexure D, my lord, page 13.
Yes. What is this order?
Lord, allegations of rude and uncultured behavior.
Termination issued to the termination of business under the disciplinary reason after giving in a several warning. Rude and uncultured behavior with her co-employee and students. The intensified level of that or intentional behavior in meaning of using that rude language in the school. Co-employee parent students above all are experienced about his name. Due to above mentioned reasons, she has been suspended. The only issue is whether it is a simpliciter or.
Please, my lord.
Yes, Mr. Counsel.
Senior.
Who is
Vasant Maan.
Huh?
Vasant Maan.
Serial number ಎಷ್ಟಿದೆ?
23.
23.
What has happened?
Personal inconvenience.
Next week. That is the only simple matter.
But tomorrow
you have to point out with any judgment saying that this doesn't amounts to stigma. Then he is out of court. Or if you are failed to show that, then matter has to go back to that EA.
Please, my lord, in fact, allegations were made that I was abusing the teachers and students and I was compelling the students to join to my tuition. These were all the allegations made. My lord.
Giving a several warning, her rude and uncultured behavior with her co-employees and students.
There was no warning, my lord. In fact, their exhibits may be looked into.
Still it's
Please,
a simpliciter ಆಗುತ್ತೆ.
In fact, my lord, in that Annexure D order,
Thing that you have to be established.
Annexure D order, they have said, my lord, because I have approached the authorities, that is why they have taken this action. It is a
Yes.
punitive and vindictive actions.
Yes.
So may I request it for tomorrow or Friday, my lord, subject to my lord's board.
1 week.
Friday ಆಗಲ್ಲ. Yes, we'll have it on 9th. 9th, please. That is the only point.
Please.
9th, mister. No further arguments. So no further adjournment.
No, what's up?
Yes.
Till number 24, Raghavendra S. G. Gayatri for
I
petitioner.
2019 in the yak pending ಇದೆ ರೀ.
Lord,
What are you
settlement.
doing from all this? Today it's an inconvenience.
No, settlement ಗೆ ಹೋಗಿತ್ತು. We have sought for
Settlements, yes.
ಹೋಗಿತ್ತು my lord. We have sought for 14 lakhs and 10 lakhs ಕೊಟ್ರೆ settlement ಆಗುತ್ತೆ.
ಅವ್ರು ಎಷ್ಟು ಆಫರ್ ಮಾಡಿದ್ರು?
Very paltry sum. ತುಂಬಾ ಕಮ್ಮಿ ಹೇಳಿದ್ರು.
I will decide on the yes.
Please. Great.
24, Raghavendra G. Gayatri for petitioner, Gurraj Joshi.
Yes.
Lords, I appear for the petition. Lords, kindly take the, Lords may please to take the interim order dated 17/2/21. That's all my case.
17
to 2021.
Yes. Read.
May I read?
Yes.
Prima facie, the second paragraph.
Yes.
Prima facie, the proceedings that is now sought to be instituted by the respondents is contrary to law in as much as the regulation of the respondents Karnataka Rural Infrastructure Development Limited does not permit to institute disciplinary proceeding against the retired employee in the light of there being no provision to hold an inquiry against the retired employees. Therefore, the action of the respondents will fall foul in terms of the law laid down by the apex court in the case of so and so, whereby the apex court has held that there is no provision to hold an inquiry against an employee who has already retired from service. Therefore, there shall be an interim.
No, there is no, they have not adopted KCSR.
No, my lord, there is an independent regulation. But I should,
ಏನೆಂತ ಇದೆ?
as on the date of retirement, there is no amendment. But in the year 2021, there is amendment because that will not be applicable.
Yes. Where is that?
That regulation I have not attached. I have carried it. There, my lords, articles of charges. My lords will find it. My lords, page 22 and 23 is the last paragraph. They have invoked rule 91 and
22. Yes.
My apologies, my lords. I got the book today, my lords. So I
Yes, yes. Which is that? 90? 92?
91, my lords, the same.
91.
91 and 92 is what they have invoked. But
Absolutely nothing is upcoming in employee. Every employee holding the supernumerary post is possible to steps to ensure that so and so. Misconduct. That's
91, 92 retired employees ಗೆ ಏನು ಹೇಳಲ್ಲ.
Yes, mister. That's all.
Seek the instructions, my lord.
No, what is that instruction? Nothing is there. That's all. Otherwise, all matter I have to be urgent.
Lord, this is what amendment is. Now they have included.
That means to say there was no such.
The date of retirement is 37/2016.
37/2016. When that we initiated that departmental.
Lords, articles of charges is 22/12/2018. Lords, what happened is
22/12/2018. After that.
Lords, middle one round litigation ಆಗಿದೆ 2017 ಅಲ್ಲಿ pensionary benefit ಕೊಡಿ ಅಂತ writ petition ಹಾಕಿದೆ. Writ petition they don't come and object anything as to that. One against other assistant executive engineer inquiry is pending. You wait ಅಂತ ಹೇಳಿದ್ರು. I challenge that endorsement. Lords will find the writ order at Annexure Q.
This case.
Annexure Q page 92.
No, that is a different thing. That is not.
ಅಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಕೇಳಿದೆ ನಾನು ಪೆನ್ಷನರಿ ಡಿಸ್ಪರ್ಸ್ ಮಾಡಿದ್ರು ಇಂಟ್ರೆಸ್ಟ್ ಕೇಳಿದೆ ಅಂತ ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಚಾರ್ಜಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು.
No, that where is the date in that articles of charges?
Lords, articles of charges, my lords will find it Annexure A, page 18. Adhika dosharopana patti.
Yes, 2/12/20. Now that what is that amendment they have made?
My lords, the rule invoked is 91 and 92.
When the employee was in service, the same may be instituted against the retired employee with the approval of the appointing authority.
Allegation, my lords will find it page 19.
Same KCSR ನ ಅಡಾಪ್ಟ್ ತರ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
ಅಲ್ಲ ಈಗ
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
That's all. In this writ petition, petitioner called in question Annexure A, initiating the departmental inquiry.
Lords, may in between. Lords, I have prayed second prayer to grant interest on my lords belated payment also. Covered by my lords coordinate bench.
I will direct it to consider for that. Let them
Endorsement issue ಮಾಡಿದ್ದಾರೆ. Articles of charge. Annexure B. I have challenged Annexure B also.
What is that Annexure B?
Not saying that articles of charges issued, so you are not entitled.
No, therefore, now in view of that, let them consider your representation. Yes.
Lords, in terms of judgment of coordinate bench.
Yes.
May I pass on?
What is that?
Very same KR IDL employee. Relying on 2014 Supreme Court, my lords, the Coordinate bench held 8% interest, my lords, at page 4, paragraph 4.
Yes.
Writ of mandamus issued respondent to calculate and pay the petitioner all his terminal with interest of 8%.
No, that is delay. But in
Delay.
your case, that inquiry has been initiated.
Lords,
Wrongly.
here is mine is also delay in, my lords, for this reason. I initially annexed.
Because there is no this thing. Departmental inquiry has
First round, I came before this court seeking release of pensionary benefits with interest because they can't.
What is the directions of this court?
This court, my lords, will find at page 96, 94, 5.
Yes.
Directed to release pensionary benefits.
No interest has been
Insofar as interest is concerned, my lords, this honorable court has said, my lords, whether delay was deliberate or not, you examine and then consider the representation was the order.
Same thing. Yes.
I'll leave it.
Yes. Called in question. Initiation of the departmental inquiry by the respondent by issuing an articles of charges void annexure A dated 22/12/2018. Petitioner you are appointed as what?
My lords, task force engineer, later converted as.
Yes. Was appointed as a task force commander in the respondent corporation. And he was retired as
Superintendent.
Superintendent.
Engineer.
Superintendent engineer on
Lords, 37/2016.
2016. After petitioner retired from the service, the departmental inquiry has been initiated while issuing an articles of charges void annexure A. Being agreed by the same, the petitioner is before this court. Learned counsel appearing for the petitioner has submitted that the respondent corporation has its own, what is this, C&R or what they are called?
Amendment to
rules.
95.
Yeah, C&R rules. Under the said rule,
1996 C&R rules. They have amended 95.
yes, under the 1996 C&R rules, Karnataka Land Army Corporation Limited Cadre and Recruitment Rules 1996. Under the said rules, there is no provision for initiation of departmental inquiry against that retired employee. Since articles of charges has been issued on 22/12/2018, the same is without authority of law. In support of his contention, he has also relied on judgment of Apex Court in 1999 3 SEC 666.
Shall I pass?
Relevant para will explain. Which is that relevant para?
Para 6 minutes. 6 and 7. May I read?
Yes, 7. Yes.
It will be.
He sought for allowing that writ petition. For contra, learned counsel appearing for the corporation has submitted that. The corporation has amended the C&R rules on 25/6/2025, whereby they inserted the provision for initiating the departmental inquiry against that retired employee. Hence, he sought for allowing that the dismissal of the writ petition. Heard the learned counsel for the parties. Peruse writ paper. It is not in dispute. Petitioner has retired as an what engineer? Assistant engineer.
Superintendent.
Superintendent engineer from Respondent Corporation on 30/7/2016. By exercising the power under Rule 91 and 92 of C&R Rules 1996, The corporation has initiated the departmental inquiry and issued articles of charges with Annexure A dated 22/12/2018. Admittedly, the articles of charges has been issued after petitioner retired from the case. It is very clear from the conduct rules, there is no provision for initiation of the departmental inquiry against the retired employee. The relevant rules, Rule 91 and 92 extracted below. A copy kodi. Yes. The apex court, in case of Bhagirathi Jina 1999 3 SCC Supra, has held that in the absence of provision for initiating the departmental inquiry, is without jurisdiction. The relevant paragraph 6 and 7 is extracted below. In fact, this court, while granting an interim order, also has taken note of that same. On 7/12/2022.
21.
2021, the interim order is extracted below.
17 to 21.
Yes, 17 to 2021. The amendment made to that rule is on 25/6/2021. After 3 years from the initiation of the departmental inquiry, the same operates only prospective. It cannot be made applicable to the case of the petitioner. In view of the above, the impugn order liable to be quashed. Accordingly, this petition is allowed. The impugn order Annexure A is quashed. In respect of prior B is concerned, the petitioner at liberty to submit a representation.
I've submitted it Annexure R, my lords.
Is submitted an Annexure R.
96.
Yes, respondent is directed to consider that representation of the petitioner
Dated 24/7/2018.
2018, keeping in view of the order of this court in WP number 14160 of 2017, disposed upon 14 June 2018, within 8 weeks from date of receipt of copy.
There's Annexure B to be set aside, my lords. That is endorsement denying interest.
Yes, A and B. Yes.
Obliged.
A and B is set aside. Yes. All pending applications are disposed of.
Obliged, my lords.
Yes.
Lords, I'll submit the copy to.
Copy code is there. Yes.
Serial number 25 KB Muralidhar for petitioner, Siddhartha Baburao.
Appear for petition in this case.
Yes.
Lord. This is a matter pertaining to Lord giving weightage to the assistant teachers, Lord, who are under Craig Moraji Desai schools, Lord. They are appointed, Lord, on outsourcing basis from 2006 to 11.
Yes.
Lord, he has worked for more than 5 years. This honorable court, Lord, honorable coordinate bench of this honorable court, Lord, in 2012 passed an order to give the weightage, Lord, of 5%. Again, I done Cornelian Tandre. They have issued an endorsement on Annexure J.
Yes.
Annexure J is relevant page number 69, my lord. They have counted 3/10/2006 is the appointment date. In fact, it is on 27/9/2006. Anyhow, 4 days is not a matter.
Yes.
3/10/2006 1 ವರ್ಷ ತಗೊಂಡಿದ್ದಾರೆ. 7 to 8 ತಗೊಂಡಿದ್ದಾರೆ. 8 to 9 ತಗೊಂಡಿದ್ದಾರೆ. 9 to 10 ತಗೊಂಡಿದ್ದಾರೆ. 4 years ತಗೊಂಡಿದ್ದಾರೆ. So far as 1/6/2010 to 31/7/2010, my lord. In fact, he was after 1st August 2010, my lord. He was directed to work as FDA in the school, in the same school. And my lord, your lordship is very well aware. I'm a temporary employee. I cannot say I don't work. In fact, I was compelled to work as FDA that have produced an Annexure A by the respondent only. By virtue of that, my lord, I was working as FDA for 1 year. Thereafter, my lord, challenging that from
when?
2010, that is 1st August 2010, my lord.
No.
1st August
As a
2010.
teacher, you have worked 1/6/2010 to 31/7/2010, only 2 months.
No, no, no. I have worked as teacher from 10 to 2016.
ಆಯ್ತು.
As
6 7 7 8 8 9 9
ಅದು
10
4 ವರ್ಷ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು. ಹೌದು.
4 ವರ್ಷಕ್ಕೆ 20 ಮಾರ್ಕ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
20 ಮಾರ್ಕ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ.
ಇದೊಂದು ಲಾಸ್ಟ್ 1 year ಗೆ ಅವ್ನು 1 ಮಾರ್ಕ್ಸ್ ಇನ್ನ 5 ಮಾರ್ಕ್ಸ್ ಬರ್ಬೇಕಾಗಿತ್ತು. ಅದಕ್ಕೆ ಯು ಹ್ಯಾವ್ ನಾಟ್ ವರ್ಕ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ ಸ್ವಾಮಿ. ನೀವು ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತಾರೆ. ನೀವು ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಮಲ್ಲ ನೀವು ಕರ್ನಾಟಕ ವಸತಿ ಶಿಕ್ಷಣ ಸಂಘದ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ಅಧಿನಿಯಮ 2011 ಜಾರಿಗೆ ಬಂದ ದಿನಾಂಕದಂದು ವಸತಿ ಶಾಲೆಯಲ್ಲಿ ಕನ್ನಡ ಭಾಷಾ ಶಿಕ್ಷಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿಲ್ಲ ಅಂತ. In 2011 he was working as FDA ಅನ್ನೋ ಕಾರಣಕ್ಕೋಸ್ಕರನೇ he has been denied this opportunity. Lord, in fact, when he was posted as FDA, Lord, by the respondent, Lord, he had filed a writ petition before this honorable court, my Lord, pursuant to that interim order granted by this honorable court, my Lord, as status quo, my Lord, there is that is Annexure B is the order, my Lord. Annexure B, page number 24, relevant page is the page number 25, my Lord.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ ಇಲ್ಲಿ?
In fact, this was challenged. The notification was challenged, my lord. Notification of fresh recruitment was made at that time. We were also one of the parties because we had to be counted as
ಗ್ರೂಪ್ ಡಿ ಮಾಡಿರೋದಕ್ಕೆ ನೀವೇನು ಚಾಲೆಂಜ್
ಅಲ್ಲ FDA ಮಾಡಿ ಗ್ರೂಪ್ ಡಿ ಅಲ್ಲ FDA ಮಾಡಿ
ಮಾಡಿರೋದಕ್ಕೆ ಏನು ಚಾಲೆಂಜ್?
ಅದಕ್ಕೆ ಇನ್ಫ್ಯಾಕ್ಟ್ ಅದ ಬೇಸಿಸ್ ಮೇಲೆ ಅವರೇ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. Annexure C may can be seen next pair. ಅವರೇ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಏನಾಯ್ತು ಅಂದ್ರೆ one ಮೈಲಾರಪ್ಪ was taken in my place and I was directed to work as FDA. ಅದಕ್ಕೆ ಅವರೇನೆ ಏನಂತ ಹೇಳ್ತಾರೆ, ಮೇ ರೀಡ್ ದಿಸ್ Annexure C. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಹೊರ ಸಂಪನ್ಮೂಲ ಸಿಬ್ಬಂದಿಗಳಾದ ಮೈಲಾರಪ್ಪ ಮತ್ತು ಸಂತೋಷ್ ಇವರನ್ನು ಕನ್ನಡ ಶಿಕ್ಷಕರ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಸಲು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮಧ್ಯಂತರ ಆದೇಶ ನೀಡುವುದರಿಂದ ಇಬ್ಬರಲ್ಲಿ ಯಾರನ್ನು ಕೆಲಸಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಬೇಕನ್ನು ಆದೇಶ ಕೋರಲಾಗಿತ್ತು. ಅದರಂತೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ದಿನಾಂಕ 26/2012 ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ಎನ್ ಸಂತೋಷ್, ದಟ್ ಈಸ್ ಪಿಟಿಷನರ್, ಇವರನ್ನು ಸೇವೆಯಲ್ಲಿ ಮುಂದುವರಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ವಿಳಂಬ ಮಾಡುತ್ತಿರುವುದರಿಂದ ಹಾಗೂ ಅವರ ಜಾಗದಲ್ಲಿ ಮೈಲಾರಪ್ಪ ಎಂಬುವರನ್ನು ಕನ್ನಡ ಶಿಕ್ಷಕರನ್ನಾಗಿ ಹೊರ ಸಂಪನ್ಮೂಲ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವುದು ನ್ಯಾಯಾಂಗ ನಿಂದನೆ ಎಂದು ಪರಿಗಣಿತವಾಗಿರುವುದರಿಂದ ಆದಷ್ಟು ಬೇಗನೆ ಅವರಿಬ್ಬರಲ್ಲಿ ಮೊದಲಿಗರಾದ ಸಂತೋಷ್ ಅವರನ್ನು ಸೇವೆಯಲ್ಲಿ ಮುಂದುವರಿಸುವುದು ಅಂದ್ರೆ ಟೀಚರ್ ಆಗಿ, ಮತ್ತೊಬ್ಬ ರಿಟ್ ಅರ್ಜಿದಾರ ಅವರನ್ನು ಬೇರೆ ವಸತಿ ಶಾಲೆಯಲ್ಲಿ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಆದೇಶಿಸಲಾಗುತ್ತದೆ. ಉಲ್ಲೇಖ 1ರ ದಿನಾಂಕ 6/8/2012 ಪತ್ರದಲ್ಲಿ ಕಳೆದ 4 ವರ್ಷದಿಂದ ಸದರಿ ಶಾಲೆಯಲ್ಲಿ ಕನ್ನಡ ಶಿಕ್ಷಕರಾಗಿ ಸೇರಿಸುತ್ತಿರುವ ಶ್ರೀ ಮೈಲಾರಪ್ಪ ಇವರನ್ನು ಹಾಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಕನಕಪುರ ಶಾಲೆಯಲ್ಲಿ ಮುಂದುವರಿಸಲು ಹಾಗೂ ಶ್ರೀ ಸಂತೋಷ್ ಅವರನ್ನು ತಮ್ಮ ಸೇವೆಯಲ್ಲಿ ಮುಂದುವರಿಸುವಂತೆ ಮನವಿ ಮಾಡಿದಲ್ಲಿ ಬೇರೆ ಖಾಲಿ ಇರುವ ಮೊರಾರ್ಜಿ ವಸತಿ ಶಾಲೆಗೆ ಮುಂದುವರಿಸಲು ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಮೈಲಾರಪ್ಪ ಅವರನ್ನು ಮುಂದುವರಿಸಲು ತಿಳಿಸಲಾಗಿದೆ. ಮತ್ತೊಬ್ಬ ಹೊರ ಸಂಪನ್ಮೂಲ ಸಿಬ್ಬಂದಿಯಾದ ಸಂತೋಷ್ ಅವರನ್ನು ಸಾತನೂರು ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆಗೆ ನಿಲ್ಲಿಸಲಾಗಿದೆ. ಇಲ್ಲೇನಾಯ್ತು, ಆಸ್ ಅಪ್ಲಿಕೆಂಟ್ ವಾಸ್ ವರ್ಕಿಂಗ್ ಆಸ್ FDA, he was compelled to work as FDA, he didn't have any other option, my lord. Therefore, my lord, he was working as FDA. Thereafter, they only have posted him back to as teachers. What is now being denied, my lord, is that as you are working as FDA during that period, relevant period, you are not entitled. Well, it is not the request of the petitioner.
Again, when you have started to work as a teacher?
August 2012, my lord. That is Annexure C.
2012 ಇಂದನಾ?
ಹೌದು, August 2012 Annexure C ಇಂದನೇ ಅವ್ರನ್ನ ಇದುವರೆಗೂ ಟೀಚರ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ. Even now he is working as teacher. Only for that relevant period, my lord, as they themselves had posted me as FDA, my lord, I cannot be denied.
Notification ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡಿದ್ರು?
Please, my lord.
When the notification has been issued for?
Annexure, that is 2011, my lord, 2011. During that relevant period, I was compelled to work as FDA. Then, in fact, he had given a representation, my lord, to post him back to work as teacher, and that is he has given on the 2010.
Where is that representation? ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನಂತ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ನನಗೆ ಕನಕಪುರ ಕೆಳಗಡೆ ಮಾರ್ಕ್ ಮಾಡಿ ಸ್ವಾಮಿ, ನನಗೆ ಕನಕಪುರ ಟೌನ್ ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆಯಲ್ಲಿ ನೇಮಕಾತಿ ಪಟ್ಟಿಯಲ್ಲಿ FDA ಎಂದು ತೋರಿಸಿ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಶಾಲೆಗೆ ಹೋಗುವಂತಿಲ್ಲ. ತಾಲೂಕು ಪಂಚಾಯತಿ BCM ಕಚೇರಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಬೇಕೆಂಬ ಷರತ್ತಿನೊಂದಿಗೆ ಹಿಂದುಳಿದ ವರ್ಗ ಮತ್ತು ಅಲ್ಪಸಂಖ್ಯಾತರ ಕಲ್ಯಾಣ ಇಲಾಖೆಯ DO FDA ನೇಮಕ ಮಾಡಿರುತ್ತಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಪಿಟಿಷನ್ ಹೇಳಿದ್ದೀರಾ?
ಪಿಟಿಷನ್ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ನನ್ನ ಫೋರ್ಸ್ಫುಲ್ ಆಗಿ ಕಳಿಸಿದ್ದಾರೆ.
ಪ್ಲೀಸ್ ವಿತೌಟ್ ನಾಟ್ ಆನ್ ಹಿಸ್ ರಿಕ್ವೆಸ್ಟ್ ಆರ್ ನಾಟ್ ಆನ್ ಹಿಸ್ ಕನ್ಸೆಂಟ್ ಅಂತಾನೆ ಹೇಳಿದೆ ಸ್ವಾಮಿ.
Yes, where is that? Where you have stated?
Please, madam. Page number 6, para number 6. My lord. Lord, may I read para number 7 ಅಲ್ಲಿ para number 7 starts at page number 10, my lord. ಇಲ್ಲ para number page number 11 ಅಲ್ಲಿ ದಯಮಾಡಿ ನೋಡಿ ಸ್ವಾಮಿ.
Yes.
Page number 11 ಅಲ್ಲಿ fourth line ಅಲ್ಲಿ. Hence, the statement stating that the petitioner has worked as FDA is totally misleading, as the same has been said only to deprive the petitioner of the benefit of the order passed.
Yes, Mr.
Which is
Lord, may I make one submission? Lord?
Yes.
May I read para 5 of the writ petition, Lord? I will give some brief facts of the case, Lord.
Yes.
Lord, the petitioner has applied for the notification issued on 7/5/2011, Lord. And what he secured, Lord, 28%, 48.21% he secured, Lord. 48.21.
48 point ಅದು
48.21%. Lord, as against the general category post, he was applied. The cutoff was the last selected candidate for the general category was 72.77.
ಕೊಟ್ಟರು ಬರಲ್ಲ ಇವರಿಗೆ
ಬರುತ್ತೆ
72.77. That was where, my lord, kindly see the para 6. May I read that? It is his submission, it is not my submission. The petitioner submits that he was selected as a committee handed over to Chief Executive Officer, Bengaluru Rural District, to the post.
Which paragraph you are reading?
Para 6 of the writ petition, my lord.
Yes,
Page
yes.
10, my lord. The petitioner submits that he was selected by the selection committee headed by the Chief Executive Officer of the Bengaluru Rural District to the post of Assistant Teacher Kannada and worked as such from 29/9/2006 till the date of, except from, Lord, this is very important, Lord, except from August 2010, the date on which the petitioner was posted on which his consent.
Without his consent.
Lord, out of his consent as a FDA till the date of 14/8/2025, 2012, my lord. That is where, my lord, Lord, may read the provisions where the weightage to whom it was given. Lord, weightage was enforced in the year 2011, my lord.
ನೋ ಈಗ 48 ಗೆ 5 ಮಾರ್ಕ್ಸ್ ಕೊಟ್ರೆ ಅವ್ರು ಬರ್ತಾರಾ?
ಬರ್ತಾರೆ.
ಇಲ್ಲ, ಅವ್ರಿಗೆ 48 ಬರಲ್ಲ, ಅವ್ರಿಗೆ ಅಷ್ಟು ಬರಲ್ಲ, ಅವ್ರು ಕೇಳಿದಷ್ಟು ನಾನು ಅದು ಹೇಳ್ತೀನಿ ಅಂತ. Lord, may read the C&R provision, my lord. It was not granted to the non-teaching faculty, my lord. Lord, may request my lord to turn at page 27, my lord. 26, it starts from, Lord, item number 9.
Yes.
Item number, my lord, page 26, my lord.
Page 9, item number 19. 19 and 9 ಅದು
9 ಸ್ವಾಮಿ
19
9 ಎಲ್ಲ ಲ್ಯಾಂಗ್ವೇಜ್ ಟೀಚರ್ 9 10 11 12 ಎಲ್ಲ ಲ್ಯಾಂಗ್ವೇಜ್ ಟೀಚರ್ ಇದ್ದಾರೆ.
Page 27.
Page 26, my lord.
26.
ಹೌದು ಸ್ವಾಮಿ. 19 ಕೆಳಗಡೆ ಇದೆ, ಬಟ್ ಅದ್ರ ಮೇಲೆ ಇದೆ ಕನ್ನಡ. he applied for
Yes.
language teacher, Kannada language teacher.
Yes.
Lord, this is where, my lord, first para is very much required because it is covered under this post is covered under the weightage, my lord.
Yes.
May read the next page, my lord. Last line, my lord. Sorry, my lord. In that page, last line, weightage to the contract teacher.
Yes.
Notwithstanding anything contained in these regulations while preparing the merit list, weightage of 5 years for such each
5%.
5% of each completed year of service shall be given, subject to maximum for 40% adding to the total percentage of the degree, B.Ed and B.Ed competitive examination in respect of the candidate appointed by the Karnataka Residential Education Institution Society and who are working as an assistant teacher, Principal Moraji Desai Residential School on contract basis as a one-time measure.
Yes.
This is as a one-time measure, Lord. Lord, may I show that, Lord, from Lord August 2010, he was not working as a teacher.
Yes.
As a language teacher, Lord. That because of that reason, there is no provisions under the C&R rules to grant somebody who worked as an FD or other than the teaching post. Lord.
Yes.
May directly go to, Lord, page number 69, Lord, where the marks is allotted. The weightage is considered.
Yes.
Lord, kindly see, my lord, 3/10/2016 to 30/3/2007, my lord. This is 6 months, my lord. As per the present judgment, not the new judgment, he is eligible for 2.5, my lord, that is proportionate weightage, my lord, for that 6 months, my lord. Lord, these
No,
2
is that
years,
judgment says that is there any minimum period has to be worked in that academic?
Lord, it is not like that. Lord, C and the rules is very much clear. Each completed year, my lord. Each completed year, my lord, that we argued, but we failed that. I don't want to canvass that argument because we are already failed in that, my lord.
No, what is that Supreme Court said?
Supreme Court doesn't say anything, my lord. It says that proportionate weightage can be given.
No, that he said it is not full academic year. If it is,
Oh,
could you
no, but
judgment?
Veerappa, this is Veerappa judgment, Lord. This is a Supreme Court judgment. Lord.
No, I want finding of the Supreme Court.
Please, then copy.
This is there. Yes, which is that paragraph? The ambiguity in the language will not correctly dealing so and so. The employee has paid salary only 10 months. Which paragraph, Mr.? Hearing the counsel for the parties until so and so. Matter we are not inclined to examine.
Lord, that is not said, Lord, that is not clarified at all, my lord. That is
No,
only it says that
no,
proportionate
somewhere I have read in that subsequent Supreme Court judgment an academic year under not full year.
6 months ಗಿಂತ ಕಡಿಮೆ ಇತ್ತು ಅಂದ್ರೆ 1 month ಗೆ 1 ಪಾಯಿಂಟ್ ಕೊಡಬೇಕು. 6 months ಗಿಂತ ಜಾಸ್ತಿ ಇತ್ತು ಅಂದ್ರೆ 8 month I'll give the judgment.
ಮತ್ತೆ ಅದನ್ನ ವಾರ್ಗೆ ಮಾಡಷ್ಟು
ಅದರಲ್ಲಿಲ್ಲ. I'm sure that, my lord, I can assure that.
Veerappa judgment.
That is not
Justice
there
Veerappa
in,
judgment.
Justice Veerappa.
ಎಲ್ಲಿದೆ ಕೊಡಿ ನೀವು
I'll
ಕೊಡಬೇಕು.
produce that. Kindly pass on.
Yes, you also verify, Mr. Yes. But the request leaves this matter on 11th.
Also.
Yes.
Bill number 26, R. Ganesh Rao, petitioner 14%. Pradeep S. Saukar.
For the point number 1.
Yes.
Kindly give some time.
Lord, idರಲ್ಲಿ I had requested my learned friend on the petitioner side to serve me writ petitions paper. ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
Yes,
Not
none
able
appear
to-
for the.
It may be a direction to serve me papers.
Please this matter after 2 weeks. In the meantime, petitioner is directed to serve a copy, petition copy to that council appearing for R1.
Please, grateful.
Bill number 27, Satyanarayana P. Wagade for petitioner. Sumana Baligaya.
Yes.
The respondent number 5 in this matter.
Lord, sir, I love to.
This challenge is, Lord, is the final select list.
Hmm.
So challenge to the appointment order subsequent to the final selection.
I'll have to file an amendment application, my lords. I'll file my amendment application, challenging the appointment order.
Let him do it, then you can file an objection.
Yes.
Then we'll consider.
Please, 3 days, ಸೋಮವಾರಕ್ಕೆ ಹಾಕೊಂಡ್ಬಿಡಿ.
And Somari, file ಮಾಡ್ರಿ.
ಮಾಡ್ತೀನಿ sir.
At the request of petitioner, leave this matter next week.
Bill number 28,
My lords, may
Sundaresh
kindly-
NC for petitioner.
Kindly give a date, my lords, ಇಲ್ದಿರ ಬರೋದಿಲ್ಲ.
ಫೈಲ್ ಮಾಡಿ ಆಮೇಲೆ ಮೂವ್ ಮಾಡಿ ಕಾಪಿ ಕೊಡಿ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ಅಂತಾರೆ ಅವ್ರು ಮತ್ತೆ 2 ವಾರ ಕೇಳ್ತಾರೆ ನಮ್ದು ರೋಸ್ಟರ್ ಎಲ್ಲ ದಾಟೋಗಿರುತ್ತೆ wait
After
ಮಾಡ್ಬಿಡಿ.
23 it is coming only now, my lords. ಅದಕ್ಕಾಗಿ ಅಷ್ಟೇ.
ಆಯ್ತು ನೀವು ಫೈಲ್ ಮಾಡಿ.
ಸರಿ,
You have not see that what is that relief you have to be start. Yes.
28, Sundaresh NC.
Lord, I appear for a petition in this case.
For the respondent.
Lord, the petitioner, Lord, is a retired employee of the second respondent corporation. As per the regulations of the corporation, the employee who is stagnant for without getting any promotion or entitled for time-bound promotion for every completion of 7 years of service. Lord, the respondent corporation has granted 3 time-bound promotion to the petitioners.
ಯಾವಾಗ ನೀವು
First time-bound promotion on 13/4/94.
ಯಾವಾಗ ಅಪಾಯಿಂಟ್ ಆದ್ರಿ?
Is appointed in the year no, 2008
2008
as a workman category 1. Workman category 1.
2008
No,
in
he
the
will
first
automatically, on 91, he was appointed in the year 91.
Yes.
The regulation that which provides for granting time-bound promotion for every completion of 7 years, that is with effect from 13/4/94. Your lordship may
ಆಯ್ತು 91 94 ಇಂದ ಫಸ್ಟ್ ನಿಮಗೆ ಎಲ್ಸಿ ಯಾವಾಗ
first promotion time-bound 13/4/94.
13/4/94.
The second time-bound promotion of 13/4/2001.
13/4/2001.
The third time-bound promotion was 13/4/2008.
13/4/2008.
That he was due for a fourth time-bound promotion with effect from 13/4/2015.
the said promotion was not granted.
13/4/2015.
15. The
ನೀವು
said
ಏನು ವರ್ಕ್ಮನ್ ಒಂದರಲ್ಲೇ ಇದ್ದೀರಾ?
workman category 1.
Category 1 ಅಲ್ಲೇ
Category
ಇದ್ದೀರಾ?
1 ಅಲ್ಲೇ.
ರಿಟೈರ್ಡ್ ಆದ್ರೆ ಈಗ?
Then my lord,
When you have retired?
Retired on 36/2017. 36/2017.
ನಿಮಗೆ 2008 ಅಲ್ಲಿ ಕೊಟ್ರು. ಆಮೇಲೆ 7 years ಅಂದ್ರೆ 15 ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು.
2015 ಅಲ್ಲಿ ಕೊಡ್ಬೇಕಿತ್ತು.
17 ಅಲ್ಲಿ ರಿಟೈರ್ಡ್ ಆದ್ರೆ.
ಆಯ್ತು.
Yes, Mr.
2015, 13/4, that has been granted. Your lord, a writ petition came to be filed as per Annex D. A direction has been issued to grant fifth time on promotion, fourth time on promotion. Annex D may you kindly be seen, your lord.
Consider in accordance
Regulation 41.
ಏನಾಯ್ತು ಆಮೇಲೆ?
Then that the time on promotion was granted.
ಯಾವುದು?
In the fourth
ಕೊಟ್ರ
as per Annex H, your lordship may kindly.
Fourth has given.
With effect from 13/4/2015. But the monetary benefit has been extended from 1/4/2018. By the time he has already retired from service.
Where is that?
Annex H, Annex H. Page 40. So the time on promotion has been, fourth time on promotion has been granted. Melkanda Sri KT Lakshman. KT Lakshman, ಕಾರ್ಮಿಕ ದರ್ಜೆ 1. ಇವರಿಗೆ ಮಂಜೂರಾದ ದಿನಾಂಕ 13/4/2015. ಕೆಳಗಡೆ 4ನೇ ಕಾಲಮಿತಿ ಬಡ್ತಿಯನ್ನು ಮಂಜೂರು ಮಾಡಿದ ನಂತರ ನಿಗದಿಪಡಿಸಿ ಮೂಲ ವೇತನ ಕಚೇರಿ ಆದೇಶ ಪ್ರತ್ಯೇಕಗೊಳಿಸಲಾಗುವುದು ಹಾಗೂ ಸದರಿ ಆದೇಶದಿಂದ ಬರುವ ಆರ್ಥಿಕ ಸವಲತ್ತನ್ನು 1/4/18 ಪಾವತಿಸುವ ಕಾರಣ. So by the time he has already retired from service, no, he is entitled for monetary benefits with effect from 13/4/2015. That has not been granted.
ನೀವು ಕೊಟ್ಟೇನು ಉಪಯೋಗ ಆಯ್ತು ಅಲ್ಲಿಗೆ?
ಏನು ಉಪಯೋಗ ಆಗಲಿಲ್ಲ.
ಅವ್ರು ರಿಟೈರ್ಡ್ ಆಗೋಗಾಗಿದೆ ನೀವು. 2018 ಅಲ್ಲಿ he was not there in the service.
Not in the service.
Yes, that's all. That order you have challenged.
Yes, this order I have not challenged.
Then what is that you are releasing?
Monetary, the nature of mandamus directing the respondent to.
ಗೊತ್ತಿಲ್ಲ ರಿಲೀಫ್ ಏನು ಕೇಳಿದಿರ ಅಂತ. You have challenged that part.
To grant, no, filed to grant benefit of time on promotion with effect from 13/4/2015 with all consequences and benefits.
Yes.
As per the official
ಅವ್ರಿಗೆ
order.
ಕೊಟ್ಟಿದ್ದಾರೆ, ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ, ಕೊಡ್ಲಿಲ್ಲ. Subsidiary ಕೇಳಿದ್ವಿ Annex H.
No, only for you or
only for me.
ಕಾಲಮಿತಿ
So far as petition is concerned, my lord.
No, what about that other candidate?
Other candidates, my lord.
ಅವ್ರಿಗೆ 16 ರಿಂದ ಕೊಡ್ಬೇಕಲ್ಲ?
ಕೆಲವರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೆಲವರಿಗೆ ಕೊಡ್ಲಿಲ್ಲ.
ಅಲ್ರಿ, what you say about it is applicable to both.
Both.
ಅವ್ರೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ?
ಇಲ್ಲ, ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ. Annex H I have challenged.
Yes, mister. Nothing is there, mister. Yes. In this writ petition, petitioner called in question Annexure H dated 17/2/2022 only in related to the petitioner for non-granting monetary benefit from 13/4/2015. Earlier writ petition order ಎಲ್ಲಿದೆ? Next sir.
Earlier Annexure B. Annexure B, page 19, the 3 time on promotion has been granted.
Annexure D.
Annexure B, 94, 2001, 2008, 3 time on promotions.
Yes. Petitioner joined the service of corporation on 8/4/1991. In terms of the regulation obtaining in that corporation, the petitioner is entitled to a time bond promotion to overcome stagnation every 7 years. On completion of every 7 years of service, the petitioner owing to purport the regulation, petitioner was granted time bond promotion on 3 occasions on completion of every 7 years of service. When it come to that 4th time bond promotion, which was to be granted on 13/4/2015, the respondent corporation did not accede to the request of the petitioner. Therefore, petitioner has given a representation seeking for consideration of his 4th time bond promotion on completion of 28 years of service in terms of the regulation on 7/7/2015. Since his request was not considered, he has approached this court by filing a writ petition. This court, by order dated 7th December 2020, has directed the respondent corporation to consider that representation the petitioner dated 7/7/2015 pursuant to the direction. The petitioner case was considered by Annexure H on 17/2/2022 has granted a 4th time bond promotion from 13/4/2015. In the same order, it is clarified that for the monetary benefit, petitioner is entitled from 1/4/2018. Being agreed by the part of that direction, petitioner is before this court. The regulations of that corporation is very clear that the workman of the factory units has not got any promotion for more than 7 years in the existing cadre. The corporation shall be promoted to the next higher cadre if he has remained promotion to the same. He is entitled for time bond promotion. The relevant regulations is extracted below. Page 24 will extract ಮಾಡಿದ್ದಾರೆ. Accordingly, petitioner has been granted the petitioner was appointed on a workman category 1 and he was retired in the same post on 30/6/2017. As per that regulation, on 30/4/1994, 1 time bond promotion has been granted. On 30/4/2001, 2nd time bond promotion has been granted. On 30/4/2008, 3rd time bond promotion has been granted. On 13/4/2015, the petitioner is entitled for 4th time bond promotion. By impugn order, the time bond promotion has been granted to the petitioner from 13/4/2015 by order dated 17/2/2022. In the same order, in respect of monetary benefit is concerned, it has extended from 1/4/2018. This class in that impugn order is without authority of law. To that extent, impugn order annexure H has to be quashed only in respect of the petitioner. Accordingly, writ petition is allowed. The impugn order dated annexure H on 17/2/2022 only related to the part of the order in which the monetary benefit to the petitioner was been denied from 13/4/2015 is quashed. The petitioner is permitted to representation ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
The respondent is directed to consider that representation submitted by the petitioner void annexure G dated 29/9/2021, keeping in view of that order passed by this court in this petition within 8 weeks from date of first of appearance.
Cell number 29, Gaurish S. Kashampur for petitioner, M.A.
Appearing for petitioner, my lord. My lord, it is in case of promotion withheld by the district judicial department, my lord. It is a judicial department case, my lord. Here, my lord, petitioner is promoted as a FDA in 2018, my lord. Thereafter, my promotion was pending since from 2019, my lord. 2019, please, my lord.
Yes.
On the allegation that there is no specific allegation, there is no complaint, there is no video record, only orally the Honorable Principal District Judge refused us to promote me on the ground that there is a complaint in vigilance, my lord.
Yes.
As on today, I have filed an application, copy application for what is the allegation pending against me. There is no document issued by the registry, my lord.
Yes.
Till today. But they are saying orally, only orally they are saying that there is a complaint pending. Since from 2019, I am suffering from the promotion, my lord.
Yes.
Even
Yes,
in
Mr.
response, even in reply also they are stated that there is no case
After
is pending
filing of the
against.
writ petition, my lord, he has been promoted. Annexure R1 is the order of promotion.
Promotion ಕೊಟ್ಟಿದಾರಲ್ರಿ?
ಅಲ್ಲಲ್ಲ ಪ್ರಮೋಷನ್ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ 2019 ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ಅದಾದ್ಮೇಲೆ 2022ಗೆ ನನ್ನ ಅಗೇನೆಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕೊಡ್ತಾರೆ. ಐ ಆಮ್ ಸಫರ್.
No, is there any junior of you has been promoted?
Yes, my lord.
Madhya.
They are promoted.
Annexure E ನಲ್ಲಿ
ಅಲ್ಲಲ್ಲ ಅವ್ರಿಗೆ ಪಾರ್ಟಿ ಮಾಡೋದಕ್ಕೆ ಇಶ್ಯೂ ಇಸ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ ದೇರ್ ಇಸ್ ಅನ್ ಅಲಿಗೇಷನ್ ಅಗೇನೆಸ್ಟ್ ಮೀ ಅಂತ ಹೇಳಿ ನನ್ನ ಪ್ರಮೋಷನ್ ಅನ್ನ ವಿತ್ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಐ ಹ್ಯಾವ್ ನೋ ಗ್ರೀವೆನ್ಸ್ ಅಗೇನೆಸ್ಟ್ ಎನಿ ಪ್ರೈವೇಟ್ ಪರ್ಸನ್.
No, you need not make any party. You have to give him a promotion from the date.
ಅಲ್ಲಿ ನಾನು ಅಗೇನೆಸ್ಟ್ ವಿಜಿಲೆನ್ಸ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಪೆಂಡಿಂಗ್ ಇಲ್ದೇನೆ ಬೈ ಓರಲಿ ಓನ್ಲಿ ವಿಜಿಲೆನ್ಸ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ತಿಳ್ಕೊಂಡು.
Yes, wait. Yes, Mr.
My lord, annexure E, my lord, is challenged now. My lord, and in annexure E, yes, my lord, there is no charge memo issued as on the date of annexure E. That my lord,
ಚಾರ್ಜ್ ಮೆಮೊ ಇದ್ರು ಸೀಲ್ಡ್ ಕವರ್ ಇಡ್ರಿ ಕೊಡ್ರಿ ಅಂತ ಎಲ್ಲ ಹೇಳ್ತಾರೆ. ನೀವು
ಅದಕ್ಕೆ ಓವರ್ಲುಕ್ ಮಾಡ್ಯಾರೆ. Now, my lord, kindly see annexure E. The relevant page, my lord, page 24. Next page, my lord, serial number 4.
Yes.
Sunita. She has been promoted, my lord.
Serial part B ಅಲ್ಲ?
Part A.
Part A.
Part A ನಲ್ಲಿ.
Sunita FDA. She is junior to him.
She is junior to him. Now we cannot, my lord, promote two persons to a single post.
Now you have promoted him.
Yes.
No, he is not. You cannot. Now that he is already promoted, you give all consequential benefit from the date that Sunita has been promoted.
But please, my prayer is, my lord,
no, we will grant, Mr.
ಅಲ್ಲಲ್ಲ ಸ್ವಾಮಿ ಇವಾಗ ಬಂದ್ ಹೇಳ್ತಿದ್ದಾರೆ ಮೈ ಪ್ರೇಯರ್ ಈಸ್ ಅಂತ. ಸಿನ್ಸ್ ಫ್ರಮ್ 2023 ಮೈ ಲಾರ್ಡ್ ಮೈ ಪಿಟಿಷನ್ ಇಸ್ ಪೆಂಡಿಂಗ್ 21 ಮೈ ಲಾರ್ಡ್.
This is not expected from this institution, mister. Yes. Why you have denied the promotion?
On the ground that there was a complaint, there was no charge memo.
ಮತ್ ಕಂಪ್ಲೇಂಟ್ ಇದ್ರೆ ಚಾರ್ಜ್ ಮೆಮೊ ಮಾಡಿದ್ರೆ ಪ್ರಮೋಷನ್ ಎಲ್ರಿ? ಚಾರ್ಜ್ ಮೆಮೊ ಎನ್ಕ್ವೈರಿ ಕನ್ಕ್ಲೂಡ್ ಆಗದೆ ಇದ್ರು ಕೊಡ್ರಿ ಪ್ರಮೋಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ನೀವು ಇವನ್ ಇಟ್ಕೊಂಡ್ ಬಿಟ್ಟು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯು ಆರ್ ನಾಟ್ ಗಿವಿಂಗ್ ಇನ್ ದ ಪ್ರಮೋಷನ್.
Now subsequently has been.
But you give it from that retrospective effect with all consequences.
Let him make a representation, my lord, let it be considered by the first respondent.
Yes, you given a representation.
Next year,
ಈಗ ನಾನು representation ಕೊಟ್ರೆ ಮಾತ್ರ representation it will take time, my lord. Kindly issue a positive direction.
Now, what is your relief in that writ petition, mister?
Please, my lord, kindly see prayer number 2, my lord. Even if I have sought for the quashing of annexure E, my lord. In prayer.
What is annexure,
my lord?
What is that annexure?
Annexure is the promotion list, my lord. As on the date of 2020, I am eligible for promotion, my lord. But my name is not considered.
That's what I referred, my lord.
Annexure?
24.
Annexure E.
Yes,
Then if you want to quash this, you have to make all these persons as in a party, mister.
Not only one person.
ಅದಕ್ಕೆ I am restricting my prayer to the second prayer, my lord.
What is that second
kindly
prayer?
See a writ in the nature of madam must issue and direction and kindly issue and direction to the respondent number 1 to give a promotion to the writ petitioner for the cadre of the Shirastedar with effect from the 1/7/2022 by conducting.
That's what we are saying that. For that you given a representation, let him consider and pass an order. That's what we are saying that.
Please, my lord, positive direction may be issued, my lord. Only consider
if you are wrongly rejected, you come before this court, then we will see. Yes.
Otherwise ಏನಾಗುತ್ತೆ again 2021 ಇಂದ he is suffering, my lord. Now we are in 2026.
Yes.
That's only my request.
Yes.
With all consequential benefits, my lord.
If he will not press annexure prior A, he is restricted his petition only to prior B. The prior B extract ಮಾಡಿ.
I am not pressing, my lord, but he is entitled for promotion as on the date of 1/7/2020 ಅಂತ ಅದೊಂದು observation ಬರಲಿ.
Counsel, you are a lawyer appearing for the party. You argue correctly. If you are pressing, you argue. I will consider that.
Please, my lord. Yes. My only submission, my lord, he is entitled for promotion as on the date of 1/7/2020. That may be observed. That is only my submission.
Yes. That is your case. We will observe that. Let him consider. If they say you are not entitled, then we will examine.
Please,
yes.
My lord. Please.
He is seeking prior B. So and so prior. The case of the petitioner that. Petitioner was appointed as a typist in the year 1998. Thereafter, he has been promoted as a FDA in 2015, and he is working in respondent institution from 1998. Petitioner case has not been considered for the promotion to the post of processor.
Shirastedar.
Therefore, petitioner has submitted a representation. Representation ಏನಾರು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಇದು series of representation. It starts from annexure H, my lord. ಅದನ್ನ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ one more representation is not necessary, my lord.
Yes, has not submitted a representation without considering the case of the petitioner. The person who has junior to the petitioner has also been promoted by order dated by wide annexure E to the post of Sirasdar. One of the candidates is Srimati Sunita, who is junior to the petitioner. After therefore, petitioner is before this court. Learned counsel.
My representation is in annexure page number 43, my lord.
ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ. Yes.
ಅವ್ರ representation ಆದ್ಮೇಲೆ.
Yes, yes. Therefore, petitioner, learned counsel appearing for the petitioner submitted that during the pendency of this petition, while order dated 2/11/2021, the promotion has been accorded to the petitioner from the date of order dated, from the date the annexure R1 is issued. He contended that without any authority of law, the petitioner has been denied the promotion from the date his junior has been promoted, that is on 1/7/2022. Therefore, petitioner is entitled for all monetary benefit, all benefit from the date his junior has been promoted, that is from
Along with seniority, my lord.
ಎಲ್ಲ ಬರುತ್ತೆ.
Consequential ಅಂದ್ರೆ
Consequential benefit. Yes. All consequential benefit from so and so. Learned counsel appearing for the respondent has submitted that petitioner representation has been considered and petitioner has been promoted on 2/11/2021. Heard the learned counsel for the parties peruse read papers. It is not in dispute. Petitioner was appointed as a typist in the year 1998 in respondent institution. Later, he was promoted as an FDA in the year 2015. And it is also not in dispute that there is no any inquiry is pending against the petitioner. There is no any departmental inquiry against the petitioner. Even though petitioner is entitled to promoted as a Sirasdar, without considering the case of the petitioner, by the annexure E dated 1/7/2020, the candidate who are junior to the petitioner, that is one Srimati Sunita FDA, has been promoted as a Sirasdar. The petitioner is also entitled, even though he is entitled from the date his junior has been promoted, even though petitioner has been promoted by annexure R1 on 2/11/2021, the petitioner is entitled for all monetary and consequential benefit from the date his junior has been promoted. Therefore, petitioner is at reserving liberty to submit one more representation to that respondent.
First respondent.
If such a representation is submitted, the first respondent is directed to consider the same in accordance with law, keeping in view of observation made in this order within 6 weeks from date of receipt of that representation. Yes.
Grateful, my lord. Grateful.
Yes.
Cell number 30, Vijay Kumar for petitioner. Connected matter, Pradeep S. Saukar.
Yes.
I appear for the respondents.
Yes. Yes, Mr.
Matter relates to promotion to the post of technical officer grade 1, 2 and 3, my lord.
Yes.
Petitioner was working in the Indian Institute of Science.
Yes.
Lord, before going to the merits of the case, my lord, your lordship may kindly see 3 documents, my lord, which I am relying on.
Yes.
Lord,
Page number 20.
Lord,
my lord, I may permit, your lordship may kindly take the writ petition 114 of 22, my lord.
may I make one more submission, my lord? Subject to, my lord, my learned friend's convenience, my lord, to effectively assist your lordship, my lord, may I request time till next week, my lord. A date next week and I will argue. I'm not asking for more.
2021-22.
One thing he is requesting to give effective assistance, that what's I required also.
Please.
Therefore, if that is the case, we will grant it. Normally,
1 week.
we will not seek. Yes.
Normally, I argue all the cases.
Yes,
my lord.
yes. That's what-
This case.
Yes, we will grant 1 week time. 9th.
Please, great.
Bill number 31, Subramania Bhattam for petitioner, R. Padmanabha.
On submission millets, I filed an application for impeding millets. I am also working as a teacher.
Yes.
We both, petitioner and myself, were appointed on the same day. And I was also deputed to the other schools. Lord, in this case, the vacancy arises in this parental school millets. This is a R8 institution, R6 and 7 institution. My case also be considered because I am senior to
31.
31.
Yes, ready, both of them will
Lord,
hear.
in this case, Lord, in view of the stand taken by Mr. Narayan Swami, Lord, now I see some ray of hope, my Lord, in my case.
Yes.
Because, Lord, what happened was, Lord, I was initially appointed, my Lord, as an assistant teacher, Lord, in the National High School, my Lord, Chilur Honnali. That was in the year 2007. My Lord, then I was transferred to another school. My Lord, the date of initial appointment is 15/10/2007.
Yes.
My Lord, as a Kannada assistant teacher.
Yes.
Then, my Lord, I was transferred to another school, my Lord, that is Sharada Devi Girls High School. My Lord, on 8/7/2000. Adu by the same management.
No, in the same Honnalli only.
How?
Yes.
My Lord, that was on 8/7/2011.
Yes.
My Lord, then what happened was, my Lord, on account of depletion of student strength.
Yes.
My Lord, this Sharada school was required to be closed down.
Yes.
So, my Lord, then what this sixth respondent did was, my Lord, it transferred me, my Lord, to another school
Yes.
on 28/4/2018.
Yes.
My Lord, that is to the third school, that is Tirthalingeshwara High School.
Yes.
My Lord, in the meanwhile,
Yes.
my Lord, this particular post to which I was transferred, that is in Tirthalingeshwara School, my Lord, that was sought to be filled up by direct recruitment.
Yes.
And my Lord, respondent number 8 applied for the said post. But by that time, my Lord, by the selection process was over, I was already redeployed and readjusted to that particular post.
In that
Tirthalingeshwara. Lord, then the management, Lord, took a decision to cancel the appointment of eighth respondent, so as to accommodate me, my Lord, in that school.
Yes.
Lord, then this eighth respondent filed a writ petition before this honorable court,
Yes.
challenging the decision of the sixth respondent as well as by the government.
Yes.
Lord, the government refused to grant approval to the appointment of eighth respondent on account of the fact that, Lord, I was readjusted to that post.
Yes.
The writ petition filed by the eighth respondent, Lord, came to be allowed. No doubt, Lord, I was a party to that writ petition.
Yes.
Writ petition came to be allowed, and, my Lord, the decision taken by the state government was set at naught with a direction to consider, my Lord, the case of the eighth respondent for grant of approval. So then, my Lord, again, I was transferred, my Lord, to the fourth school, that is, my Lord, Jade Shankara Swami High School.
Yes.
That is on 19/4/2021.
Yes.
But unfortunately, my Lord, counseling was held behind my back.
Yes.
Lord, I was not present during the course of the counseling.
Yes.
Lord, then I did not report for duty to the fourth school.
Yes.
And eventually, my Lord, I filed a writ petition challenging the very process of considering me as excess teacher.
Yes.
This honorable court granted me an interim order of status quo. But ultimately, my Lord, the writ petition was withdrawn with liberty to approach the government. Accordingly, I approached the government by filing an appeal under section 130 of the Education Act, my Lord, and that appeal came to be rejected by the government,
Yes.
my Lord, which is the subject matter of this writ petition.
Yes.
Now, my Lord, during the pendency of this writ petition, my Lord, one post, my Lord, has fallen vacant in Padmamba High School, my Lord, which is run by the sixth respondent.
Yes.
My Lord, the person who was holding that post, my Lord, has been promoted as a lecturer.
Yes.
So on account of that, my Lord, one post has fallen vacant.
Yes.
Now, my Lord, Mr. Narayan Swami's client, my Lord, she claims that she is senior to me.
Yes.
Senior to the petitioner. So if at all somebody is required to be posted to Padmamba High School, it is not the petitioner. His client should be posted. Lord, fine, I cannot have any quarrel because, my Lord, I am junior to his client.
Yes.
Now, Lord, hitherto, my Lord, Narayan Swami's client was working in Basaveshwara High School.
Yes.
As an assistant teacher. From where, my Lord, she will be now transferred to Padmamba School.
Why?
That is, my Lord, she was also treated as excess. Now, my Lord, one post is found vacant in the institution run by the sixth respondent.
Yes.
So naturally, my Lord, then if vacancy is there, then the senior most will have to be brought to the Padmamba school. My lord, I cannot have any quarrel.
Yes.
Now, my lord, my only limited prayer is, now if Narayan Swami's client is not brought back to Padmamba High School, one vacancy, my lord, will arise in Basaveshwara High School, which was, my lord, hitherto, which was being held by Narayan Swami's client.
No, but who was there in that Basaveshwara school earlier?
That is, my lord, the impleading applicant.
It was on deputation.
She was also on deputation.
Deputation.
How? She was also similarly circumstanced like me. My lord, the moment she is transferred to this Padmamba
Why
High
he has been transferred from Basaveshwara school? That's what I am asking.
Now, my lord, he is claiming that he is senior most and senior to the petitioner.
Therefore, he has to give an option.
He has to be given an opportunity.
Yes. Now that the place where he has been transferred,
yes,
their vacancy is there.
Exactly, my lord.
Then you can adjust that. Petitioner can be adjusted to that Basaveshwara. That sixth respondent to Padma. Yes.
Last year, you know, the Salmon Court directed me to assess it. Whether any posts are vacant or not. This is the document saying that, my lord, there is a one post vacant in Jagadguru Jadeshankara Praudashale. My lord, on the second submission, my lord, she is unauthorized absent more than 9 months, my lord.
That he will give up the right. That's what he
9
said.
years, my lord. I'm sorry, my lord. 9 years, my lord. Even though my lord, we conducted counseling, my lord, she is not participated in the counseling.
Lord, from 2021, my lord, no doubt I concede that, my lord, I am out of employment.
2021.
21 because
you said that 9 years.
Illa 9 years in Barala.
5 years, my lord. 5 years, my lord. 24/4/2021 in the.
2021 in the Andhra, she is litigating here.
How?
Yes,
No.
2012 ರೇಟ್ ಹಾಕಿದ್ದಾರೆ.
22
ಮಾರ್ಚ್ ಅಲ್ಲಿ ರೇಟ್ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ ಹಾಕಿರೋದು 2000 ಈ ಜಾಗಕ್ಕೆ ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ ಈ ಜಾಗ.
ಎಲ್ಲಿ ಹೋಗಿಲ್ಲ? Jadeshankar, we have not
because, my lord, this counseling was held behind my back. I was on medical leave, my lord, so therefore I could not attend the counseling.
She has not go and join that after that also, Jade Maheshwara. What is the wrong in that?
Lord, all that I can say is that, Lord, there is, Lord, as a matter of fact,
not claim any benefit. Let her go and report to that Jade Maheshwara, Mr.
Please, my lord.
Without claiming any monetary benefit.
Please.
From the next date, we will fix on that day, go and report to that Jade Maheshwara, there is a vacancy.
Vacancy.
To go and report there. From that date, his service will count.
My lord, earlier could have posting could, my lord, in statement of objection, I received the paragraph reimbursement, I have not filed. But my lord, my contention is, my lord, the admission in the school of where petitioner was working was decreasing continuously. The petitioner was twice informed well in advance to attend the counseling for redeployment. In spite of that, petitioner chose to remain absent from attending the counseling. As such, the petitioner was redeployed to an aided high school, that is Jayadeva Sankara Swami High School, Hirekalmutta, Honnali Taluku, which is in the same district by an order dated 19/4/2021. The petitioner refused the said order by her endorsement dated 22/4/2021.
Now that Jade Maheshwara, that there is a vacancy.
All vacant.
Their petitioner can go and report.
Please.
For without any burden to the state government for seeking any monetary benefit.
Please.
That can be done, Mr. Yes.
ಅದು ಆಗ್ಬೋದು ಬಸವೇಶ್ವರ ಯಾವ್ದಾರ ಒಂದು ಸ್ಕೂಲಲ್ಲಿ ಕೊಡ್ಬೋದು.
No, Jade Maheshwara.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್. Yes, sir.
Jade Maheshwara government has passed an order. You go and report. Not to claim any.
ಅಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ ಏನ್ ಪೊಸಿಷನ್ ಪ್ರೆಸೆಂಟ್ ಪೊಸಿಷನ್ ಏನು.
ಅಲ್ಲ, I am submitting the document. I am on instruction only, I am submitting.
Yes. This writ petition. What is that annexure V you are seeking?
Lord, annexure V, my lord, is the order passed by the authorities by which, my lord, I was treated as an excess teacher and I was transferred, my lord.
Transferred to where?
Transfer Jadeshankara. Please have a look at page 80.
Yes. Now that that order will be upheld, you will be directed to report within that so and so date. From that date, you are entitled for all monetary benefit. Challenge. Oh, now what is your role now? Now he is not coming to his place.
I have no claim. Now my grievance is solved.
No, see, he has not been directed to report to that Padmanabheshwara school. That is for you to work out there. Now only in respect of the petitioner.
Petitioner consent. Correct.
Anyhow, I have to come and record me. That's why
No, your presence is not necessary now.
I am not claiming anything.
That's what that.
I am not claiming any relief.
Yes. Now almost his case is dismissing. permitted to report not to claim any benefit. That is what that relief now we are seeking. Yes. Challenging that order dated 19/4/2021, whereby petitioner has been treated as an excess teacher and directed to transfer to the Jada Shankareshwara Prodashale.
Jade Shankara Swami Prodashale.
Jada Shankara Swami Prodashale, Ire Kalmat Mannali, which is also institution run by sixth respondent. Petitioner was appointed.
There is one more annexure which is under challenge. That is the order passed by the state government. Lord, which is at annexure AF page 105.
Being agreed by that.
By which my appeal has been rejected.
Yes. And also order passed by the state government.
Page 105.
Annexure AF, whereby his appeal has been dismissed, filed under section 130 of Education Act, confirming that order dated 19/4/2021. The petitioner was appointed as a assistant teacher grade 2 high school in Kannada language in 2007, posted to National High School, Chellur, Honnali Taluk. Thereafter, petitioner was transferred to Siddhalingeshwar Nayanadar. Second transfer,
Sharada Devi Girls High School.
Sharada Devi Girls High School, Shimoga, in the year 2011, on the basis that she was treated as an excess teacher.
Illa, alli excess anta agilla. She was simply transferred.
Yes, she was transferred to Sharada Devi High School, Shimoga, which is run by sixth respondent education institution. Thereafter, petitioner has been transferred to
Tirthalingeshwara High School.
Excess
Haudu.
Has been transferred to Tirthalingeshwara
High School, Belagutti, Davanagere.
Belagutti, Davanagere. That is also run by sixth respondent.
Haudu.
As run by sixth respondent. On the basis of that, petitioner was treated as an excess teacher. Thereafter, petitioner was again treated as an excess teacher in view of the reduction of the student strength in that Tirthalingeshwara institution. Petitioner has been treated as an excess teacher and he has been called for an counseling by impugn order annexure V. Petitioner has been transferred to that Jadesh Shankara Swami Prodashale, which is also run by sixth respondent.
Illa, idu sixth respondent.
Alva, bere. Yes, yes. Jadalangeshwara Prodashale. Being agreed by the same, petitioner also filed an appeal before that authority under section 130 of Education Act. The same is also dismissed by order dated 7/2/2022, annexure AF. Being agreed by these two order, the petitioner is before this court. The only ground urged by the petitioner that while conducting a council for transferring the excess teacher, no notice has been given to the petitioner. Therefore, petitioner was not appeared on the day when the counseling was held. Learned government advocate has submitted that notice has been issued to the petitioner. Since petitioner has not attended the counseling, he contended that even today that post in Jadashankara Swami Prodashale is vacant. In view of the above, in the interest of justice, this court has the opinion that petitioner is directed to be reported in Jadashankeshwara Swami Prodashale within how many days she will report?
Within 1 week.
Within 1 week from today. then it is made clear that petitioner is not entitled for any monetary benefit from which date, Mr.
Lord, that is from, I worked last, my lord. That is, my lord, from June 2021.
From June?
June 2021.
June 2021 to till she reported.
ಇಲ್ಲ ಜೂನ್ ವರೆಗೆ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
June ವರೆಗೆ
ಹೌದು ಮಾಡಿದ್ದಾರೆ. I have produced attendance register.
Where you have worked for June? When
Lord,
that
that is,
transfer order has been passed? No, she has been transferred in 19/4/2021.
ಹೌದು
That date.
ಆಮೇಲೆ 2 ತಿಂಗಳು ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ.
No, after transfer you cannot work there.
No,
where you are work?
My lord, in the very same school, that is Tirthalingeshwara High School. My lord, I
No,
was.
after that you cannot work. Even if it is work also, you cannot be paid because government has from 19/4/2021 till she is reporting in that Jadashankareshwara Swami Prodashale. With that observation, the above petition is disposed of. That is for you to do it. We will not say anything. All this has been kept open. Yes.
Lord, may I make one submission?
Yes.
This interregnum period, my lord, that may be counted for the purpose of terminal benefits, my lord, only that. Because pension ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಈ 4 ವರ್ಷ.
Except the salary and seniority. For all other benefit, this period can be considered.
Grateful.
Yes.
Cell number 32 adjourn. Cell number 33.
No, that's
32, my lord.
which is also subject to if there is any inquiry is conducted, Mr. Yes. This is also subject to any departmental inquiry, if any initiated by that department. Yes.
ಇನ್ನೇನು ಮಾಡಿಲ್ಲ.
ಅವ್ರು ಏನಾರ ಮಾಡಿದ್ರೆ tomorrow they can't impose this penalty because High Court has directed. Yes.
Cell number 32 adjourn. Cell number 33 Gurraj R for petitioner, government advocate. 33 Gurraj R.
I am for the petitioner, my lord.
Yes.
This is the case of bringing petitioners into Karnataka Welfare Act, Daily Wages Welfare Act. Actually, I had to get some more records from Mandya, so a week accommodation may kindly.
The request of counsel for the petitioner is this matter of 2 weeks.
2 weeks.
Yes.
A date may be fixed. Date may be fixed.
Date is 25th. Yes. March.
25th.
March.
Cell number
4 weeks.
34.
Date illa. Yes.
Bonsle for petitioner, MS Devraj.
Yes, Mr.
Seeking appropriate ranking in the final seniority list of the.
Yes.
Devraj sir is there. They are A Nagarajappa sir.
A Nagarajappa, my lord. A Nagarajappa.
Next.
What is this relief you have sought, Mr.?
He is appointed as clerk cum typist, my lord. The government has passed the orders in the year 2014, my lord. Those who are appointed as a clerk cum data entry operator, their seniority should be commenced from the date of government order, my lord. That is 10/14.
Early the government order.
The government order clarification ಕೊಟ್ಟಿದ್ದಾರೆ. Annexure D kindly be seen. Annexure D, page number 16. Page number 16, Annexure D, my lord. ಸರ್ಕಾರ ಸ್ಪಷ್ಟೀಕರಣ, they clarified, my lord. Government has clarified. ಸರ್ಕಾರದ ಆದೇಶಕ may I read, my lord?
Yes.
ಸರ್ಕಾರದ ಆದೇಶಕ್ಕೆ ಗ್ರಾಪಕ ಸೋನ್ಸೋ ದಿನಾಂಕ 10/9/2014 ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮ 93ರ ಪ್ರಕರಣ 112 ಅಡಿಯಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸಿಬ್ಬಂದಿ ವರ್ಗದ ಮಾದರಿ ಮತ್ತು ನೇಮಕಾತಿ ವಿಧಾನದಲ್ಲಿ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟ್ ಹುದ್ದೆ ಸೃಜನೆಯಾಗಿರುವುದಿಲ್ಲ. ಪ್ರಸ್ತುತ ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳ ಸಾಮಾನ್ಯ ಸಭೆಯ ನಿರ್ಣಯದ ಮೂಲಕ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟ್ ಹುದ್ದೆಯು ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವ ಪ್ರಕರಣಗಳು ಅಸಿಂಧುವಾಗಿರುತ್ತದೆ. ಈ ರೀತಿ ನೇಮಕೊಂಡಿರುವವರ ಹಿಂದಿನ ಸೇವಾ ಅವಧಿಯನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಸಿಬ್ಬಂದಿ ಸೇವಾ ಅವಧಿಯ ಜ್ಯೇಷ್ಠತೆಗೆ ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಲಾಗಿದೆ. ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ 16 ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ಗಳು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ನೌಕರರೆಂದು ದಿನಾಂಕ 10/9/2014 they has to be treated from their appointment, even though they appointed prior to the 10/9/2014, their appointment should be continued from the 10/9/22, my lord.
ಓದಿ ಅದನ್ನ ಅಲ್ಲಿಗೆ ನೀವು
ನಂತರ ಸಕ್ರಮಗೊಂಡಿರುವ ಅವರ ಜ್ಯೇಷ್ಠತೆಯು ದಿನಾಂಕ ಮತ್ತು ನಂತರ ದಿನಾಂಕದಿಂದ ಪರಿಗಣಿಸಲಾಗುವುದು. ಆದರೆ ಜ್ಯೇಷ್ಠತೆಯ ಪಟ್ಟಿಯೊಳಗೆ ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ನೌಕರರು ಅಂತರ್ಜ್ಯೇಷ್ಠತೆಗೆ ನಿಗದಿಪಡಿಸಿರುವ ಉದ್ದೇಶಕ್ಕೆ ಮಾತ್ರ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಈ ಹಿಂದೆ ನೇಮಕವಾದ ನೇಮಕವನ್ನು ಪರಿಗಣಿಸುವ. Even my lord, that's my lord, I have given the after publishing on the provisions in list, my lord, I have given detailed objection as per annex here.
Yes, who
Annex
is
A5.
appearing? Chief Executive Officer. Yes, Mr. Devaraj, what is this government order? Another clarification.
ಯಾರು ಎಲ್ಲ ಕೊಡಗಲ್ಲ ತುಮಕೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ತುಮಕೂರು ಡಿಸ್ಟಿಕ್. ಯಾರ ಹೆಸರು ಇದೆ ಇದರಲ್ಲಿ? This is from which? ತುಮಕೂರು.
ತುಮಕೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ನಾಗರಾಜ. ಅದೊಂದು ಲಿಸ್ಟ್ ಕೊಡ್ರಿ, ನೀವ್ ಯಾರ್ಯಾರಕ್ಕೆ ಇದ್ದೀರಾ, ನೀವ್ ಯಾವ್ದಕ್ಕೆ ಇದ್ದೀರಾ ಅಂತ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ. You give that list, I can direct when that matter has come. You are appearing for which? And Nagaraja files. Yes, I think you both only appearing most of.
Others, yes.
Yes, what is this, Mr. Nagaraja Padas?
I will get instruction. ನನ್ನ ಹತ್ರ ಕಾಪಿ ಇಲ್ಲ ಅದಕ್ಕೆ.
Copy ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರಾ? Yes, let him get
Yes,
instruction.
I will announce a copy.
The request of respondent.
After 10th of
Is this matter on 16th?
16th.
Bill number 35, Shailendra MR for petitioner, Mohammad Ayub Ali.
Yes. Yes, Mr. Sir.
Number 2 and 3.
Yes, Mr.
This matter relates to seniority of staff nurses working in BMCRA and PMSSY. ಅವ್ರದ್ದು ಸಪರೇಟ್ ಸೀನಿಯರಿಟಿ ಲಿಸ್ಟ್ ಇತ್ತು, ಈಗ ಕಂಬೈನ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. Now during the pendency, my lords, they had framed C&R rules, my lords, and has been sent to government for approval. Last occasion I had told this honorable court
where is that?
That it is being finalized anta, on that note it was urgent, because without C&R, if the C&R rules is finalized,
And then you
virtually this can be over anta heli.
Yes, where is that C&R? C&R is framed, Mr.
The CNR is yet to be finalized and implemented, your lord.
ಎಲ್ಲಿದೆ C&R?
ಅಲ್ಲ ಗವರ್ನಮೆಂಟ್
ಫೈನಲೈಸ್ ಆಗಿಲ್ಲ, ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗ್ಬೇಕು. ಗವರ್ಮೆಂಟ್ ಕಡೆಯಿಂದ ನಮಗೆ ಅಪ್ಡೇಷನ್ ಫೈನಲೈಸೇಷನ್ ಬರ್ಬೇಕು.
ಏನಾಗಿದೆ ರೀ? ಆ ಡೀಟೇಲ್ಸ್ ಕೊಡ್ರಿ, ಅದು ಯಾವ್ದು ಅಂತ ಅವರಿಗೆ.
C&R rules, till then there is no C&R rules.
Yes.
Here my learned friend is seeking that based on the High Court order, 2 High Court orders based on the director, ಅವ್ರದ್ದು ಏನಂದ್ರೆ director and dean cannot give the seniority list ಅಂತ ಅಷ್ಟೇ. C&R rules ಗೆ ಸಂಬಂಧ ಇಲ್ಲ. So far they don't have any rules. They have sent it, it is before the secretary. Since many months it is lying there. ಇನ್ನ ಬಹಳ ವರ್ಷ ಆಗುತ್ತೆ, ಅದು ಮಾಡಲ್ಲ. It takes long time. ಈಗ ನಮ್ಮ
Now how their promotion has been appointed?
ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ, ಪ್ರಮೋಷನ್ ಇಲ್ಲ.
ಪ್ರಮೋಷನ್ ನಮ್ದು 2012, ಅವ್ರದ್ದು 2015 and 17. ಅವ್ರು ಹೇಳೋದೇನಂದ್ರೆ there are many units. ಈ ಯೂನಿಟ್
ಅವ್ರ ಸೀನಿಯರ್ ಸಪರೇಟ್
ಡೀನ್ ಅಪಾಯಿಂಟ್ ಆಗಿತ್ತು. ನಮ್ಮ ಯೂನಿಟ್ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಅಂಡ್ ಡೀನ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು. ಅವ್ರು ಹೇಳೋದು ನಮ್ಮ ಇದು ಡೀನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ.
ಏನ್ ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ?
ಸೀನಿಯಾರಿಟಿ
ನೀವು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಏನ್ ಹೇಳ್ತೀರಾ? ಅವ್ರು ಏನಕ್ಕೆ ಸೀನಿಯರ್?
ದಿಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್, ಆನರಬಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್, ಬೇಸ್ಡ್ ಆನ್ ದಿ ಡೈರೆಕ್ಟರ್ಸ್ ಆರ್ಡರ್, ಅಂಡ್ ನಾವು ವಿ ಆರ್ ಆಲ್ ದಿ ಸೀನಿಯರ್ಸ್. ಅಷ್ಟೇ.
No, what is
ಹಾಸ್ಪಿಟಲ್ ಸಪರೇಟ್, ಅದರಿಂದ ಸಪರೇಟ್ ಇಡಬೇಕು ಅಂತ. ಐದರ್ ವೇ ಸೀನಿಯರ್.
What is your case, Mr.? There should be a separate seniority list for each hospital.
No, for PMSSY ಮಾತ್ರ.
ನೀವೇ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದೀರಾ?
ಯಾಕೆಂದ್ರೆ it is a super specialty hospital and they have avenues there also. But unless C&R rules is there, there will be no promotion. There is no interim order also in the writ petition. It can be heard.
Yes,
your lordship, one submission. The PMSSY and BMCRA are one single institution. They are not separate institution.
That is what is their stand.
ಆಯ್ತು, ಈಗ C&R ಡ್ರಾಫ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದೀರಾ? ಎಲ್ಲ ಕಾಮನ್ ಮಾಡಿದೀರಾ? ಏನ್ ಮಾಡಿದೀರಾ?
ಹಾ ಎಲ್ಲ ಕಾಮನ್ ಆಗಿದೆ ಅದು. ಇನ್ನೊಂದು
ಕಾಮನ್ ಆಗಿ ಆದ್ರೆ ಉಳಿಯೋದೇ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ.
they cannot ask for a separate seniority list based on PMSSY.
ಆಯ್ತ್ರಿ, ಈಗ ನಿಮ್ C&R ಅಲ್ಲಿ ಕಾಮನ್ ಮಾಡಿದ್ರೆ if they are agreed they have to challenge.
Let them challenge.
ಎಲ್ಲ C&R ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ರೀ? ನೀವೇನ್ ಮಾಡ್ತೀರಿ? C&R ಮಾಡೋದಿಲ್ಲ, ಸುಮ್ನೆ ಅವ್ರವ್ರಿಗೆ ಜಗಳ ಬಿಟ್ಬಿಟ್ಟು. ವಿತೌಟ್ C&R ಹೆಂಗ್ರಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ರನ್ ಆಗೋದು? ಅವ್ರಿಗೆ ಪ್ರಮೋಷನ್ ಇರಲ್ಲ. There was no interest in that.
ಮೆಡಿಕಲ್ ಎಜುಕೇಶನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆದಾಗಿಂದ ಇನ್ನೂ C&R ಇವಾಗ ಫೈನಲೈಸ್ ಮಾಡಿದ್ದಾರೆ, ಮಾಡಿ ಕಳಿಸಿದ್ದಾರೆ ಆಫ್ಟರ್ ಮೆನಿ ಇಯರ್ಸ್.
ಇನ್ನ ಆಗಿಲ್ಲ
ಸೆಕ್ರೆಟರಿ ಅಪ್ರೂವ್ ಮಾಡ್ಬೇಕು, ಗವರ್ಮೆಂಟ್ ಅಪ್ರೂವ್ ಮಾಡ್ಬೇಕು.
ಅದೇ ಎಲ್ಲಿದೆ ಸೆಕ್ರೆಟರಿ ಮುಂದೆ? ವಾಟ್ ಇಸ್ ದ ಸ್ಟೇಜ್ ಮಿಸ್ಟರ್? I will ascertain. Yes, at the request of government advocate. Is this matter of 2 weeks? You go and give a representation if they are not. ಅದಕ್ಕೆ ಒಂದು ರಿಟ್ ಹಾಕಿ ಅವಾಗ. Yes, yes.
This fiction does not come in the way of the Idantam observation.
You give a representation if they are not given.
I have filed in my reply also.
ನೀವು separate ರಿಟ್ ಹಾಕಿ ಅವಾಗ ನಾವು ಡೈರೆಕ್ಟ್ ಮಾಡಿ. Yes.
ಅದೇ ಇದೆ, ನೆಕ್ಸ್ಟ್ ಬರ್ತಾ ಇದ್ದೇವೆ. ನಿನ್ನೆ ಬಂತು, ಇದಾಗಿ ಇಲ್ಲ ಅದು.
Yes.
ಡೇಟ್ ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
I appear for the petitioner.
ಅವ್ರಿಗೆ ಏನು ಅರ್ಜೆಂಟ್ ಇಲ್ಲ ಬಿಡಿ, ಯಾಕೆ ನಿಮಗೆ 2 weeks? Yes.
ಅಲ್ಲಲ್ಲ, ಬಿಕಾಸ್ ಮೈ ಪ್ರಮೋಷನ್ is because of this is ಹೇಳೋದು.
ಆಯ್ತು, ನಿಮ್ ಕೇಸ್ ಬಂದಾಗ ನೋಡೋಣ, ಅದ್ರಲ್ಲಿ ಹೇಳೋಣ. Yes. Yes.
ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ.
Yes, leave this matter on 25th. Yes.
26.
My lord, I appear for the petitioner. My lord, I have filed the application for early hearing. Short date may be fixed, my lord.
Rule issue ಆಗಿದೆಯಾ? Rule is not issued.
Then my lord, a short date may be fixed, my lord.
Yes. IA is ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆಯಾ? Yes, leave this matter
2 weeks. Respond
on 24th. Yes.
37 DP Siddaramaya for petitioner.
Appearance for respondent members. Lords, I am filing a statement of objections.
Yes, Mr. Siddaramaya. You want to go through that?
Yeah, right now ಇದು ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ರು ನೋಡ್ಕೊಂಡು.
File it in the counter, Mr. Yes. At the request of respondent. Leave this matter next week, 21. Yes.
Date may kindly fix, ma'am.
Yes, on 23rd.
38 Srinivasa K for petitioner. Venkatesh C. TS.
The respondent number 2, Your Honor.
Yes.
Your Honor, liberty may be granted for me to file my statement of objections. I've served the copy.
Let them file, my lord. This is a matter pertaining to recovery, my lord, from out of the terminal benefits.
No, you are ready.
I am ready, my lord. The copy, my lord, has been just now received. They have filed several documents. I will go through it, my lord.
Yes. At the request
Liberty may be granted for me to file the filing counter, Your Honor.
Counter liberty need not be. You can file it, madam.
Yes.
At the request of respondent, leave this matter.
Short date.
16th.
Please.
Grateful, Your Honor.
39 Ajitesh Shetty for petitioner.
My lord, petitioner.
Yes, Mr. Shetty.
My lord, the only prayer that I have made, my lord, is to consider my representations. My lord, the petitioner, my lord, he was appointed as a temporary lecturer. My lord, from
Yes.
the 8th of September 2009, he was appointed as a Sanskrit lecturer.
Yes.
With the respondent institutions, my lord, they are all, my lord, aided institutions.
Yes.
And my lord, the position which he is seeking, my lord's regularization is also a sanctioned position.
Yes.
So all that I'm requesting, my lords, is that the authorities should consider my representation and my lords pass necessary orders in accordance with law.
Your representation for what?
My lords, I have sought for regularization of my employment. My lords, I was appointed on a temporary basis.
Where you are working?
My lords, with the respondent institution, my lords, if my lord should see the cost item.
Yes, who is appearing for that institution?
What up, sir?
My lords, it was Mr.
Where is your
Karthik.
representation? Where is representation?
My lords, all annexures E, J, O, my lords, multiple representations. If my lord should see, my lords,
Yes.
page 20 onwards. Page 20 and 21, my lords.
Yes.
And then, my lords, page 27.
Why?
On this ground, my lord, they have not taken permission from the department. And they have not followed any laws. Therefore, it is not taken.
Now that they are given to management. Let the management be decide. Why do you want to worry about that? They are not seeking. ಏನ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವರು? ಅರಕಾಲಿಕವಾಗಿ PhD ವ್ಯಾಸಂಗ ಮಾಡಿ ನಮ್ಮ ಅಭ್ಯಂತರವಿಲ್ಲ, ನಿರೀಕ್ಷಣಾ ಪತ್ರ ನೀಡಿ ಸಂಶೋಧನೆ. Annexure E ನಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ. Annexure J ತಾವು page 20 ತಾವು ನೋಡಿದ್ರಿ ಸ್ವಾಮಿ.
ಇದು ಯಾವುದೇ ಮೀಸಲಾತಿಯನ್ನು ಹೊಂದದೆ ಇರುವುದರಿಂದ ಕಾಯಂ ಆಗಲು ಹೆಚ್ಚಿನ ಅವಕಾಶವಿರುತ್ತದೆ.
ಸುಮಾರು ವರ್ಷಗಳಿಂದ ಕೆಲಸ
ಕಾಯಮೂರ್ತಿಗೆ ಪರಿಗಣಿಸಿ ಹೆಚ್ಚಿನ ಸೇವೆ ಸಲ್ಲಿಸಲು ಅವಕಾಶ ಮಾಡಬೇಕಾಗಿ ತಮ್ಮಲ್ಲಿ ಕೋರುತ್ತೇವೆ.
ಪ್ಲೀಸ್.
Yes, ಕಾರ್ಯದರ್ಶಿ. You are giving only secretary.
Yes, Manoj. To the institution, Manoj, I'm told they have forwarded my representations to the department as well.
For what?
Manoj, to confirm my appointment, Manoj, and to convert my employment into a regular employment rather than a contract.
Where is that recommendation?
Adu, Manoj, I've been informed orally, Manoj. I have no information of that.
Petitioner sought following direction, start following prayer. The case of the petitioner that he was appointed by the respondent management, fourth respondent management.
Please.
As a, when you have appointed?
Manoj, on the 8th of September 2009.
On Sanskrit lecturer on 8th September 2009.
Please.
Till today, petitioner is working in that institution. Therefore, he has submitted in a representation annexure J.
E, J and O, Manoj.
Annexure?
E, J and O, Manoj.
Yes, E, J and O to that respondent. Secretary, 3 to 4, 3 and 4.
Please.
3 and 4.
Please.
For regularize his service, since his representation is not considered, he is before this court. In view of the above, without expressing any opinion on the merit of the, since the respondent is not considered that representation submitted by the petitioner, the above writ petition, it is suffice for this court to direct the respondent to consider that representation dated so and so. Accordingly, writ petition is disposed of. Respondent number 3 to 5 is directed to consider that representation submitted by the petitioner, annexure E, J and J1 in accordance with law as expeditiously as possible, not later than 3 months from date of first copy.
I'm so grateful.
Yes.
Lordships, kindly, my lords, serial number 47. My lords, I have some inconvenience in the afternoon. May I request for another date, please? 47.
40, I'm appearing for the petitioner.
47, yes.
Please,
The request of counsel for that petitioner is this matter of
49,
2 weeks.
49. I inform the other side.
49.
Any other day, Lord, Friday or Monday.
At the request of counsel for respondent, leave this matter next week.
Please.
Party, my lord. Party, any next week.
40?
40, I'm appearing for the petitioner, my lord.
Itself is also there.
In this week itself, if any date, on the
Next
their
week,
request,
any
You are appearing
very
for
short point for consideration.
You are for the respondent.
Respondent 3.
You want time.
No, ma, I'm not seeking time, my lord.
You want
I'm ready,
time.
my lord.
Why?
To get instructions, just they have given.
Yes, at the request of respondent, leave this matter.
In
on
this week
16th.
itself, any date, my lord.
16th.
A very short point for consideration, my lord.
Yellow short point about time illala. Yes.
41 minutes
41.
for the petition. Any other date?
At the request of counsel for the petitioner, leave this matter on 17th. Yes.
For the serial number 46, the matter may be taken on after 2 weeks.
81.
Yes.
My lords, I have to
46.
give the matter.
80?
81. I've ETU'd. Yes, not day before yesterday, your lordship will not be kind enough.
Yes.
No, why?
Yes.
Your lordship, next week.
Yes. Any date?
Sorry. Serial number 46.
6th
Friday I have that RFAS matters and RSA. 4th, 5th.
ಅಂದ್ರೆ ಸರಿಯಾಗದೇ ಇದ್ರೆ ಮತ್ತೆ ಪುನಃ ನಾನು ಕೇಳೋದು ಬೇಡ.
ಆಯ್ತು, will grant time. There is no problem. Yes.
Allot serial number 46.
9th.
Sir, one ನಿಮಿಷ wait ಮಾಡಿ ಬಿಸಿ.
9th ಬೇಡ, 10th.
Great.
You
No,
inform
sorry,
other
my
side also.
profound
Yes.
apologies.
What is that?
Should we accredit said, my lord, regarding
fourth and fifth respondents, he will.
No, after completion, you do it, then only he has to answer and you have to reply, that's all. It may not take another 1 hour. Yes.
My lord,
10th.
63, my lords.
63.
It is a Morarji Desai school teacher.
Yes.
District Committee Chikmagalur recommended that the petitioner should be granted a weightage.
Yes.
Representation is pending in view of the latest Supreme Court judgment. Only direction to consider.
Yes, you want
230.
adjournment?
No, 2:30 it can.
No, we will here. There is no any 2:30 matter today.
Serial number 44.
Huh? Same, it will be in 2:30.
Serial number
69,
It is only 1 hour, we will finish it up. Yes.
69, my lords.
Yes.
But it's where, my lords, we sought permission to fill up the post in primary school. But the other side, my lords, the state was required to reply.
Yes, Mr. ನೀವೇ ಕೇಳಿದ್ರೆ ಅವ್ರು ಬಾರಿ
ರೆಡಿ
ಖುಷಿಯಾಗಿರ್ತಾರೆ.
ಇಲ್ಲ ಅಂತ ಅಂದ್ರು, ಅದು ಇಂಡಿಕೇಶನ್. ಅದಕ್ಕೆ let me indicate any date, my lords.
Yes, 12th.
12th, my lords, if it is possible, my lords,
Serial number
so that matter can be disposed of. Covered by 2 decisions, my lords.
No, then you wait today. Today I think I can reach because there
Some
is no.
difficulty, my lords, some difficulty.
You are also in the problem today. Yes. Yes.
My lord, serial number 45 may be adjourned.
11. Yes.
ಇಲ್ಲ preliminary angle orders ಅಲ್ಲಿ ನಾವು ತಗೋಬಹುದು.
No preference to any case. Whatever
covered
is
by
stage,
decision, my lord.
I will try my level best to reach. If it is not reached, what?
Serial number
ಏನೋ
40.
ಭಾರಿ ಪ್ರಾಬ್ಲಮ್ ಇದ್ದು ಏನಾರು ಆಗುತ್ತೆ ಅನ್ನೋದಿದ್ರೆ we have to protect that interest of the parties then. Otherwise, yes.
Serial number 44, my lords.
44,
my lords.
Yes.
I appear for respondent in 44.2 and 3, my lord.
You are objecting. Yes, Mr. Objection. We'll see when the matter is called. Yes. We'll see when the matter is called.
Next week.
Sir, list 2 matters ಎಲ್ಲ ರೆಫರ್ ಆಯ್ತಾ?
50 ಅರ್ಜನ್ ಆಗಿಲ್ಲ
ಕಂಪ್ಲೀಟ್ ಲಿಸ್ಟ್. ಡೇಟ್ ಏನು ಕೊಟ್ಟಿಲ್ಲಲ್ಲ, ರೆಫರ್ ಅಷ್ಟೇ. 14/3 ನ. ಥ್ಯಾಂಕ್ ಯು.
50 ಇಲ್ಲ, 50 ಇದೆ. ಕೇಳ್ಬೇಕಪ್ಪ, ಅದಕ್ಕೆ ಬಾಸ್ ಅವರು ಇದೆ 230 ಇರ್ತವೆ.
Sir, second list 24.
ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್. ಆಯ್ತು ಕೇಳ್ತೀನಿ. ಬಾಸ್ ಅವರು ಇದೆ ನೋಡೋಣ ಏನ್ ಹೇಳ್ತಾರೆ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಇಲ್ವಾ? ಡಿವಿಷನ್ ಬೆಂಚ್ ಇಲ್ವಾ?
ಅದನ್ನೇ ಸರ್ ಹೇಳಿದವ್ರಿಗೆ, ಬೇರೆ ಬೇರೆ ಬೆಂಚ್ ಎಲ್ಲ ಇದೆ, ಕೇಳ್ಬೇಕು, ವೇಟ್ ಮಾಡಿ ಅಂತ.
42.
ಏನಪ್ಪ?
List 140.
ಏನಾಯ್ತು ಅಂತ ಇದೆ. ಓಕೆ.
ದಟ್ಟು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಲೋಕದಲ್ಲತ್ತು.
ಹೌದಮ್ಮ. ಏನ್ ಯಜಮಾನ್ರು ಹೇಳಿ. ಯಾವ ಫಸ್ಟ್ ಕೇಸ್, ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? ಎಷ್ಟು ನಿಮ್ ನಂಬರ್ ಗೊತ್ತಾ? ಕೇಸ್ ನಂಬರ್ ಗೊತ್ತಾ? 17ನೇ ತಾರೀಕು ಹೋಗಿದೆ. ಗೌರ್ಮೆಂಟ್ ಲಾಯರಾ? ನಯನತಾರ PG ಅಂತ ಅವ್ರ ಮೇಡಮ್ ಇರ್ತಾರೆ.
ಗೊತ್ತಾಗಿಲ್ಲ ಕೇಳ.
ಸರ್ ಅವ್ರು ರಿಟೈರ್ಮೆಂಟ್ ಒಳ್ಳೆ ಸರಿಗೆ ಅದು ಮಾತಾಡಕ್ಕಾಗ್ತದೆ ಅವರೇ
ಬಹಳ ನೆನ್ನೆ ಇಲ್ಲಿ ಇವಾಗ ಹುಷಾರೇ ಇಲ್ಲ ನನ್ನ ಅರ್ಪಿತ ಹಿಂದೆ ಸರಿ ಅವ್ರು ಹುಷಾರಿಲ್ಲ ಅವ್ರು ಅಮೇರಿಕ ಈ ರೀತಿ ಎಲ್ಲ ಮತ್ತು ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಅದಕ್ಕೋಸ್ಕರ ಅದು ಸ್ವಲ್ಪ ಸೀರಿಯಸ್ ಇದೆ ಏನೇನು ಆಟಾಡ್ತಿದೆ ಗೊತ್ತಾ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಅದು ಇದು ಎಲ್ಲ ಕೂರಿಸ್ಕೊಂಡು ಏನೇನೋ ಮಾಡಿ ಹಿಂದಿನಿಂದ ಅದೇ ರೀತಿ ಆಗ್ತಾ ಇದೆ ಅದೇ ಅದೊಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ನಾವು ಒಂದು ನಾರಾಯಣ ಭಟ್ ಇದ್ರ ಹೌದು ನಾನು ಅಂತ ಹೇಳಿದ್ರೆ ಆಫೀಸ್ನಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೆ ಹೌದು ಈಗ ಬಿಲ್ ಚೇಂಜ್ ಆಗಲ್ಲ ಸರ್ ನಾರಾಯಣ ಭಟ್ರು ಇದ್ದರೆ ನಾನು ಮಾತ್ರ 2 ಬಾರಿ ಫಿಕ್ಸ್ ಆಗಿರೋದಲ್ವಾ ಈ ಕೋರ್ಟ್ನಲ್ಲಿ ಕೂತ್ಕೊಂಡಿದ್ದೀನಿ ಹೆಚ್ಚು ಅವರಿಂದ ಈಗ ಅವ್ರು ಮಾಡಿ ಹುಷಾರಿಲ್ಲ ಮತ್ತೆ ಈಗ ಈಗ ಮತ್ತೆ ಹೌದು ಕೊಟ್ಟಾಗಿದೆ ಕೊಟ್ಟರೆ ನಮ್ಗೆ ಏನ್ ಮಾಡೋದು ನಾವು 3 ಜನ ಇದ್ದೀವಿ ನಮ್ಮ ಕೊಡಿ ಸರ್ ಅಲ್ಲ ಈಗ ನಾರಾಯಣ ಭಟ್ರು ಇದ್ದಾರೆ ಓಕೆ ನಾವಿಲ್ಲಿ ಇದ್ದೀವಿ ನಾವು ಇಲ್ಲಿ ಬೋರ್ಡ್ ಒಳಗಡೆ ಇದ್ದೀವಿ ನೋಡಿ ಎಸ್ 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 ಭಾಳ ಇದು ನಮಗೂ ಇಲ್ಲಿ ಬಂದ್ಮೇಲೆ ಇದೆಲ್ಲ ಈ ಓಕೆ ಬೋರ್ಡ್ ಲೈವ್ ಇದೆ ಸರ್ ಬೋರ್ಡ್ ಅದು astonishing stories.
ಎಲ್ಲಿದ್ದೀರಾ ಶ್ರೀನಿವಾಸ್? ಹೆಂಗೆ ಪೊಸಿಷನ್?
What next week? ಮೀಡಿಯೇಷನ್ ಇದು ಸಾರಿ ಲೋಕ ಅದಾಲತ್ 14-3 ಏನ ಕೆಳಗೆ ಬಿದ್ದಿತ್ತದ ಯಾರು ಏನ ಆಯಮ್ಮ ಯಾರು ಇದು ಯಾವ ಕೆಳಗೆ ಬಿಸಾಕಿದ್ರೆ ಇವ್ರಿಗೆ ಎಷ್ಟೊಂದು ಅರ್ಜನ್ ಆಗಿದೆ ತಕ್ಕೊಡ್ತೀನಿ.
ಹಲೋ, ಗುಲ್ಬರ್ಗ ಕೋರ್ಟಿಂದ ಆಡಿಯೋ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಲ್ಲ?
ಕ್ಲಿಯರ್ ಇದೆ.
ಹೋಟೆಲ್ ನಂಬರ್ ಬೆಂಗಳೂರು ಬೆಂಚ್.
ಹೌದು ಸರ್, ಹೇಳಿ ಸರ್. ಹಾ ಸರ್,
ಹೋಟೆಲ್ ನಂಬರ್ ಬೆಂಗಳೂರು ಬೆಂಚ್.
ಹೌದು ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಹೇಳಿ.
ಆಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆ ಸರ್?
ಕ್ಲಿಯರ್ ಇದೆ.
ಓಕೆ.
ಹೇಳಿ ಸರ್. ಹಾ 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 ಹೌದಾ? ಹಾ ಸರಿ ಸರ್, ಹೇಳಿ. ಹಾ ಮಾಡಿ ಸರ್, ಮಾಡಿ. ಅದು ತರ್ಸ್ಕೊಂತೀನಿ ಅಷ್ಟೊತ್ತಿಗೆ ಮಾಡಿ ಸರ್. ಓಕೆ ಸರ್. ಎಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ ರೀಚ್ ಮಾಡಿ ಹೇಳಿ. 41, 73, 42 ಇದೆ, 43 ಇದೆ. ಅಜ್ಜ ನಾನು ಹೇಳ್ಬೇಕಾ? 47, 49, 69, ಬಂದಿದೆ. ಅವ್ರು ರೆಡಿ ಆಗ್ತಾರೆ. 81.
ಹಲೋ, ಹಾ ಹೇಳಿ ಸರ್. ಮೆನ್ಷನ್ ಮಾಡ್ತೀವಿ, ನಿಮ್ಮ ಕಲಿ ಕಳಿಸಿದ್ರೆ ಸೊ ದಟ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ಅಲೌ ಮಾಡ್ತಾರೆ. ಯಾರು ಮೇಡಮ್ಮ? ಎಷ್ಟನೇ ಕೋರ್ಟ್ ಬಂದಿದ್ದಾರೆ?
ಸರ್ ಹೇಳಿ. ಅಜ್ಜನ ಒಳ್ಳೆ ಸರ್, ಇಲ್ಲೇ ಇದ್ರು, ನೀವು ಇರ್ಲಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಅವರು ಫುಲ್ಲು ಬ್ಲಾಕ್ ಆಗಿದೆ. ಡೇಟಾ ನಾನು ಅವ್ರು ಕಂಡು ಕೂಡಲೇ ಹೇಳ್ಬಿಟ್ಟೆ, ಪಾಪ ವೇಟ್ ಮಾಡೋದ್ ಬೇಡ, ಯಾಕಂದ್ರೆ ಸಾಹೇಬ್ರು ಯಾಕ್ರಿ ಹೇಳಲಿಲ್ಲ ಅನ್ಬಾರ್ದು. ಬಟ್ ಇಲ್ಲ, ನಾವು ಫರ್ದರ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರು ಮಾಡಿ ಸರ್. ಇಲ್ಲ, ಅವರು ಚೇಂಜಸ್ ಕೇಳ್ತಾರೆ, ತೋರಿಸ್ಬಿಡಿ ಸರ್. ಹೌದೌದು ಸರ್, ಅವೆಲ್ಲ ಕಾಮನ್, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇದನ್ನ ನಾನು CPC ಸಬ್ಜೆಕ್ಟ್ ಇದ್ದಾಗ ಫೇಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಇವಾಗ ನೀವು ಹೇಳಿದ್ದನ್ನ ನಾನು CPC ಹಾ ಹಾ
ನಮಸ್ಕಾರ. ಮುಂಚೆ ಸಂಡೆ
ಎಲ್ಲ ಹೋಗಿದ್ದಾರೆ ಜಡ್ಜಸ್. ಹೌದಾ? ಮತ್ತೆ ನಮ್ದು ಗುಲ್ಬರ್ಗ ಪಾಪ ಅವ್ರು ಬಂದ್ಬಿಟ್ರೆ ಸಾಹೇಬ್ ಇನ್ನೂ ಇಲ್ಲ ಬಂದು. ಈವ್ನಿಂಗ್
ಒಂಜಿ ದಿನ ಬೋರ್ ಹಾಕೊಂಡು ಎಕ್ಕದಲ್ಲ ಅಂದ
ಮಧ್ಯಾಹ್ನ ಕೊನಸ್ಕೊಂಡು ಗೊತ್ತಿತ್ತು ಶಾಲೆ
ಅದ್ಯಾವುದೋ ಫೈಲಿಂದ ಬಿದ್ದೋಗಿದೆ ಅನ್ಸುತ್ತೆ. ಇತ್ತು ಅప్పుడే ಅದು ಹೋಗುವಾಗ ಸುಮ್ಮನೆ ಅದ್ರದ್ದ
ಅಂದಂದು ಗ್ಯಾಸ್ ಐ ಕ್ಯಾನ್ ಇನ್ಫಾರ್ಮೇಶನ್
ಈ ಗ್ರೂಪ್ ಮುಗಿಯೋವರೆಗೂ
ಅರ್ಜೆನ್ಸಿ
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ರೆ ಮತ್ತೆ
ಮುದದಿಂದಲೇ ಒಂದು ದಿಕ್ಕಿನ ಮಾಡ್ತೀವಿ
taken as further hearing.
ಮತ್ತೆ ಬಂದು serial number
81, 230 meter.
Oh, it is designated. You have taken at 1%. Not a big data.
130. Consider, okay.
I say,
Correct 130. Timings of the same.
ಇದು ಓಡ್ಕೊಂಡು ಇಟ್ಬೋದು.
The
time sense. And then inform.
Arcachari. ಅದನ್ನೇ ಇಷ್ಟು ಅದರಿಗೆ ಫರ್ದರ್ ಏನು ತಗೊಂಡು ಇವರು ಯಾಕಂದ್ರೆ ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡಿ ನಾವು ಬರುವ ಒಳಗೆ
ಇಲ್ಲ measurement argument ಆಗಿದೆ.
My lord, one submission with respect to serial number 81. I am told that this honorable court was pleased to adjourn the matter to March 10th.
Yes, yes.
My lord, it may be taken as further hearing because substantially it has been argued.
It will be there. What will happen? 2:30. 2:30 it will come on that day.
Yes. It, like further hearing, my lord.
No, 2:30 matter, it will be another 1 hour it requires. He will give and he will take another half an hour to reply. That's all is left.
Please, my lord.
Yes. 10th, 2:30. 2:30, yes.
Further hearing.
Yes, 2:30 it will come on that. Yes.
Part heard because substantially.
Bharat, I don't think any this thing. It will
ಅವರು ಚೇಂಜ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Let us see. Yes.
That is the only ambiguity we had, my lord.
Yes. 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 Yes.
May May I make a mention?
You know, that should, now I have Kalburgi bench matter, then I will, yes. Intimate ಮಾಡಿಲ್ವಲ್ಲ ಕೇಳಿದ್ರೆ ಬಂದಿಲ್ಲಲ್ಲ ಕೇಳಿ ಫೋನ್ ಮಾಡಿ ಚೇಂಬರಿಗೆ ಫೋನ್ ಹಾ yes.
Kalburgi bench matter for pronouncement of judgment, serial number 1, Vishal Pratap Singh for appellant, additional SPP.
This appeal is hereby dismissed. Consequently, the judgment dated 22/12/2018 of the learned second edition session judge Kalburgi in special case number 8/2018 shall stand confirmed.
Hearing interlocutory application matter, serial number 2, government advocate.
Yes.
Yes, Mr. Government Advocate.
Serial number 2, government advocate.
Yes. Who is appearing, Mr. Patil?
Yes.
Sir, I appeared for sale number 1, my lords. Of
No,
course,
no, no,
yes,
second
I'll-
matter.
Second matter,
Government.
yes,
Second matter.
I don't file, my lords. Then
None
also I'll
appear.
appear.
VM
My
Veeradhar.
lords.
Yes,
Additional
none appear.
department. There is no representation.
Yes, there is no representation on behalf of
My lords, one submission.
petition. Government leaves this matter after 2 weeks. Yes.
Thank you, sir.
Yes, but thank you, brother. Yes.
Principal bench matter, past hour matter.
Before that, serial number 56, at the 56 minute, at the last time your lordships have ordered to post the matter in the orders list.
You the other ಬೇರೆ ಯಾವುದು which is the
56ರಲ್ಲಿ there is an application filed for bringing LRs. Your lordships day before yesterday, that is 23,
Yes.
ordered to post the matters on the orders list. In
Serial
spite
number?
of 56 minute. In spite of that, it has been posted in the B group.
Is it Mr. Court officer?
ನೋಡಿ ಸರ್ ಹೇಳಿ
ನೋಡಿ ನೋಡಿ ಇದೆ. ಏನಾಗಿದೆ ಇವತ್ತು ಇದೆಯಾ?
ಅದೇ ಇವತ್ತಿದೆ ಅದು ರೀಚ್ ಆಗ
Wait, we'll reach. Let us see.
ಆಯ್ತು
Otherwise
ರೀಚ್
we'll
ಆದ್ರೆ
fix the date for orders.
ಆಯ್ತು.
Yes. Correct.
past hour matter, serial number 11, Shiva Yogesha.
I have complied.
ಯಾಕೆ ಪಾಸ್ವರ್ಡ್ ಬರುತ್ತೆ? Continue ಮಾಡ್ರಿ. Who said that password?
Continue.
Yes.
Continuation of list, serial number 42, KL Srinivas for petitioner, Mohammad Ayub Ali. KL Srinivasa.
Yes. Serial number?
42, sir.
Yes. Yes, Mr. None appear for the petitioner. Is this matter after 3 weeks? Yes.
Serial number 43, Venkatesh Somareddy.
Which matter? ಯಾವ ಮ್ಯಾಟರ್ ಅಲ್ರಿ? 43. No, 43, this is the matter which has been heard, ಅದಲ್ವಾ? ಏನಿದೆ ನಿಮ್ದು? Hmm.
ನಮ್ಗಿಲ್ಲ.
Hmm.
ಎಲ್ಲ ಟೂ ಮಾತ್ರ ಒಂದು.
What is the qualification required?
ಫಸ್ಟ್ ಒಂದು ಏನು ಟಚ್ ಮಾಡ್ತೀವಿ. ನಮ್ಮ ಹತ್ರ ಏನೂ ಇಲ್ಲ.
Which petitioner has not, all petitioner has not qualified? ಯಾವ್ದು ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ? 2 double? Serial number ಎಷ್ಟ್ರಿ?
Sir, 43.4.
Hmm. 43.4. Yes, what is this? Hmm. Yes. Hmm. Yes. Yes. Yes, Mr.
Petition submission, my lord, in the main matter, your lord.
Yes. Yes.
Lordship, my lord, the matter, first matter is, my lord, 27878.
Yes.
That is, my lord, 43.2.
Yes.
That we have argued on the, my lord, the legal question.
Yes.
On the last occasion, your lordships, my lord, the learned additional advocate general
Yes.
has took, my lord, the UGC, my lord, UGC regulations.
Yes.
Before going to that, my lord, it is a backlog vacancy. I will take your lordship, my lord, Annexure D, page 43.
ಯಾವ ಕೇಸಲ್ಲಿ?
My lord, that is on
Notification.
27878.
Notification?
Notification.
Notification.
27878. 27878.
ಆಯ್ತು, ಇದ್ರಲ್ಲೇ ನೋಟಿಫಿಕೇಶನ್ ಇದೆಯಲ್ಲ ಹೇಳಿ.
ಇದೆ.
ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಅದೇ ತಾನೇ?
Notification is same, my lord.
Yes, yes.
But what is, my lord, the backlog vacancies? Just to
read.
point out, my lord, Annexure D, page 43.
ಅಲ್ಲ, ನೋಟಿಫಿಕೇಶನ್ ಡೇಟೆಡ್.
Notifications ಎಲ್ಲ ಸೇಮ್.
ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ಒಂದ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇದೆ, ಅದನ್ನೇ ಹೇಳಿ ಅಂತ.
ಅದನ್ನ ಹೇಳ್ತೀನಿ. Then before that, my lord.
That is dated 28/3/23.
Please.
Where
Before going to that, your lordship, my lord, this is the backlog vacancies accrued, my lord, from 2015 onwards. For that, my lord, I have to show your lordship, my lord, Annexure D.
No, there are two things.
Please, my lord.
Backlog is reserved for that SC/ST or that is that
No,
post which is
backlog
not.
vacancies, my lord, vacancies,
Yes.
not the reservation.
Yes.
Why, my lord, I am harping on that? This is not, my lord, in the midway to, my lord, to come to, my lord, the proportion of law. My lord, Annexure D, page 43.
Yes.
My lord, para 2 of that, my lord, document Annexure D.
Yes.
ಅದರಂತೆ ಪ್ರಾದೇಶಿಕ ಜಂಟಿ ನಿರ್ದೇಶಕರು second para.
Annexure.
My lord, Annexure D, page 43. I will read from, my lord, the
Yes.
ಫಸ್ಟ್ ಪ್ಯಾರ. ಇಲಾಖಾ ವ್ಯಾಪ್ತಿಗೊಳಪಡುವ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜುಗಳಲ್ಲಿ 31/12/2015 ನಿವೃತ್ತಿ, ನಿಧನ, ರಾಜೀನಾಮೆ ಹಾಗೂ ಇನ್ನಿತರ ಕಾರಣಗಳಿಂದ ತೆರವಾಗುವ ಬೋಧಕರ ಹುದ್ದೆಯನ್ನು ಕೆಲವೊಂದು ಷರತ್ತುಗಳು ಒಳಪಟ್ಟು ಮಾಡಲು ಉಲ್ಲೇಖ ಸೋಣಿಸೋ ಸರ್ಕಾರದ ಪತ್ರದ ಅನುಮತಿ ನೀಡಲಾಗಿದೆ. ಅದರಂತೆ ಪ್ರಾದೇಶಿಕ ಜಂಟಿ ನಿರ್ದೇಶಕ ಕಚೇರಿಗಳಿಂದ ಬರುವ ಪ್ರಸ್ತಾವನೆಗಳಲ್ಲಿ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜುಗಳಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿಗಳ ಸಂಖ್ಯೆ ಹಾಗೂ ಕಾರ್ಯಭಾರಕ್ಕೆ ಅನುಗುಣವಾಗಿ ದಿನಾಂಕ 31/12/2015 ಖಾಲಿ ಇರುವ ಬೋಧಕರ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲು ಈ ಕಚೇರಿಯಿಂದ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು. This is the government order, my lord, communicated to the all the college, including, my lord, the petitioners college.
Yes.
That is addressed by the government.
Yes.
Why, my lord, I am referring to these documents is the backlog, my lord, not the reservation, backlog vacancies.
Yes.
Accrued for, my lord, for several years.
Yes.
That is 2015. And, my lord,
the recruitment has taken place 2015, and my lord, partially the selection was completed. My lord, almost all 70% of the recruitment was completed. For the remaining,
When completed?
my lord, that has made gradually from 2015, gradually midway, my lord. That is the notification. The lordship may kindly go to my lord, page 119.
Yes.
119 annexure L. My lord, this I will read your lordships, my lord. From top, ಪ್ರಸ್ತಾವನೆ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆಯಲ್ಲಿ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜುಗಳಲ್ಲಿ ದಿನಾಂಕ 31/12/2015 ಒಳಗೆ, ದಿಸ್ ಇಸ್ ರೆಫರೆನ್ಸ್ ಟು 31/12 ಒಳಗೆ ವಿವಿಧ ಕಾರಣಗಳಿಂದ ಖಾಲಿ ಇರುವ ಬೋಧಕರ ಹುದ್ದೆಗಳನ್ನು ಆಯ್ಕೆ ಸಮಿತಿಯ ಮೂಲಕ ಸಂದರ್ಶನ ನಡೆಸಿ ಭರ್ತಿ ಮಾಡುವ ಸಂಬಂಧ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಕೆಲವೊಂದು ಷರತ್ತು ಮಾನದಂಡ ನಡೆಸುವ ಮೂಲಕ ಸರ್ಕಾರದ ಆದೇಶ ಕೋರಲಾಗಿರುತ್ತದೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 2 ಸರ್ಕಾರ ಆದೇಶದಲ್ಲಿ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜುಗಳಲ್ಲಿ ವಿವಿಧ ಕಾರಣಗಳಿಂದ ದಿನಾಂಕ 31/12/15 ಖಾಲಿಯಾಗಿರುವ ಬೋಧಕರ ಹುದ್ದೆಗಳನ್ನು ಉಪಲಬ್ಧ ಕಾರ್ಯಭಾರದ ಆಧಾರದ ಮೇಲೆ ನಿಯಮಾನುಸಾರ ಭರ್ತಿ ಮಾಡಲು ಸರ್ಕಾರದ ಅನುಮತಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ ಸರ್ಕಾರ ಪತ್ರದಲ್ಲಿ ಆರ್ಥಿಕ ಇಲಾಖೆ ನಿಗದಿಪಡಿಸಿರುವ ಚೆಕ್ ಲಿಸ್ಟ್ ನಂತೆ ವಿದ್ಯಾರ್ಹತೆ ಮೀಸಲಾತಿ ಕಾರ್ಯಭಾರದ ಆಧಾರದ ಮೇಲೆ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಗಳನ್ನು ಖಾಸಗಿ ಅನುದಾನಿತ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಕಗಳಿಗೆ ಆರ್ಥಿಕ ಇಲಾಖೆ ನಿಗದಿಪಡಿಸಿರುವ ಮಾನದಂಡಗಳ ಅನ್ವಯ ಪಾರದರ್ಶಕವಾಗಿ ಖಾಲಿ ಹುದ್ದೆ ಭರ್ತಿ ಮಾಡಲು ನಿಯಮಾನುಸಾರ ನೇಮಕಾತಿಗಾಗಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸುವ ಬಗ್ಗೆ ಅನುಮತಿ ನೀಡಲು ಆಯುಕ್ತರು ಕಾಲೇಜು ಶಿಕ್ಷಣ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆಯವರಿಗೆ ಅಧಿಕಾರವನ್ನು ಪ್ರಚೋದಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಆಯುಕ್ತಾಲಯದಿಂದ ಅನುಮತಿ ಪಡೆದ ನಂತರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಹಂತದಲ್ಲಿ ಖಾಲಿ ಹುದ್ದೆಗಳನ್ನು ಪಾರದರ್ಶಕವಾಗಿ ಮತ್ತು ಏಕರೂಪವಾಗಿ ನಡೆಸಲು ಕೆಲವೊಂದು ಮಾರ್ಗಸೂಚಿಗಳನ್ನು ಷರತ್ತುಗಳನ್ನು ವಿಧಿಸಲು ಸರ್ಕಾರವು ತೀರ್ಮಾನಿಸುತ್ತೆ ಕೆಳಗಂಟೆ ಆದೇಶಿಸಿದೆ. ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜ್ ದಿನಾಂಕ 31/12/15 ವಿವಿಧ ಕಾರಣಗಳಿಂದ ಖಾಲಿಯಾದ ಬೋಧಕ ಹುದ್ದೆಗಳಿಗೆ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಸರ್ಕಾರದ ಅನುಮತಿ ನೀಡಿದ್ದು, ಅದರಂತೆ ಆಡಳಿತ ಮಂಡಳಿಗಳು ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಆಯ್ಕೆ ಸಮಿತಿಯ ಮೂಲಕ ಸಂದರ್ಶನ ನಡೆಸಿ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಸಂದರ್ಶನ ನಡೆಸಲು ಮತ್ತು ಪ್ರಸ್ತುತ ಸಮಿತಿ ಮೂಲಕ ಸಂದರ್ಶನ ನಡೆಸಿ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಸಂದರ್ಶನದ ನಡೆಸಲು ಪ್ರಸ್ತುತ ಬಾಕಿ ಇರುವ ಎಲ್ಲಾ ಪ್ರಕರಣಗಳು ಒಳಗೊಂಡಂತೆ ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳನ್ನು ಮಾನದಂಡ ವಿಧಿಸಲಾಗಿದೆ. ಖಾಲಿ ಹುದ್ದೆ ಭರ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ UGC ಅಧಿಸೂಚನೆ regulations of minimum qualification for appointment of the teachers and other academic staff in universities and colleges and other measures for the maintenance of standards of education 2018 dated 18/7/2008 table 3B ರಲ್ಲಿ ನಿಗದಿಪಡಿಸಲಾಗಿರುವ ಅರ್ಜಿಯ ಸಲ್ಲಿಸಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಅಂಕಗಳನ್ನು ನಿಗದಿಪಡಿಸಿದ 1:5 ಅನುಪಾತದಲ್ಲಿ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಸಂದರ್ಶನಕ್ಕೆ ಆಹ್ವಾನಿಸುವುದು. ಸಂದರ್ಶನಕ್ಕೆ ಆಯ್ಕೆಯಾದ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಸಂದರ್ಶನದ ಕರೆಯನ್ನು ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಮೂಲಕ ರವಾನಿಸುವುದು. ಸಂದರ್ಶನಕ್ಕೆ ಕೆಳಗಂಡಂತೆ 110 ಅಂಕಗಳನ್ನು ನಿಗದಿಪಡಿಸುವುದು. Then your lordships, my lord, out the 110 marks split into my lord various my lord categories. That is, my lord, item number 4 PhD 25, net 10, NET 8, SLAT SET 5.
Yes.
Then my lord, the publication 6, teaching experience 10. My lord, then international and national level award 3. Then my lord, the state level 2. Domain knowledge, your lordship may kindly see my lord, item number 9.
Yes.
Domain knowledge 5, communication skills 5. Your lordship, my lord, please come, my lord, come to my lord, the item number D.
Yes.
My lord, these two subjects, domain knowledge 5, communication skill, my lord, it's not find place anywhere in the, my lord, UGC regulations.
No, it is UGC regulation is not speaking about that how interview has to be conducted. It is entire domain of
that is the crucial question, my lord. If I am not eligible in a selection list, my lord, it's short list, what they will call as, my lord, the short list. If I am not eligible in this short list, my lord, I will not be, my lord, eligible for participation. That is the, my lord, the crux of this issue.
This is for an interview, mister. You have to participate in that written examination. Written examination idya? Written illa. Your list will be selected for shortlisting. Only your qualification is required.
But
Qualification
and that UGC's that guidelines
Then your lordship may kindly go to.
is for interview. That is what the distinction made by that.
No, that's entirely different, my lord. Your lordship may kindly go to, my lord, UGC regulation 64.
No, there is no dispute, Mr. UGC regulation is for only shortlisting the candidates for interview. How interview has to be conducted, government has issued a circular because UGC has not said. UGC said that do it in accordance with law.
But if I am not, my lord, this is the crux of the issue. My lord, page 64, annexure K.
If you are qualified as per the table mentioned in that, what is that, in that UGC regulations, you are qualified for an interview. For how to interview conducted, it is there. You have not been shutted out, Mr.
As far as my case is concerned, my lord, all my lord, my clients, my lord, they have applied, and my lord, the interview was not held on the, my lord, the respective dates.
Interview you have to be 1:5.
That is, my lord, if I am eligible.
No. See, interview ge 1:5 al ನೀವು ಬರಬೇಕು. You are qualified to be applied for the post.
But where is that 1:5, my lord? Where is that 1:5?
They can be.
No, that cannot be.
We'll answer. If 10,000 candidate has been applied, qualified, you can't conduct 10,000 candidates for an interview.
No. There must be some rationale behind that, my lord. For that, your lordship may kindly, my lord, go to, my lord, at the table 3 again, at the cost of, my lord, the reputation. Table 3.
Where is that it is mentioned 1:5?
Your lordship, 115. 115.
ಅಲ್ಲ ನೀವು ಒಬ್ಬೊಬ್ಬರು ಒಂದೊಂದ್ರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅದರಲ್ಲಿ ಅವರೆಲ್ಲ ವೇರ್ ಇಸ್ ದಟ್ 1:5 is referred
1 ಇದರಲ್ಲೇ ಇದೆ, ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲೇ ಇದೆ, ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್ ನಲ್ಲೇ ಇದೆ.
ಎಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ?
ಪೇಜ್ 120 120 ಅಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 1 ಖಾಲಿ ಹುದ್ದೆಗಳ ಭರ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ UGC ಸೋಂಡ್ಸೋ ಅಂತ ಆದ್ಮೇಲೆ ಲಾಸ್ಟ್ ನಲ್ಲಿ ಟೇಬಲ್ ಬಿ ರಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಅಂಕಗಳನ್ನು ನಿಗದಿಪಡಿಸಿದ 1:5 ಅನುಪಾತದಲ್ಲಿ ಸಂದರ್ಶನಕ್ಕೆ ಆಹ್ವಾನಿಸಲಾಗುವುದು. Lord, then your lordship, my lord, now go to Lord the table 3B 115 criteria for shortlisting of candidate for interview. My lord, this is for also for interview. 115 UGC regulations, page 115, my lord, in my petition. Interview is something different from.
No. Shortlisting for interview. Interview will come that next. Here, shortlisting. See, person who has qualified this, you shortlist for an interview. If you are qualified all these things, you are entitled for the interview. Then they can say that among that one post again now I janan karitivi anta 1:5 they said.
That where they will get, my lord, where they will, that is the judgment of, my lord, the Manjushri case, which is referred to, my lord, 3 judges bench. Then, my lord, in the Tej Prakash case referred to Shivananda's case. They cannot tinker with the, my lord.
Qualification cannot be tinkered. Interview, how to conduct, it is for the domain of that employer. You can't say that.
My lord, apart.
No,
my lord, they can work it out.
There are 36,000 persons who is qualified for an interview. Do you mean to say that 36% has to be interviewed?
No. There must be some rash.
ಅದಕ್ಕೆ ಇದನ್ನ ಮಾಡಿದ್ರು 1:5.
That wisdom has to, my lord, that has to be, it is the wisdom of the management. They cannot take on over. That is the, your lordship, kindly, my lord, 115.
Yes.
Then the purpose of, my lord, conducting an interview will be OTOs. My lord, table 3B. Criteria for shortlisting of candidates. My lord, it's a replica of what is the government order, except changing the marks, my lord, everything is ditto. My lord, the replica of the government order.
Interview ಕರೆದಾಗ ಯಾವ ತರ ಮಾರ್ಕ್ಸ್ ಕೊಡಬೇಕು ಅಂತ
ಅದು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಬಿಟ್ಟಿರೋದು, ಇವ್ರು ಹೇಳೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
State, whether state has such a power to give directions or not.
That nowhere, my lord.
Management has not come before the court saying that no, you have not. You are a candidate. You can be tested by this method. You can't challenge that. Management who are getting a grant from the government they are saying that yes, that method is correct.
What is the, my lord, the effect of, my lord, this manipulation?
No
They are
manipulation. It is
giving
not.
a room for the management, my lord,
No,
to
no,
manipulate.
no. See, here there is no discrimination at all.
Man,
If
I'll
you are
point
in the
out,
top, you will get it.
I will point
If
out,
you
my
are in
lord, I
the-
will leave it
yes.
to your lordships, my lord.
Yes, yes.
The criteria for shortlisting of a
Now,
candidate.
what that argument which has been advanced earlier is that this table which is created government for shortlisting itself, it is not shortlisting.
There is no, my lord, what is,
For an interview.
my lord, where is, my lord, the shortlisting of the government and for an interview? They have not bifurcated anything. They have not said anything. This is a shortlist and this is for interview. Where is that, my lord? They are following only, my lord, the UGC regulations.
No, Mr.
Table B.
No, see, they have shortlisted that candidate. You are there in that list or not? If you are qualified this qualification, if you are not in that list which is prepared for a short list, then you have a grievance. Among them, they call for an interview 1:5. How to interview has to be conducted, they have made it in a chart.
No, they have not done it. They have not shown anywhere. My lord, what is the procedure adopted for interview? We don't know, my lord. We don't know. Because we have not been even, ಹೇಗಂದ್ರೆ ನಾವು ದೇವಸ್ಥಾನದೊಳಗಡೆ ಹೋಗಿಲ್ಲ. Question of going to the Garbhagudi will not arise at all. We have been sent out in the admission.
ಸಂದರ್ಶನಕ್ಕೆ ಈ ಕೆಳಕಂಡಂತೆ ಅಂಕಗಳನ್ನು ನಿಗದಿಪಡಿಸಿದೆ. ಸಂದರ್ಶನಕ್ಕೆ ಅಂದ್ರೆ ಇಂಟರ್ವ್ಯೂಗೆ. This is not for short listing.
And here also, my
This is
lord.
what that clarification by that AG, what that argued by senior.
Please, my lord, that's
Yes.
I will clarify your lord.
Yes, yes.
And then 15,
Yes.
my lord, the heading itself, my lord, criteria for shortlisting of a candidates
Yes.
for interview for the post of assistant professor in college. Then your lordship, my lord, come down to, my lord, the next page,
Yes.
116.
Yes.
B, number of candidates to be called for interview shall be decided by the college.
Yes.
And my lord, the total marks is 100.
Yes.
My lord, the number of candidates to be interviewed is,
Yes.
my lord, left to the discretion of the management
Yes, yes.
by
That
the
will
UGC.
take- Yes.
They cannot overreach, my lord, the decision of the UGC.
Yes.
If my lord, they have fixed, my lord, 1:5. Why not 1:7?
Yes.
Why
yes.
not 1:10?
Number of candidates for calling. Yes.
If the UGC says,
Yes.
my lord, it is 1:3.
Yes.
My lord, I'm out of, my lord, the contest.
Yes.
I
that will
cannot,
cons-
my lord, tinker with, my lord, this
Yes.
one. Then, my lord, the marks is concerned.
Yes.
My lord, academic score is 84, research publication 6, teaching experience 10. Total, my lord, put together 100.
Yes.
Your lordship, now, my lord, during the pendency of the petition, this honorable court, my lord, issued a direction to issue a corrigendum
Yes.
or a modified order. In view of these developments,
Yes.
my lord, the court has, my lord, your lordship will find in the order sheets, my lord, there is a reference to that. My lord, page 175 is the modified order. This is nothing but,
your petitioner is not applied. You have applied.
my lord, I have applied. ನಮ್ಗೆ ಇಂಟರ್ವ್ಯೂನೇ ಇಲ್ಲ.
ನೀವು
You are not short list ಬರೋದಿಲ್ಲ ಅಂತ ತೆಗೆದಾಕ್ಬಿಟ್ರು.
ನೀವು ಬಾಟಮ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ಅದಕ್ಕೋಸ್ಕರ ತೆಗ್ದಿದ್ದೀರಾ.
ಅಲ್ಲ ವೈ ನಾಟ್ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೆ. 1:7 ಆಗ್ಬೋದು, 1:10 ಆಗ್ಬೋದು. ಅದೇ?
No, that, no, how you have called for an interview? Interview is not a.
That is, my lord,
ಮಾಡ್ತಾರೆ ನಿಮ್ಗೆ.
my clients has informed in the morning. My lord, if the court directs, my lord, they will consider the cases individually, my lord.
No,
because my lord,
no, I have not taken any decision.
Just they came.
You are appearing in this case. You, National Education Society is not yet conducted any interview. You have to be compliant in terms of that. That's what. Yes. They have not yet. You may selected also. Why do you?
ಅಲ್ಲ ಇಂಟರ್ವ್ಯೂ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅದನ್ನ.
Interview ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಶಾರ್ಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಲ್ಲಲ್ಲ. Before that only your party has assumed that he is not entitled.
Because this is coming in the way ಅಂತ.
Worst, mister. Yes. See, if your score which has been mentioned in that regulations of UGC, if you are secured more score, you will be in the top. By challenging that, you are getting affected that, mister.
That's a different.
You have not seen that your candidates. Yes.
ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ No, no, my lord, he has got a slat, my lord, that is an exempted, this is there in the UGC regulation itself.
No,
It's
now in
exempted.
this, we'll see that qualification of petitioner.
Please, my lord.
In all petitioners has. No, Santosh has no PhD.
That has been exempted. My lord,
Where is that?
PhD, that your lordship will find in the UGC regulation itself.
ಅಲ್ಲ ಅವ್ರ ಎಕ್ಸಾಮ್ಷನ್ ಇದೆ
ಅಲ್ಲ ಇದು ಎಕ್ಸಾಮ್ಷನ್ ಇದೆ
ಎಲ್ಲಿದೆ
page 116
Yes.
in the UGC regulation at item number D
116 yes
SLET and SET score shall be valid for appointment in respect of state university college and institutions only. And my lord, in these colleges where my learned friend Mr. Reddy is appearing,
Yes.
they have appointed my lord 10 candidates. My lord, 10 candidates, those who have completed my lord the qualification of SLAT and KSAT.
now that we'll see assistant college including the college the selection committee's post professor where is that qualification it is prescribed UGC yes arts commerce master degree with 55 marks equivalent to that also in validity subject to that university equivalent to the degree credited university besides fulfilling the above qualification candidates must have cleared the net
master of commerce
at the UGC or CSR similarly UGC set net who are have been awarded PhD degree in the accordance with the University Grant Commission PhD regulations their amendment time to time as the case may be exempted from now that you have in a net
net
PhD ಬೇಡ ರೀ ಎಲ್ಲ PhD
net ಇದ್ರೆ ಸಾಕು ಅವರು PhD ಬೇಕು ಅಂತಾರೆ
ಅಲ್ಲ ಶಾರ್ಟ್ ಲಿಸ್ಟಿಂಗ್ ಬೇಡ್ರಿ ವೆದರ್ ಈಸ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಫೈಲಿಂಗ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ದಟ್ ಇಸ್ ದಟ್ ರೀ ಅವಾಗ ಅವರಿಗೆ ಮಾರ್ಕ್ಸ್ ಕಡಿಮೆ ಆಗ್ಬೋದು ಅದು ಬೇರೆ ಅವ್ರು ಯಾವ ಸ್ಟೇಜಿಗೆ ಬರ್ತಾರೆ ಬಟ್ ಈಸ್ ಕ್ವಾಲಿಫೈಡ್ ಟು ಬಿ yes
then lordship that's the marks
yes
110 your lordship can the modified government order my lord at page 175
yes
but here but earlier your lordships my lord page 175 please come to my lord item number 3 PhD
yes
earlier it was my lord the 25 now reduced to 15 in the
yes.
modified
no
list.
that he has argued in that first
reduced to 15
yes
and thereafter my lord the other subjects and then your lordship may go to my lord the next page 176
yes
in that your lordship will find my lord item number D domain knowledge 10 and communication skill 10
yes
where these two subjects my lord the government has got my lord to accommodate 20 marks
yes
this is not my lord is not forthcoming from the UGC regulations
yes
these two subjects
yes
what is the criteria my lord to allot 10 marks for domain knowledge and communication skill
yes
there my lord we will lose the opportunity of my lord selection and as well as my lord shortlisting
no this will not come to the shortlisting that's what that you are confusing this is for interview see communication skill will be absorbed and we are conducting an interview the purpose of conducting an interview to see that how you have a communication skill major interview for that interview ಅಲ್ಲಿ ನಿಮಗೆ ಮೆರಿಟ್ ಮೇಲೆ ಕ್ವಶನ್ ಕೇಳೋದು ಅಲ್ಲ ಕರೆಕ್ಟ್ ಅಲ್ಲ ಮೆರಿಟ್ ಮೇಲೆ ರಿಟರ್ನ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲ ಇಂಟರ್ವ್ಯೂ ಅಲ್ಲಿ ಕಮ್ಯುನಿಕೇಶನ್ ಸ್ಕಿಲ್ how you are facing that situation and all is that criteria actually
at any rate your lordship they cannot increase from 100 to 110 your lordship
yes
my submission
yes
they have to work out only my lord all these categories within the 100 marks prescribed by the UGC
yes
they cannot exceed from 100 to 110
yes
this is my submission your lordship
yes
in the other case where my learned friend was arguing he has completed my lord my learned friend says he has not completed my lord PhD he has completed net that is the
yes
in both the cases in my case my lord
said you are not completed PhD
in these two cases my lord the interview was not held my information is my lord if the honorable court directs them to consider, will consider ಅಂತ ಹೇಳ್ತಾ
ನೀವೇ
ಇದ್ದಾರೆ.
ಇಲ್ಲಿ ಬಂದು ಸ್ಟೇ ತಗೊಂಡಿರೋದ್ರಿಂದ ಅವ್ರು ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ,
ಅದೇ,
otherwise ಅವ್ರು
ಅದರಿಂದ.
ಮಾಡ್ತಾ ಇದ್ರು.
ಅಲ್ಲ, that my lord, what my London friends have been, my lord, they are informing, and my clients also, last minute the direction ಕೊಟ್ರೆ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಂತೆ.
ಅಲ್ಲ, ನೀವ್ ಹೇಳಿದ್ರೆ ನಿಮ್ ಕೇಸ್
apart from that,
if you want that, I will dispose of saying that, consider in terms of that. If you are challenging that, then we'll see that result what.
Because we are.
Yes. Yes. Yes, Mr.
Could I add one recent view of the honorable decisions on the Supreme Court, my lords? May I pass on?
Yes.
Mandip Singh 2025. ಒಂದು ಕಾಪಿ ಎಷ್ಟಿದೆ ಕೊಡಿ ಅವರಿಗೆ. Whether, my lord, any such rules can be made, any rule can be made by the state, my lords, when there is a my lord, para 4, my lord, in this case. Para 4, before the learned single judge, the division bench as well as before this court, appellants have been consistent in the submission that the recruit process was shared in more than one count. Most importantly, the recruitment was made in violation of UGC regulation 2010 so and so, which were adopted with the state of Punjab on so and so, which mandated an entirely different criteria and procedure for recruitment. Further, the election to those posts ought to have been made to the commission as admittedly as these posts were within the purview of the commission under so and so and so. Entire process is arbitrary, etc. Then, my lord, on this point, the discussion by the and the reasoning of the honorable Supreme Court, my lords. Para 34, please, my lords. I may beg to read from para 33, please. Para 33.
Yes.
Let us also understand the scheme of UGC regulations.
Yes.
Entry 66 of list 1 of schedule 7 of the Constitution empowers union to make law relating to coordination and determination of standards in institutions for higher education, research and scientific and technical institutions. Under the entry, Parliament had enacted UGC Act 1950 setting up an expert body named UGC for the purpose of the act, which is clear from the preamble. An act to make provision for the coordination and determination of standards in universities for that purpose established so and so. Under provision UGC Act, UGC frames regulations from time to setting out qualification standards for teaching and non-teaching staff. Under section 26(1)(e) and (g), the UGC minimum qualification appointment of teachers and staff so and colleges measures regulations 2010 were framed. These regulations sets the minimum eligibility criterion for the appointment of various posts, including assistant teachers and librarians. A method of selection to these posts is also provided in the 2010 regulation, which has not been followed in the present case. To this, private responsible state have taken the stand. These regulations are directory in nature. Non-compliance these would not vitiate the recruitment.
Yeah.
Then, my lord, the decisions between the decisions relate both the sides, etc. Then kindly see, my lord, the para 38.
Yes.
Now, Karnataka has also adopted it. There is no doubt on that. Karnataka. Para 38 means.
Yes.
The distinction here is that in case of adoption by incorporation, the subsequent amendment or repeal of the incorporated statute will be of no consequence on the incorporation. The adoption then becomes frozen at the time when the incorporation is made. But the question whether a provision of law is adopted by reference or incorporation also depends on the language of this other statute or which provision is made. It may also depend upon the conduct of the state and how it has been recognized and accepted the state. The 18 UGC regulation may have repealed 2010 UGC regulations, but still they were being considered and recognized in the state of Punjab for all purposes, even after the repeal. We have already referred the above order dates where the state government has adopted the 10 regulations. Reasons assigned by the state government doing so. I'm reading this because even in the changed regulation procedures they wanted, they refer to the UGC regulations. Reference number 1 to 3, their UGC regulations are found. After saying this, my lords, just kindly see, my lord, how this is done. Para 39.
Yes.
The selection percentage ಎಷ್ಟು ಅಂತ ಕೆಳಗಡೆ weightage selection committee weightage 100 ಎಷ್ಟು ಇರಬೇಕು ಅಂತ. Next 40 41.
Yes.
41 again how they have done it, my lords. Then now kindly see, my lords, para 42. In a more recent division of a division bench of this court, para 42 last line.
Yes.
In Gambhirdan versus Gambhirdan K. Gandhi 2022, it is held that UGC regulations have a mandatory character and are binding on all universities, state or central, that have opted to receive the financial assistance of the UGC under the scheme dated so and so,
Yes.
etc. In that case, what weighed in the mind of the division bench of this court was the fact that the concerned university had availed the above mentioned UGC scheme, and as part of the same, it agreed to adhere to UGC regulations so and so.
Yes.
As the university was bound to follow UGC regulations for the purpose of appointment of so and so.
Yes.
Then, my lords, kindly permit me to read 44, para 44.
Yes.
UGC regulations are made under the UGC Act, which is enacted by the Parliament under entry 66 of list 1 of the Schedule 7, whereas state governments exercise powers under entry 25 of the list 3 of Schedule 7 to make laws relating to education. It is to be noted, entry 25 of list 3 is subject to entry 66 of list 1. Hence, laws including the subordinate legislation are in the present case made in article entry 66 of the union list would prevail. Last line, my lords. Would prevail over any law made under so and so of the concurrent list.
Yes.
Para 46. That UGC regulations would be binding.
Yes.
Now, my lord, the question is, can the state say, no, there is some, we want to answer some other situation, etc. I have respect to submit, there is no end to this. Finding a vacuum and saying, there is a vacuum, therefore we are exercising. That cannot be done. When UGC is a complete code in itself, how it should be appointed, that cannot be tinkered with. And kindly see how it is being done. Once advertisement issued, the process already starts, then they want to have a change. Your lordship may kindly see in the malified excise point also your lordship may kindly consider. The situation is some persons would approach them and say, you more marks to this area. Any change in the criterion, my lord, of marks would imbalance it, would change it. The very purpose is something else. And they go on changing it every time so that a particular candidate can be accommodated. Particular candidates will go out. Any change in marks of 1 or 2 would also change. So they cannot come out with any such regulation. They cannot say, now you follow this. They have no freedom at all. That the mandate is the UGC regulation that has to be followed. They cannot change it, or they cannot incorporate some other regulation, say, no, we are answering a different situation. Entire selection has to be based on the UGC.
Yes.
And of course, in the present case, of course, another reason also, my lord, as all of us have in unison put it before my lord,
yes,
that
yes,
we don't admit that the state has any power. Even otherwise, state cannot. Once the process has started, they cannot. Therefore, the entire process is illegal, and the process has to start, my lords, from the initial stage, following completely the UGC regulation. If they have any doubt as to how to follow it, any vacuum, if they say there is a vacuum, according to us, there is no vacuum. Freedom is given to the committee to do it in accordance with this. That has not been followed, my lords. Therefore, my lords, and my one more submission that was made is that about having already undergone service of 13 years, my lords, whether it can be done. As far as the Honorable Writ Court is concerned, these procedural shackles will never keep the Honorable Court, my lords, from doing complete justice. Here is a case where what we say is, we have completed these many years of service, my lords, we cannot be thrown out.
First matter.
First matter, my lords. And alternatively, we say, if at all your lordship is not pleased to, my lords, apply what we say, my lords, is the principle, my lords, or your lordship is told that we are not coming within that bracket, then we are praying for this. So final prayer is that we should be in the post. And this sort, the Honorable Supreme Court said, my lords, the continuing conversion, that too in the legal establishment, my lords, continuing for decades together. Then they say, no, we are removing you. So they have removed.
Yes.
They have removed the first case after this, my lords.
Yes.
They removed her. Therefore, we have also, my lords, the prime of our youth, our life has been there. She has abruptly been now removed. We have sought the prayer, my lords, for reinstatement with all the back wages also, my lords, in the first case.
How many is there in first case?
Pardon me?
One petitioner.
One case. One
Yes.
case.
Yes.
I'm most grateful. Well grateful.
If I may just
These,
submit
sorry,
one.
these decisions are in addition to the decisions which you already submitted. Same principles are there.
Your Lordship, if I may submit just on the decisions, just a distinction, just to bring to your Lordship's notice what is the facts that is divergent from what my learned friend had submitted. My learned, I appear in 43 and 43.3. I appear for the management in this. Just with regard to the citation that was cited today. Now, in this citation, the facts in that particular citation is entirely different. That is because the Supreme
madam,
Court came down
No, that's-
heavily on, because they changed the criteria itself. They introduced a written
No,
examination.
If there is any clarification, I could have been asked. You have reply to reply will not be. If any judgment is submitted, if court wants clarification, I could have asked you. Yes.
Yes, yes, that's the only.
H. Prakash judgment and Shivananda. This is the latest judgment, Your Lordship.
Yes.
It's only I read 2 paras in that. But in this case,
Yes.
the candidates have undergone the interview also.
Hmm.
Para 53, my lord, para 53 of my lord Pratap Das.
Hmm.
Another aspect of the matter is the question as to whether any absolute right of appointment has accrued in favor of the appellant by participating in the recruitment process after completion of the recruitment rallies and when a professional merit list has been prepared, or they have legitimate expectation to be recruited, having participated in the process. If so, whether a cancellation of the recruitment would impinge upon such legitimate expectation. My lord, para 54, they have followed my lord Shivananda case.
Yes.
Which I have cited, Your Lord.
Yes.
Thereafter, in the conclusion part, from the para 60, my lord,
Yes.
from the discussion made here and in the facts of this case, the appellants have participated in the process of recruitment conducted in furtherance of the provisions of Act and PCR rules. There, my lord, they participated in the interview, and the Honorable Court held, my lord, the tinkering with the my lord UGC regulation. This
Yes. Or this is
Interim order may continue.
interim order granted. Continued until further orders. Yes. Clean markers. Yes.
Serial number 44, Balekundri, Pranav for petitioner.
Lots
connected
appearing
matter.
petitioners in 54, 44.2 and 3 millets. In this matter, millets.
The matter, I am for the petitioner.
In this case, in 44.2 and 3 millets, I am appearing for respond number 5 millets. I seek money. Inside today, I am some income.
Yes, what
Millets on last occasion also they have taken a adjournment.
I will not take.
Millets, this is the 5th or 6th time they have taken the adjournment.
No, it is not.
Millets, in this matter, millets.
You are appearing for whom?
Respond number 5 in this. In this matter, 44.2 and 44.3, Lordship. I am
Millets,
seeking
in this.
first time in this case, Lordship.
No. That's what every day I am telling that there are 5 respondents.
Please, Lord, please, Lord.
Each respondent cannot seek time for 2 weeks, Mr. Once time is granted for a respondent,
seek
everybody
Lordship
has to file.
Since minute today, I will.
No, this installment, see, there are 5. You first ask. After that, I will ask.
No.
Which is not that rule.
Other respondents are, my Lord.
You said I have not asked.
No.
That is not that. If you are not filed an
No.
objection, you can seek that.
Please, Lord.
No, this is not first time. In so many cases, I have told that this is
Please,
not the
please,
procedure.
Lord. I agree with the Lordship.
Otherwise, if the number of respondent is there, number of adjournment will also be there.
Please.
Yes, Mr. He wants time to file.
Millets, I'm opposing for the time. Millets. This is the 5th or 6th time they have taken the adjournment.
No, that who is the contesting?
No, the respond number 5, my Lord. I have appointed, my Lord, as processor.
Millets, in this matter, it's a short point. Millets.
Recruited employee minutes.
Millets, we have challenged
Representing the recruited employee minutes.
Who is an
Yes. Now I am.
short point minutes in this matter. We have challenged the appointment of the process server to the court of small causes minutes.
Yes.
In spite of the respondent number 5 scoring the least amount of marks, she has been appointed for the as a process server minutes, which is contrary to the rule 5 of the.
What is it? Who has appointed?
Let's respondent number 3 minutes. That is the chief judge minutes.
Respondent number 3.
Please minutes.
No. It is recruitment to that post of
Process server minutes.
Who has been appointed, even though he has not scored
In 44 and 44.1, my lords, respondent number 5 has been appointed, my lords.
Respondent number 5.
5, please, my lords.
Where did you,
My lords, I'll just place one short submissions for all the petitions.
what are this your main contention?
It's contrary to the rule 5, that's their appointment. That's the only ground we are urging.
What is that rule 5?
Please, my lords. Rule 5 talks about the recruitment.
Where is that rule 5 you are getting? I will
Last
produce the
occasion I
copy.
have placed the rule 5, sir.
What of the rule? Copy. Yes. What the rule 5 says?
Rule 5 talks about the recruitment to the post of drivers and process server.
Rule 5.
Page
Yes.
1285, my lords.
Yes.
1285. Rule 5(7), my lords. That is a relevant part, my lords.
Yes.
The appointing authority shall, on the basis of the marks obtained in the interview and taking into considerations the orders issued from time to time by the government relating to the reservation of the post for the scheduled castes and scheduled tribes and other backward classes, including reservation for women, prepare in the order of merit a list of candidates eligible for the appointment to the post. If the marks obtained in the interview by 2 or more candidates are equal, the order of merit in respect of such candidates shall be fixed on the basis of their age, older in age being placed. In my case, in serial number 44 and 44.1, my lords, the respondent number 5 has scored 3 marks.
In the interview.
Please, my lords. And I have scored 7 marks.
You have scored 7
7
marks.
marks.
You are not selected.
I was not selected.
Where is that?
Please.
Where did you get that?
Your lordship may kindly see the submissions, my lords. Submissions which I have placed.
No.
Yes, my lords. Please, my lords. My lords, page number 2, my lords. I have just in a tabular form.
Marks obtained 7.
Please, my lords. That is serial number 1.
Yes.
And
No, where is that respondent?
please, it is at serial number 7, my lords.
Now you are challenging that she is low. Yes, Mr.
She's
we are-
ineligible.
Interpretation, my lord, which could be done, my lord, is rule 5(2). Lordship may kindly say rule 5, Roman 2, small Roman 2.
Yes.
The married, my lord, the appointing authority shall, from among the candidates who have applied in pursuance of the notification inviting applications under class 1 for the post of process servers, prepare separate list of candidates for interview in the order of merit on the basis of percentage of total marks secured in the qualifying examination and taking into consideration the orders issued by the government relating to the reservation of posts for the scheduled caste and scheduled tribes and other backward classes, including the reservation for women, rural candidate, ex-servicemen and others in accordance with the rules in force. The number of candidates to be included in such list of eligible candidates for interview for the post of process servers shall be equal to 25 times the total number of vacancies notified selected in the order of merit.
Yes.
That my submission, my lord, is that for the purpose of preparation of the list of candidates who could be called for interview is in the, my lord, order of merit based on the percentage of marks obtained in the qualifying examination. My lord, after, my lord, calling for interview, my lord, now the process which has been adopted by the respondent, my lord, is that the marks obtained in the qualifying examination and the marks obtained in the interview, right, both are added together. Right, then, right, the selection process, right, if without reading sub-rule 2, if we read only sub-rule 7 or sub-rule 5 of rule 5, right, it would be in a situation.
That is not that intention.
Yes.
Intention is that to shortlist that qualification has been
Correct,
fixed.
Malik.
Because
Correct.
the qualification is nothing to do with the work.
Right now,
The qualification is fixed because 30, 40,000 employees will be applied.
Yes.
You take that on merit.
Correct.
To appoint only on that interview marks, you cannot consider for that qualification. What is not there in this, that he is adding that.
Let's now, what is the rationale behind grant of these marks in the interview? That is not forthcoming from the records. We cannot establish. One candidate who has secured 94%, he has been given 3 marks in the interview, and the person who has obtained 84%, he has been given 7%.
That is what the criteria to appoint. Whoever made good in that interview, he has to be selected. Qualification is only to shortlist, Mr. That is very clear. We have done it, Mr. I am in that committee for Group D. I have selected 1,000. This is the criteria. See, we have also done it. 99% marks has been obtained all from that Bagalkot and all. Person who is eligible, others district.
Other district.
They have in SSLC marks card, they have obtained only a 75-80. But they have to exclude. All top will be that Bagalkot. What to do? This is what the rule says.
If that is the
also suspected that see 99 marks has been obtained and all, how it is and all. There are in a fake marks cards and all. We have sorted out. But for the purpose of interview, this is the only. Only interview marks will be selected best candidates.
But if that is the strict interpretation of this rule, the process adopted by the recruiting authority is not correct. That is what.
Yes.
Yes. I am the selected candidate. I have filed detailed reply. I have secured 96%. Obtained 3%, 3 marks in Viva.
ಜಾಸ್ತಿ ಮಾರ್ಕ್ಸ್ ತಗೊಂಡಿರ್ತಿರಲ್ಲ ನಿಮಗೆ ಇಂಟರ್ವ್ಯೂ ಬರಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಅಷ್ಟೇ. ಜಾಸ್ತಿ ಮಾರ್ಕ್ಸ್ ತಗೊಂಡಿಲ್ದಿದ್ದರು ಈ ಕೆಲಸ ಮಾಡಕ್ಕೆ ಇನ್ನೂ ಸೂಟಬಲ್ ಇದ್ದಾರೆ. ಬಟ್ ಅವ್ರ ಮಾರ್ಕ್ಸ್ SSLC ತಗೊಂಡೇ ಇರೋದ್ರಿಂದ they will be
kindly appreciate the marks obtained by the petitioner in SSLC. He has secured only 83%.
You go other posts where that
I am already working last 2 years.
Certification is the criteria for selection. You will be that best person. Here they want that not your qualification. They want that your performance in the interview first. That is what the rule says.
Last 2 years I am already working getting salary.
That's subject to that result. You have to.
While entertaining the writ petition,
also I permitted to file objection in one more writ petition filed.
Then your service will be more than.
Pardon?
You will undertake that. You will give back all your salary. Then will be extended. Will give back all your salary, which is paid after filing the writ petition. Then you will be allowed to continue. Or will say that don't. This is what that.
The issuance of appointment letters were made subject to result of the writ petition by an interim order.
No, still if you want to extend, every month he is paying.
I am not seeking any adjournment. I am not seeking.
You have filed an objection.
I am already filed my objection.
Till here.
I will adopt it in one more writ petition filed by WP writ petition.
Happening in that morning also I disposed of that. Person who don't have any departmental inquiry has not been given a promotion for 5 years. After court direction, promotion has been given after 5 years. Then that is juniors. Then he has been asked to give only from the date of order. We said give it back from the data. No inquiry. If it is inquiry is pending, no inquiry, nothing is pending. His junior has been promoted, he has been kept under. That is happening in this institution.
Yes. Page 13 of my writ petition.
Then we'll hear, Mr.
Please. 44.1.
Yes, now
is the criteria fixed. Case number 13.
Now in all, how many cases are there?
4 minutes. 4
cases.
Yes.
44.1.
In all cases, your selected candidate has been made as a party.
Please, minutes, please.
Yes.
In my case, that is a Shaikshanika Vidyarthi. That is a SLC. What is the qualification fixed for the purpose of interview with the interview members? And in the bottom, Sandarshana.
No, our case will. Yes. No, Chandrasekhar Patil, you have how many cases?
I mean, 3 cases, man.
3 cases.
44.2 and 3 minutes.
3. Yours is the only one case.
One case.
We'll see first.
What is 44.1?
Please.
Now, first we'll hear that. What is this? In all 3 cases, is the similar points.
For a different category, melons, which candidates have been selected. In the first case,
only thing is that interview marks you have scored more, but they have given.
In 2 and 3.
both have my lord similar, same matter,
Then
their contents is my lord, they are the older than me.
that is what the rule says. Then ultimately there.
In my case, because I am older than.
No, Mr. Vivek, this is the rule as on today.
Yes,
There is no any further.
Because of my lord, the appointing authority is mistake, my lord. I have supported my lord since my lord. I have appointed my lord. I have served my lord.
You go and file in a case damages against that appointing authority if it is wrong. They will decide. The point is that you have enjoyed without you are qualified. That is what
My
that.
lord, we are, my lord, obtain my lord, marks, my lord, the genetic authority, my lord, acting, my lord, should be acted according with the, my lord.
ಎಲ್ಲರೂ ಕಾನೂನು ಪ್ರಕಾರ ಆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಮಗೆ ಕೋರ್ಟ್ ಕೇಸ್ ಯಾವ ಬರೋದಿಲ್ಲ.
Please, Lord.
But we are there is to decide.
It's not there, my lord, appointing authority mistake, my lord. I have, my lord, suffering.
No, show me any law on that point, Mr.
No, there is no sufferance as such. He has been given appointment, he is working,
You
and
should
he is
have
drawing
been thrown
salary.
out in that beginning, but you have given that entry to that institution and your work. You have an experience now. You can take
There
it
is
to
no
for
such
other
sufferance
posts.
as such.
Yes, you give that to one by one, Mr.
Please, my lords, in 44, my lords.
First matter.
Please, my lords.
Hmm.
We
When
have
that
chat-
application has been, where is that application for?
My lords,
Till I have not read the rule properly. You just you have to. In that overall situation, I said it may be that. We'll
Let's
read
see.
that rule again and what is
Please.
that actual? Yes.
my lords, in the first petition,
Yes.
page 62, my lords.
Yes.
That is the marks obtained by the respondent number 5.
Now, where is that application for interview notification?
Please, my lords, it's at
Annexure A is the notification.
B, my
Applied for
lords.
appointment to the post of processor.
Annexure B, my lords. Page 20, my lords.
Annexure,
B, page 19, my lords. That is the notification, my lords.
annexure B.
Please, my lords.
When that notification is issued?
It was issued 19/9/2022, my lords.
22 to the post of
Process server. There were 6 posts, my lords.
all process server only.
Please, my lords.
You are applied for
2A, my lords. 2A women category.
be a woman.
Please, my lords.
You are the respondent in that, Mr.
No, my lords.
I am the
You are
respondent.
respondent.
Yes,
You are also 2A woman.
yes, to him.
Yes. Yes.
And subsequently, I have been shortlisted, my lords.
2A woman ಎಷ್ಟಿದೆ?
One though.
Which is that?
One.
ಸಾಮಾನ್ಯ ವರ್ಗ. Yes, 1. 2A woman 1. Yes.
Please.
Yes. You have applied.
Please, my lords. I have applied. Application is at annexure B, my lords. Page 26, my lords.
Annexure B.
B1, my lords.
ಇದ್ರಲ್ಲಿ ಏನಾರ ಕೊಟ್ಟಿದ್ದೀರಾ ಪ್ರೊಸೆಸಿಂಗ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಯು ಹ್ಯಾವ್ ಗಿವನ್ ಎನಿ ಮೆಥಡ್ ಆಫ್ ಸೆಲೆಕ್ಷನ್ ಏನಾರ
Please, my lords, it's at
The method of selection as per Karnataka subordinate courts, ministerial and other posts.
ಇದ್ರಲ್ಲಿ ಏನ್ ಬೇರೆ ಅಡಿಷನ್ ಏನ್
No,
ಮಾಡಿ?
page 22, my lords. Qualification.
Yes. 22.
Please, my lords. In the notification itself.
Which one?
They are referring to the Karnataka subordinates codes.
Yes. ಆಯ್ಕೆ ವಿಧಾನ.
Please, my lords.
Yes. ಕ್ವಾಲಿಫಿಕೇಶನ್ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಶೈಕ್ಷಣಿಕ ವಿದ್ಯಾರ್ಹತೆ 10ನೇ ತರಗತಿ ಅಥವಾ ಸಹಸ್ರಮಾನ ಪರೀಕ್ಷೆ ತೇರ್ಗಡೆಯಾಗಿರಬೇಕು, ಕನ್ನಡ ಓದಲು ಬರಬೇಕು, ವಾಹನ ಚಾಲನೆ ಪರವಾನಗಿ ಹೊಂದಿರುವಂತೆ ಆದ್ಯತೆ ನೀಡಲಾಗಿದೆ.
21, my lords. Page 21.
Yes.
Thereafter, my lords, have been shortlisted. My lords, the shortlisted list is at page 51, my lords, annexure C1.
Page 51.
Page 51. Your lordship has got it.
Yes. ಕೊಡಿ.
My lords, in that serial number 26 and 34, my lords. 34, the petitioner is there, my lords.
Petitioner is
Serial number 34, my lords. It's at page 52, my lords.
34.
Please.
Respondent.
Respondent is at 26, my lords. Serial number 26.
Respondent is shortlisted is Yes, senior.
Please, my lords.
Yes.
Thereafter, my lords, the interview marks list is at page 62, my lords.
This is correct, Mr. Vivek, interview marks which they has produced.
Yes.
It is your
Yes,
document.
miss. These documents are furnished by us only.
Yes. 62.
Serial number 26 is respondent number 5, my lords.
3 marks. Yes.
And I am at 34, my lords.
Plus score 7 marks. Yes. Where is that appointment order issued to the?
It is at annexure A, my lords.
Yes. Now we will come to that rule.
Please.
Read. Read that rule 5 itself. Yes.
Recruitment to the post of drivers and process servers in group C and posts in group D.
Yes.
Clause 1. The appointing authority shall notify the vacancies on the notice board of the district court and all subordinate courts in the district, and also in at least 2 widely circulated regional newspapers specifying the name of the post, the conditions of eligibility, and the number of vacancies provisionally reserved in favor of scheduled caste and scheduled tribe and other backward classes, and the last date fixed for receipt of applications. Sub-rule 2, the appointing authority shall, from among the candidates who have applied in pursuance of the notification inviting application under clause 1 for the post of process server, prepare separate list of candidates for interview in the order of merit on the basis of percentage of total marks secured in the qualifying examination, and taking into consideration the order issued by the government relating to the reservation of posts for the scheduled caste, scheduled tribe, and other backward classes, including the reservation for women, rural candidates, ex-servicemen, and others in accordance with the rules in force. The number of candidates to be included in such list of eligible candidates for the interview for the post of process servers shall be equal to 25 times the total number of vacancies notified selected in the order of merit.
1:25.
Please, my lords.
Yes.
Sub rule 3. An eligibility test shall be held for the candidates who have applied for their post of drivers to ascertain their expertise or skill in driving, and the method of test may be determined by the appointing authority. Such eligibility test shall carry a maximum marks of 50. The number of candidates to be
May
included.
not be applicable for the present post.
Included in the such list of eligible.
That is only for drivers, minutes.
Please,
Most of the drivers will be equal to the 25. For
Sub
them, there is a
rule
separate
4,
one test.
the maximum marks for interview for recruitment to the post of drivers and process servers shall be 10. Such interview shall be held to ascertain the candidate's proficiency in reading, writing in Kannada, and his general knowledge in the case of process servers. And in case of drivers, personal skill, ability, aptitude, and suitability to the post.
Yes.
The appointing authority shall, from among the candidates who have applied for the post in group D in pursuance of the notification, prepare a list of candidates for interview in the order of merit as per the method stipulated in clause 2. The number of candidates included in such list for the eligible candidates for group D post shall be equal to 10 times the total number of vacancies notified in the order of merit. The maximum marks for
So 1:25.
Please, ma'am.
ಆಮೇಲೆ ಒಂದು ಎಕ್ಸಾಮ್ ಮಾಡ್ತಾರ ನಿಮಗೆ?
Only interview. It's solely based on interview.
No, appointing
That is for the drivers.
Among the candidates who have applied for the post group D in pursuance of the notification, prepare a list of candidates eligible for the interview in order of merit as per the method stipulated in that 2. The number of candidates including such list of the eligible candidate for group D post shall be equal to the 10 times of the 1:10.
That is for group D. That is for group D.
Oh, group D. This is process server. Here there is no, this clause is also not applicable.
Please, ma'am.
Yes.
The maximum marks for interview for recruitment to the post of group D shall be 10. Such interview shall be held to ascertain the ability and suitability to the post. Sub rule 7, the appointing authority shall, on the basis of the marks obtained in the interview, and taking into consideration the order issued from time to time by the government relating to the reservation of posts for the scheduled caste, scheduled tribe and other backward classes, including reservation for women, prepare in the order of merit a list of candidates eligible for appointment to the post. If the marks obtained in the interview by two or more candidates are equal, the order of merit in respect of such candidates shall be fixed on the basis of their age, older in age being placed higher in the order of merit. The number of candidates included in the list of eligible candidates shall be equal to the number of vacancies notified.
Appointing authority shall, on the basis of the marks obtained at the interview and taking into the consideration of order issued from time to time, government reservation so and so, and prepare in order of merit a list of the candidate eligible for appointment to the post. Marked obtained in the interview by two or more candidates is equal. The order of the merit so and so. On the basis of the marks obtained at that interview. Now, where is that process server out that call for an interview? See, they said the eligibility list shall be candidate who have been applied for the post of the driver. Maximum
class
marks
2
of
minutes.
the interview recruitment to the post of the driver and process server shall be.
Sub-rule 2 of Rule 5, my lord, is applicable for process server.
Yes, sub-rule 2.
Sub-rule 2 of Rule 5.
Yes, read once again.
Roman 2.
Please. The appointing authority from among the candidates who have applied in pursuance of the notification inviting applications under clause 1 for the post of process servers prepare separate list of candidates for interview in the order of merit on the basis of percentage of total marks secured in qualifying examination and taking into consideration the orders issued by the government relating to the reservation of post for the scheduled caste, scheduled tribe and other backward classes, including the reservation for women, rural candidates, ex-servicemen and others in accordance with rules in force.
Yes.
The number of candidates to be included in such list of eligible candidates for interview for the post of process server shall be equal to 25 times the total number of
This
vacancies.
process server is 1:25.
Please, Millards. In
Now
this
that
case,
you
they
come
have,
to that. Yes.
in this case, they have followed it, Millards.
Now, why that they have made it 1:25 now?
But 1:25 is
They have made it more number of that eligible candidates will become. Then you have to be given a interview. When you are giving a marks at the interview, you have to be proper in that. That is
only
what-
only one expression, my lord, I would like to stress upon. My lord, sub-rule 2,
Yes.
my lord, fourth line, my lord, sir.
Yes, you read.
That is,
If you want.
I'll read, my lord, entire rule. The appointing authority shall, from among the candidates who have applied in pursuance of the notification inviting application under class 1 for the post of process servers, prepare separate list of candidates for interview in the order of merit on the basis of the percentage of total marks secured in the qualifying examination. I'll stop here. Now kindly come to sub-rule 7 again. The appointing authority shall, on the basis of the marks obtained at the interview and taking into consideration the orders issued from time to time by the government relating to the reservation of post for the scheduled caste and scheduled tribes and other backward classes, including reservation for women. Next, my lord, this expression is important. Prepare in the order of merit a list of candidates eligible for appointment to the post.
On where your scheduled caste, scheduled by list of the candidate eligible appointment. If the marks obtained in that,
then
no, that order issue from time to time by the government related to the reservation, scheduled caste, other brackets, including the reservation for the women.
Prepare in the order of merit.
In the order of the merit.
Merit.
A list of the eligible candidate for appointment to the post. If the marks obtained in that interview.
That is, my lord, with regard to the equal marks obtained by both two candidates, then age will have to be preferred.
Yes.
But if here also, my lord, the expression used is in the order of merit. Whether this order of merit means the marks obtained only in the interview or the marks obtained in the qualifying examination, my lord, is it is open.
That would be the case.
Yes.
If the person who has obtained
then
equal marks in the interview has to be selected on the age brother lavaga. If you read this, it would not be that.
The first part of the, my lord, the rule.
The entire, this is only for the interview. If you say this part, if person is obtained that interview equal, you have to be select one among them ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ ಅವ್ರು. ಯಾಕೆ ಅಂತಂದ್ರೆ ಆ ಮೆರಿಟ್ ಇದರಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟು ಬಂದ್ರೆ ಇಲ್ಲಿ ಇಂಟರ್ವ್ಯೂ ಅಂತಾನೆ
ಇಂಟರ್ವ್ಯೂ ಅಂತ ಸ್ಪೆಸಿಫೈ.
that means to say that it is only for the interview. ಇದು ಕೊಡಿ ನಮ್ದು ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಗ್ರೂಪ್ ಡಿ ಎಂಪ್ಲಾಯೀಸ್ ಚೇಂಬರ್ ಇರಬೇಕು. That rule book, it is there. Yes.
My lords, may I take your lordship attention to one provision, my lords. That is sub rule 4, rule 4, my lords. Sub rule H, my lords.
Rule 4, sub rule H.
This is for the direct recruitment for the appointment of typists and stenographers, my lords.
Yes.
Sub clause H, my lords.
H, yes.
A selection list in each category of post shall be prepared on the basis of the aggregate of the percentage of total marks secured in the qualifying examination.
That specific ಆಗಿ ಹೇಳ್ತಾರೆ.
Please, my lords.
Qualifying examination and you read entire rules.
This provision is missing in sub.
Even in that group D employees appointed to the High Court also. Please, we are taking only interview.
Interview.
So that's the mask card. Okay, you will see that rules also. Yes. What is that second matter?
Please, my lords.
In second matter, in same.
Lords, same category they have challenged, and she being the elder.
Who being the elder?
In the second matter.
No, second matter ಅವ್ರದ್ದು different ಬಿಡಿ. ನಿಮ್ದು in ಎರಡನೇ matter ನಿಮ್ದು
44.2 my lords.
44.2
that we have challenged the appointment under GM rural category, my lords.
You are applied for GM rural.
Please, my lords.
Who is that selected candidate? You are appearing, Mr.
Please, madam, this is.
Yes, you are also applied for GM rural.
Please.
Yes. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಮಾರ್ಕ್ಸ್?
My lords, both have secured 7, my lords.
ಇಬ್ರು 7.
Please.
7 in that interview. Yes. What has happened?
As per sub rule 7, my lords.
You are that.
The older has to be selected.
And then ಇದ್ರಲ್ಲಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಮತ್ತೆ? Again that marks, you have secured more marks in that.
Please, SLC.
Yes. What about the third matter?
The third also same, my lords. I have applied for under SC women category, my lords.
SC
women category.
Who is other side contesting? ಅದರಲ್ಲೂ ನೀವೇನಾ ಮಿಸ್ಟರ್ 3 ಅಲ್ಲೂ ನೀವೇ?
Both have secured 8 marks, my lords, in the interview. I being the older.
At least if they are equal, who have scored more in that ಅಂತ ಮಾಡಿದ್ರು ಆಗಿರೋದು ಅವರು ಬಂದಿರೋದು. ಇಲ್ಲಿ ಏಜ್ ಇಸ್ ದ ಕ್ರೈಟೀರಿಯಾ ಅಂತ ಅಂದ್ರೆ you have excluded their SSLC marks.
SSLC marks
only for the purpose
only for
of
the first interview, only for shortlisting for interview.
ಈಗ ಸೆಲೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ಕೊಟ್ಟಲ್ಲ
ಅಂತ ಹೇಳಿ.
ಕಲರ್ ವೈಟ್ ಟೋಟಲ್ ಆಫ್ ಮೆಂಬರ್ಸ್ ಇದೆ ಅವರ್ ಸಿಸ್ಟಮ್ ರೂಲ್ಸ್ ಅಂದ್ರೆ ಮಾಡಿರೋ ಕ್ಯಾಟಗರಿ ಬೇರೆ ವರ್ಷಗಳು ಕ್ಯಾಟಗರಿ ಮಾಡಿರೋದು 2 ಅಲ್ಲ 7% 2 ಇವಳು 2N ಇಲ್ಲಿದೆ 2N ಸ್ವರಾಜ ಕುರಿ ಹೌದು 2A ವುಮನ್ ಹೌದು 2A ವುಮನ್ ಇವಳು 2A ವುಮನ್ ಅದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಇದರಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ 18798 ಸೊ
Same appointing authority shall on the basis of the aggregate marks obtained in that interview. Here also that appointing authority shall among the candidate who has applied for the post briefly pursuant to the notification, list of the candidates eligible for interview on the merit as per that stipulated. Applied for in separate list of the candidate interview on the merit on the basis of the percentage of the total marks secured. Then that interview is. Yes.
The marks obtained in the interview is the basis for selection. My lord, is the thumb rule.
Yes. What is your case, Mr.
My case is that I too applied under 2A women category and I secured 7 marks. And the respond number 4 has secured 3 marks, where the appointment order has been issued.
Yes.
And by virtue of the 5 rule 7, since my date of birth is in 1998, these may find it at page 17 of my writ petition. My date of birth is 18/7/1998.
No, what is that score you have made?
My marks is 7. My lords may find it at page 30.
ಅವ್ರದ್ದು ಎಷ್ಟು?
ಅವ್ರದ್ದು 3.
ಅವ್ರನ್ನ ಸೆಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಯಾಕಾಗಿ? Why? On the basis of that SSLC.
Secured more marks.
Same thing ಅಲ್ಲ. What is the difference in your case?
But on account of which, my lord, what happens is that there is
ಆಯ್ತು ಅವರು ಅದನ್ನೇ ಕೇಳ್ತಿರ ತಾನೆ.
the resultant effect would be the petitioner in WP 29418 of 2024, she would not get. The petitioner in the connected matter, right, that is 29418 of 2024.
40?
That's 44, my lords. 44 has to be dismissed.
44.
11730 has to be allowed because of the age, the older.
No, that 44, please.
Has to be dismissed.
Okay.
Because they are younger than me. Their date of birth is in 2002, my lord.
Please, 15/7/2002, my lords.
No, that, what is your name?
My lord, my name is Nanda Vasgowda.
My lord, may I point out, my lords, there is a triangle claim for one post. One is by Nanda Vasagowda, that is WP number 11730 of 2025, petitioner. Let the other claim, my lord, is by petitioner in WP 29418 of 2024. That is Sharanamma Basavaraja Kuri.
Yes.
Let now the recruited candidate is Sudha Basalingappa Kudrimani.
Yes.
Now, my lord, based on the marks obtained in the interview and the age, let the Nanda Vasagowda would be an eligible candidate.
No, the point is that you both having a
Yes,
7/7.
yes, my lord.
Please, therefore it has to go.
I am older than.
Let's now, your lordship may have to direct the appointing authority to redo the entire thing, my lord, whole exercise based on the my lord, sub rule 5.
No, only these candidates will not disturb others who has.
Yes, yes, my lord. Only with
These candidates will set aside that appointment order of this so and so. This case will be dismissed by allowing his writ petition. This automatically it goes. Instead of following this first matter, I will take that second matters to this. Then it will be dismissed later.
Yes.
Please, Kodi. So our the 42.3 there.
11730.
let's in the first matter, that is the 29418 of 2024.
No, 43.2, 43, 44, 44.2. One is that 44.2 I will dictate. Please. It's 44.2, 44.1 and 44.3 is the same. Your case will be dismissed in the consequence of that. Please. First petition 27366 of 2025. 44 ಒಂದು ಬಿಟ್ಬಿಟ್ಟು ಆ 3 ಕೇಸನ್ನು ಕನೆಕ್ಟ್ ಮಾಡಿ.
ಏನಿಲ್ಲ ಕನ್ಸಿಡರೇಷನ್ ನೆಕ್ಸ್ಟ್ ಏನಾದ್ರು ಪ್ರೊಸೆಸ್ ಕನ್ಸಿಡರೇಷನ್ ಗೆ ಒಂದು ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೇ ತರ ಪ್ರೊಸೆಸ್ ಸರ್ವರ್ ಇದೇ ತರ ಆಗಿದೆ. ಯಾರ ಲಾಸ್ಟ್ ಬರೋದು ಅದು ಸೆಟ್ ಆಗಿದೆ ಸರ್. ಲಾಸ್ಟ್ ಪೇಜ್ 13 ಪೇಜ್ ಅಲ್ಲಿ ದಾರ 13
Respondent he is hereby quashed. It is directed that in place of the respondent, petitioner shall be appointed. Respondent 2 is directed to issue a fresh appointment order so and so women category reserved for women. Respondent number 2 is directed to issue a fresh appointment order petitioner to the post of process server under
ನಂದು ಪ್ಯಾರಾ 13 ಅಲ್ಲಿ ಅಲ್ಲ ನಮ್ದು 13 ಅಲ್ಲಿ ಪ್ಯಾರಾ 13.
This is allowed on what ground?
ಹೌದು process server ಅದನ್ನ ಕ್ಯಾಟಗರಿನ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು ಬೈಪಾಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ಸೆಟ್ ಮಾಡಿದ್ರು 13 ಅಲ್ಲಿ ನಮ್ದು. Yes, last but not the least, the Learned Counsel for the respondent number 3 has considered that this respondent 3 is also a material candidate, but he has to be accommodated anywhere else. Therefore, suitable order may be passed in this regard.
Yes. Last but not least, that Learned Counsel for the petition considered the respondent is also meritorious candidate, but he has to be elsewhere. Therefore, suitable order may be passed in this regard. In my opinion, I have to make
ಏನಾದರೂ ಕನ್ಸಿಡರೇಷನ್ ಇದೆ
to remedy if that remedy is available under the law. Remedy is available ಎಲ್ಲಿ ಬರ್ತದೆ
ಅದು ಈಗ ಅಂದ್ರೆ 15 ತಿಂಗಳು ಕೆಲಸ ಮಾಡಿದ್ರು ಏನಾಗಿದೆ ಈಗೆಲ್ಲ
ನಿಮ್ಮನ್ನ ಹೆಂಗೂ ಕಾಂಟ್ರಾಕ್ಟ್ ಮೇಲೂ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ನಮ್ಮಲ್ಲಿ ಏನೂ ಬರೋದಿಲ್ಲ. Only thing is that even there is unless rule is amended to give an weightage person is working.
The service may be considered in weight service weightage.
ಏನಕ್ಕೆ ಬರ್ತದೆ ಸರ್ವಿಸ್ weightage ರೂಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಬೇಕು.
Next recruitment
ಬರೋದಿಲ್ಲ ನೀವು 3 ಜನಕ್ಕೆ ರೂಲ್ ಎಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ. Yes.
ಇಲ್ಲ ವೇಕೆನ್ಸಿ ಇರ್ಬೇಕಲ್ಲ ಸರ್, ಫ್ರೆಶ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ವೇಕೆನ್ಸಿ ಇಲ್ಲ.
ವೇಕೆನ್ಸೀಸ್ ಇಲ್ಲ. Yes. Law permits to continue on that contract basis. It is for them to continue given a representation. May say because your experience may be taken into that. If there is any this thing.
ಕ್ಲಾರಿಫೈ ಮಾಡಿ ಸಮಯ ಫುಲ್ 5 ಮತ್ತೆ
Let us see first will yes.
ಮತ್ತೆ
In all these cases, petitioners are called in question. Appointment of the private respondent to the post of process server on the ground that appointment is contrary to Rule 5 of Karnataka subordinate post bracketly ministerial and other post recruitment rules 1982. Where is that notification?
It's at annexure B, page 20.
Page?
Page 11.
Page 20 in red.
Page 20.
Page 20.
Not 20, it starts from 19.
That's
19 my lord selected candidate list. Intimation letter.
19 is the intimation letter.
Intimation
No,
letter.
in first matter ali 29418 ali, which is that notification?
Sorry.
2948. Annexure my lord.
Annexure B,
Annexure B. Yes.
Page 19 my lord.
Third respondent has issued a notification on 19/9/2022 called application for post of process server. Pursuant to that notification, petitioner in WP 24366 of 2025 is applied under GM rural quota, please. And also private respondent is also under the same category. In WP 27549 of 2025, the petitioner applied for SC women, please. That private respondent is also applied for the same category. You have applied for which, Mr. Todor?
It's under 2A category, 2A women.
Yes, in WP 1173 of 730 of 2025, the petitioner has applied for 2A women.
Please.
That select the private respondent is also applied for 2A women. As per that rules, on the basis of that marks secured in that qualifying examination, the merit list has been prepared. The candidates who is eligible for interview as per Annexure C, as per Annexure C, first matter, Annexure C bada, by notification dated 19/9, ಅಲ್ಲ ಎಲಿಜಿಬಿಲಿಟಿ ಲಿಸ್ಟ್ ಯಾವತ್ತು ಅನೌನ್ಸ್ ಮಾಡಿದ್ರು? ಡೇಟ್ ಏನಿಲ್ವಾ?
19/9/2022.
ಅದು ನೋಟಿಫಿಕೇಶನ್ ಅವತ್ತೇ ಇದೆಯಲ್ಲ.
List of
22
19/9/2022 ಎಲಿಜಿಬಿಲಿಟಿ ಲಿಸ್ಟ್ ಆಫ್
ಅದು ಆಸ್ ಪರ್ ದಟ್ ನೋಟಿಫಿಕೇಶನ್ ಅಂತ ಹೇಳಿರೋದು. ಡೇಟ್ ಇಲ್ವಾ?
19/9 ಸೇಮ್ ಪೇಜ್ ನಂಬರ್ 51 ಫಸ್ಟ್ ಡೇಟ್ ಪಿಟಿಷನ್ 51
ಎಲ್ಲಿದೆ ಅದು?
ಅಲ್ಲ ಡೇಟ್ ಕೆಳಗಿದೆ
ಡೇಟ್ ಏನಂತಿದೆ ನೋಡಿ?
19/9/2022 ಇದು.
ವೈಡ್ ನೋಟಿಫಿಕೇಶನ್ ಡೇಟ್
ಲಿಸ್ಟ್ ಆಫ್ ಎಲಿಜಿಬಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಕಾಲಿಂಗ್ ಇಂಟರ್ವ್ಯೂ ಫಾರ್ ದಿ ಪೋಸ್ಟ್ ಆಫ್ ಪ್ರೊಸೆಸರ್ ವೈಡ್ ನೋಟಿಫಿಕೇಶನ್ ಡೇಟ್ ಆಫ್ ಇಂಟರ್ವ್ಯೂ
22 ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಕರೆದಿದ್ದೀವಿ ಅಂತ ಇಲ್ಲಿ ಸೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೂ ಡೇಟ್ ಹಾಕಿಲ್ಲ. ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಏನಾರು ಇದೆಯಾ?
ಓನ್ಲಿ ಬೈ ರೆಫರಿಂಗ್ ದಿ ನೋಟಿಫಿಕೇಶನ್ ವಾಸ್ ರೆಫರ್.
ಎಸ್, ಇಲ್ಲಿ ಯಾವ್ದೋ ಇದೆಯಲ್ಲ, ಅದೇ 61 ಅಲ್ಲಿ ಏನಿದೆಯಲ್ಲ ಕಲೆಕ್ಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಅದು.
Please, that is the interview date, Milods.
Interview date
27/9/2024.
Yes, as per they have issued an eligible candidate for interview to the post of process server on the basis of merit acquired in qualifying examination. The petitioner and the private respondents is also placed in that list prepared for an interview. After conducting an interview, the private respondent has been selected and issued an appointment order. Being agreed by the same, the petitioner is before this court. Learned counsel appearing for the petitioners has contended that as per that rules 1982, rules 5, the list has to be prepared for the list of the candidates has to be prepared for the interview on the basis of the percentage of total marks secured in the qualifying examination. Person who has scored highest marks in that interview as per that rule 5 Roman 7 has to be selected, even though petitioner has scored higher marks than that selected candidates, private candidates. The private candidate has been appointed. The same is
Let's in WP number 27366 and 27549, both have scored the same marks, my lords.
yes, as person who has scored lesser marks in the interview has been appointed. In some of the cases, even though petitioner as well as private respondent has scored equal marks in that interview, the candidate who was senior in the age has to be appointed. Contrary to that, private respondent has been appointed. Who are lesser in the age has been appointed. The same is contrary to that rule 5 Roman 7 of the Act. Therefore, he sought for allowing that writ petition. Per contra, learned counsel appearing for the respondent and also counsel appearing for that counsel appearing for the private respondent and government advocate, you are also appearing. Yes, government advocate and counsel appearing for respondent number 3 and 4 and also counsel appearing for the private respondent has contended that by combined reading of rule 5 subclass 2 and subclass 5, the selection list has to be prepared on the basis of that marks obtained in that qualifying examination as well as the interview. Since the private respondent has scored higher marks in that qualifying examination, their case has been considered. Therefore, they sought for dismissal of that writ petition. Heard the learned counsel for the parties peruse writ papers. As per that notification issued by respondent number 3 calling application to the post of process server by notification dated 19/9/2022, petitioner as well as respondent, private respondent has filed an application. The rule 5 of the rules 1982 is prescribed for method of recruitment to the post of process server. The relevant rules is 5 subclass 2 and subclass rule 5 subclass 2 and subclass 5
7
is extracted below. From the rule 5 subclass 2, it is very clear that appointing authority shall, among the candidates who has applied pursuant to the notification to the post of process server, has to prepare that list of the candidate for interview on the basis of the percentage of total marks secured in the qualifying examination. Accordingly, list has been prepared. Both the petitioner as well as private respondents has placed in that list prepared for an interview. The rule 5, rule 6, rule 7 is very clear that the appointing authority shall, on the basis of the marks obtained at the interview and taking into consideration marks obtained in that interview, has to prepare list of the candidate for eligible to be appointed for the post in the order of merit. If the persons obtain, if 2 or 3 more person, 4 candidates has obtained equal the equal marks in the interview, on the basis of their age, older in that age, being placed higher in the order of merit. Since petitioner in 44.3 secured 7 marks, the selected candidates has the private respondent has secured 3 marks.
No, man, 7 marks. Both of them have secured 7 marks.
No. 44.3.
44.1.
44.1, yes, 44.
I have secured 7 marks for us. The respondent has secured 3 marks.
No, that is what I said. 44.3. No, your is 44.1. Yes. 44.3 ಯಾರ್ದು ಅದರಲ್ಲಿ ಏನಿದೆ ಈಕ್ವಲ್ ಇದೆಯಲ್ಲ
please.
Yes. In 44.1, that is WP 11730 of 2025, the petitioner has secured 7 marks in that interview. The respondent, private respondent, has secured 3 marks. Contrary to that, rule 5 subclass 7, the private respondent has been appointed to the post of process server in view of the processor. Hence, that appointment order is liable to be quashed. Accordingly, writ petition 1173 of 2025 is allowed. So and so annexure is quashed. Annexure G is quashed. In respect of WP 27366 and 2754 of 2025. The petitioner and the selected candidates both are secured equal marks, that is 7 marks each and 8 marks each in 44.3. As per that rule 7, when they have secured in their obtained equal marks, the candidates who are older in the age has to be placed higher in the order of merit. Since petitioner in 1173 of 2025 is senior in that age. What is your date of birth?
My date of birth is
1998. 11733.
1998.
18/7/1990.
Since date of birth of the petition 18/7
1998.
1988. Aurdo? Arvind, what is that?
15/7/2002. 15/7/2002.
15/7/2002. Therefore, the petitioner has to be appointed instead of respondent, private respondent. Hence, the appointment of the private respondent, appointment order issued in favor of the private respondent annexure A, which annexure?
Annexure G
is liable to be passed in 1173. 1173 annexure G. Idralli?
Let's annexure A and A1. That's
A1, A1.
A and A1, my lords, in both the petitions.
A and A1.
Please.
Yes. In respect of these two,
Consequently, my lord, WP 29418 of 2024 is to
no,
be.
only two candidates has been challenged. Ultimately, two will be good. See, first 7-3, last is also 7-3. Then one has to be selected, one has to go now.
Please.
For WP 29418 of 2024, my lord, will have to be dismissed. Consequently.
Yes, in respect of WP number 29418 of 2024 is concerned, since petitioner in WP number 11730 of 2025 has succeeded, that writ petition has to be dismissed. Other writ petitions are allowed. Yes. Learned counsel for the private respondent has submitted that since they have worked for
more than 1.5 years
they have worked for 1.5 years
and securing more marks, qualifying examination.
ಅದು ಹೇಳಿದ್ರೆ ನಮ್ಮ ಮಾಡ್ರೆ ತಪ್ಪಾಗುತ್ತೆ, ಅದನ್ನ ಹೆಂಗೆ ಹೇಳ್ಬೇಕು?
Yes.
They may be accommodated anywhere else. Therefore, they seek for order from this court. In this aspect is concerned, the liberty is reserved to the private respondent to file an application before the competent authority to work out their remedy if such remedy is available under law. With that observation,
Lordship, may I- one submission.
There will be a direction to the concerned authority to issue a.
Yes. Yes, the respondent is directed to issue appointment order in respect of the petitioner if he is there otherwise eligible. Because you reservation or cat certificate ಎಲ್ಲ verify ಇಲ್ಲ.
Municipal mallards under 2A category.
ಅದು ಅವ್ರು verify ಮಾಡಿ then issue ಮಾಡಿ. Yes.
Lord Lordship, may kindly similar in WP 29418 of 2024, I have filed my counter.
Yes.
Lordship may observe that the same counter is adopted in other matters.
Yes, yes. Filed an objection and ಅದರಲ್ಲಿ first ಗೆ ಹೇಳ್ಬಿಡಿ. Filed an objection.
In WP 29.
Filed an memo stating that
It is
we will adopt
adopted.
same in all
Other
yes.
matters. I'll file.
ಒಂದು
File
memo
my.
ಕೊಟ್ಬಿಡಿ. ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ.
Please.
Apply.
Deeply, deeply open.
All pending applications are disposed. List ಹೋಯ್ತು ನೋಡಿ. Yes. Yes.
For petition in this case. Petitioner and Lord has challenged the issuance of charge memo in this case, Lord, on the ground that Lord, subsequent to the later developments, Lord, which happened in the department, this charge memo has to be quashed.
Why?
My Lord, the petitioner, my Lord, was working as a first grade revenue inspector in town, in city municipal council, Ramnagara, my Lord. Some 6 persons, my Lord, okay, annexure B, I'll make a mention about that. Some 6 persons, my Lord, had changed the khata of certain properties, my Lord, which were of revenue lands and other things, without, there were developments without following some procedures, which land has to be approved, plan has to be approved, all those things were not happened. Allegations were there. Those persons had changed the khata of certain properties. Lord, as there was a complaint about that, my Lord, the Director of Municipal Administration, who is the second respondent, my Lord, issued directions to the Deputy Commissioner, my Lord, to cancel the khatas which were made by those 6 persons, my Lord, and report the them. My Lord, subsequently, my Lord, a departmental inquiry was initiated against those 6 persons. And there was a direction, in the meanwhile, there was a direction to cancel those khatas. And this, one of the petitioner, my Lord, was, the petitioner was one of the person who was interested with the work of cancelling of those khatas, illegal khatas made by those people. What happened, my Lord? Subsequently, during the inquiry proceedings, my Lord, which was initiated against those 6 persons who were said to have committed the mistake, my Lord, the Director of Municipal Administration, who is the discipline authority, has passed the order, my Lord, on 26/12/2022. That is in the year 2022. Charge memo to a petition was issued in 2020. ಅವ್ರಿಗೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ? They have been exonerated from the charges. ಅವ್ರ ಖಾತಾ ಮಾಡಿರೋ ತಪ್ಪು ಅನ್ನೋದನ್ನ ಎಕ್ಸಾನರೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರದ್ದು ಚಾರ್ಜ್ ಏನು, ನಿಮ್ ಚಾರ್ಜ್ ಏನು?
ಅವ್ರ ಚಾರ್ಜ್ ಏನು ಅಂತಂದ್ರೆ, ನೀವು ಖಾತಾ ಮಾಡಿದಿರಿ, ಖಾತಾ ಮಾಡಿದ ತಪ್ಪು ಅಂತ.
ನಿಮ್ ಚಾರ್ಜ್
ನಮ್ ಚಾರ್ಜ್ ಏನು ಅಂತಂದ್ರೆ, ಅವ್ರು ಮಾಡಿದ ಖಾತಾನೆ ನೀವು ಸಂಪೂರ್ಣವಾಗಿ ರದ್ದು ಮಾಡಿಲ್ಲ ಅಂತ. ಅವ್ರು ಖಾತಾ ಮಾಡಿದ್ರಲ್ಲ, ಅದನ್ನ ರದ್ದುಪಡಿಸಕ್ಕೆ ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ರು.
ನೀವೇನ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ, ಅವ್ರೇನ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ?
ಅವರು ದೇವರಲ್ ಕೇಸ್ ವರ್ಕರ್ಸ್.
You are in the.
I was in the revenue inspector.
Why they have been exonerated?
That's one charges prove ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು exonerate ಮಾಡಿದ್ದಾರೆ. Page number, my Lord, 77.
Inquiry has been conducted, then report has been submitted.
Yes, inquiry was conducted, detailed inquiry was conducted.
Charge
ಏನಾಗಿದೆ ಅಂತ exonerate ಮಾಡಿದ್ದಾರೆ, ಯಾರು ಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Inquiry officer has said that charge is not proved.
Yes.
ನಿಮ್ದ್ರಲ್ಲಿ enquiry ಆಯ್ತಾ?
ನಂದ್ರಲ್ಲಿ enquiry ಆಗಿಲ್ಲ.
ಆಗ್ಲಿ ಬಿಡಿ, ನಿಮ್ದು not proved ಆಗಕ್ಕಿಂತ ಮುಂಚೆ.
ಅಲ್ಲ, ಹಂಗಲ್ಲ ಏನಂತಂದ್ರೆ, why should I be subjected to an inquiry?
Their inquiry has been conducted, they have been exonerated.
ಹೌದು.
We don't know what is your role and all, they have to be conducted.
My role I have mentioned here. My kindly see, my Lord.
Yes, we'll hear that.
Kindly see the charge.
Yes. Issue rule.
Like issue rule better son. Don't let them file the reply.
Yes, you file.
B group agli.
Yes.
B group agli.
Yes, B group idu.
B group agli.
Call this matter of 3 weeks. In the meantime, government advocate is directed to. What is the difference between them and all? What is his role? Why is inquiry has to be continued? You have to be explained.
Both the charges are different, my Lord. In respect of other 6, my Lord, the inquiry officer hold the charges are not true.
Yes.
But my Lord, I think we have decided with the finding of the inquiry officer, and we have issued a second show cause notice. So far, my Lord, no input order came to be issued, my Lord. There is some subsequent development in this matter, my Lord.
Yes, that we'll see. Yeah,
Yes,
all that if there there you have issued an,
Disagreement.
yes, if you are exercising the power and you have seek for a further inquiry, then that ground will goes for him.
I have to
And
ascertain
most
whether-
importantly, my lord, recent ಆಗಿ ರೂಲ್ಸ್ ಮಾಡಿದ್ರು ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಈ these revenue lands and other things not B khatas have to be issued ಅಂತ ರೂಲೇ ಮಾಡಿದ್ದಾರೆ. When that is
ನೀವು ರೂಲ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆನೆ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀನಿ, ವೆರಿ ಗುಡ್.
ನಾನ್ ಮಾಡಿಲ್ಲ, ರೂಲ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಅವ್ರು ಇಶ್ಯೂ ಮಾಡಿದ್ರು.
I have to ascertain
ನಾನು
whether
ರದ್ದು ಮಾಡ್ಬೇಕು ಅಂತ when once the my lord the
See whether that person who has given, is it in a major role or your role to see that you are an higher officer?
I was not higher officer. My work was given to cancel
see that.
those illegal khatas made by them, master.
Yes, we will see that. Yes.
Please.
Yes, Santosh Sechan. Yes, none appears. Who is this
My lord,
member?
I'm for the petitioner. My lord, I'm for the petitioner in this case, Your Honor.
Yes, what is this, mister?
My lord, actually, the respondent has served the statement of objection yesterday. So I seek 2 weeks time.
It was
2 weeks time for the.
So once again, I served it. my lord.
What is
Yes,
this
Your Honor.
matter?
Yes, my lord.
There is a challenge to the rule, my lord, recruitment rule. My lord, I just state what is their case. Kindly take, my lord, annexure R2. My lord, first, my lord, they are all second division clerk working in the district judiciary. But kindly take annexure R2, that is the recruitment rule.
Yes.
Notification dated 16/3/2021.
Yes.
My lord, in that, my lord, kindly come to page 23, internal page 5.
16/3/2021.
Yes, my lord, that is the rules, main rule.
Rule for ministerial and recruitment amendment.
Yes.
15.
My lord, in that, my lord, kindly come to page 23. I'll just explain what is their grievance.
Yes.
Page 23 ಅಲ್ಲಿ serial number 7.
Serial number 7, first division.
First division assistant. Normally, as I submitted, they are all second division clerk. Lord, kindly come to column number 4. 40% by direct recruitment in accordance with Karnataka civil service recruitment to ministerial post 1978. Then next is important. 2 is important. 60% by promotion from the cadres of second division assistant, typist and typist copist on the basis of combined seniority. Now their grievance is this typist and typist copist should not be considered, and only second division assistant should be considered for the promotion to the cadre.
Yakante, what is their right to seek that only?
That according to me, it is not.
Yes,
they have to
mister.
substantiate that. How
There is no any stay in that.
there is no.
Yes, at the request of counsel for the petitioner. Leave
My
this
lord,
matter. 2 weeks.
yes, my lord.
Yes.
Yes, my lord.
Yes, correct.
A date may be given, my lord.
Yes, 25th. Yes.
Pacho.
My lords, I'm sorry for mentioning, my lords. That's serial number 49, my lords. I appear in the connected matter, my lords.
Who has taken time? No, that respondent has taken a time to file objection.
That's my seek for one date, my lords, because there are 81 years of age, my lords.
Date has given 25th. Yes.
Okay, please, my lords.
Lordship, for the petitioner, Lordship, this is also against the Karnataka Legislative Assembly Secretariat. They are not admitting that what they have done is wrong, but they are again counting, fighting this case on the ground of delay and laches. What has happened, my lord, 2022?
Dismissed by this.
Same matter.
My lord, but I did some research, man. I found some judgment of the Supreme Court.
Yes.
On the ground of delay and laches, tribunal had dismissed.
Now that you have to cite before the division bench. I can't say my earlier order 2 days back is wrong, now it is right. Please, I have to
In
follow.
all these cases, the reason why these cases are coming before my lords is that the candidates have genuinely.
Why it is not connected?
With which matter?
No, this is also similar to that.
A different appointment. That is computer operator. This is Dalayat.
This is different.
It's a different appointment. Post
Circular
different.
is same way.
What has happened is, my lords.
No, that division bench has been dismissed on the delay in that other matter.
No, my lords, one matter, no, none of them have been, the matter which they have referred to, I was not given a copy when they were arguing the other matter. In fact, that matter I'm arguing before division bench, it is on the 27th. Division bench, pleadings are complete in that matter, it will be heard on 27th. In these matters, my lords, my only contention is the reason why these matters are coming before my lords is because candidates are not kept informed about their candidature.
I will hear that. When do you want?
Any date, my lords, after.
Yes, leave this matter after 2 weeks. Yes. Yes. Yes.
Your Lordship.
None.
I am
Yes,
for
Mr.
respondent number
Which matter, Mr.?
50 and 50.1, my lord. Connected matters, my lord. Respondent number 11 and 12.
No, that is urgent, Mr. 2 weeks. Yes.
Much obliged.
Yes, 51.
My lords, in the start, we have filed a statement of objections. Seniors engaged in other court, my lords.
Lord, I appear for petitioner.
We'll argue
Lord,
the
I appear
matter.
for petitioner.
Senior is.
He wants time.
My lord, I am
Copy is
appearing
not
for
served. But the
petitioner.
reply statement copy is not served.
My lord, this is a case where petitioner who has been working for 25 years, physically. Physical, my lord, let them give the copy. My lord, this is a case where a physical education instructor is working for 25 years in the junior college. In the same college, there was a group D person called Peon, my lord, one Mr. Gopal. In his case, my lord, he had approached this honorable court. There was a direction to regularize his services, and his services have been regularized. And in similar, I am also seeking for regularization of my services and for extension of the pay scale of the post. So far as pay scale of the post is concerned, initially I was asked to go to the government by filing an appeal. And in annexure Q, my lord, the government allowed my appeal, directed the payment of pay scale on par with the regular post. That pay scale was not given. That order was challenged by the management before the this honorable court, my lord, and this honorable court said KPTCL is the institution, therefore appeal is not maintainable. On that technical ground, the appeal was set aside. But however, at page number 72, this court directed that I should make a representation. Page number 72, para 12, my lord. Kindly come to page number 7. Though several contentions have been urged by both the sides, in respect of the so and so, material on record will indicate the claim of the petitioner SP Kuldeep for equal pay for equal work has not been considered, much less the adjudicatum by the proceeding. Under these circumstances, in order to provide one more opportunity to the petitioner to put forth the claim for equal work, without expressing any opinion on the merits, deem it just and proper to set aside the order passed by the director of the university. It was in my favor. Unfortunately, it was my favor to give equal pay. But on the ground of jurisdiction, it was quashed and passed by the state government and directed that fresh representation should be considered, and such a representation made, it should be considered. And accordingly, I made a representation at page number 74, annexure T, seeking for equal for regularization, equal pay for equal work. ಅದನ್ನು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟು page number 80, my lord, annexure V, the KPTCL, which is the management, my lord, because this college is run by Karnataka Power Corporation Limited. They have issued an endorsement extracting Uma Devi's case. Kindly come to page number 81. Page number 81, my lord. They have extracted the judgment of the Honorable High Court in the absence of a post being an aided post. Post is there, but aided illa, government aid kottilla, post na sanction madide, because every pre-university college should have a post of physical education instructor. It's a composite junior college. Adrinda post is there, but grant government kottilla, adondu ground mele, in the absence of the post being an aided post, petitioner admittedly having been appointed on temporary basis, regulation of the corporation would provide for such appointment only for a period of 8 months. This is 25 years now. As already stated, there is no provision to continue to such a temporary employee, and it is on the realization of this aspect of the matter that the respondents sought to depute yet another teacher in place of petitioner, notwithstanding he has been.
Consider in keeping in view of the latest judgment of the Supreme Court.
Consider andre matte reject ಮಾಡ್ತಾರೆ ದಯವಿಟ್ಟು ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡಿ ಸ್ವಾಮಿ ಇದು ಕನ್ಸಿಡರ್ ಅಂದ್ರೆ ಮತ್ತೆ I have suffered.
His senior is not there, he wants time.
ಆಯ್ತು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ, ಬಟ್ ಮತ್ತೆ ಕನ್ಸಿಡರ್ ಬೇಡ. ಈಗ ಲೇಟೆಸ್ಟ್ ಜಡ್ಮೆಂಟ್ ಪ್ರಕಾರ 25 ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿ, 25 years.
Yes. Yes.
ಅಂಡ್ ಗೋಪಾಲ್ ಅಂತ ಇನ್ನೊಬ್ರು ಅದೇ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲೇ ಗ್ರೂಪ್ ಡಿ, ಈಸ್ ಎ ಗ್ರೂಪ್ ಡಿ, ನೋ ಡೌಟ್.
File it in the counter along with that. Yes.
Cell number
Keep a short
52.
date, my lord.
Yes, I agree. Yes.
Please, my lord.
52 Chandan Shrikant.
Yes.
My lord, in this case, the petitioner was appointed as Gram Sahayak, my lord,
Yes.
in the year 2017, my lord.
Yes.
And after a period of nearly 7 years, my lord,
Yes.
her appointment was challenged by some third individual, my lord.
Yes.
He was not even a candidate, my lord.
Yes.
And subsequently, in fact, there is a judgment passed by this honorable court, my lord, wherein it specifically says that where a Gram Sahayak appointment has been challenged after a period of 6 years, my lord. So the honorable court come to the conclusion that it would not be appropriate to interfere as well, my lord.
Yes. Now what has happened? Why he has challenged?
My lord, he is some third individual, my lord, who is the complainant. He is not even a candidate, my lord. He simply says that based on the compassionate appointment, this present petitioner was appointed, my lord. Whereas a regular course was conducted, my lord. Even she was interviewed and subsequently she has been selected, my lord. As per the
appointment order.
my lord, appointment order, your lordship will find that ink page number 25, annexure B, my lord.
Yes.
And even there was a permission sought from the respective villagers as well, my lord. May I read, my lord?
Yes, read.
ಶ್ರೀರಂಗಪಟ್ಟಣ ತಾಲೂಕು ಶೆಟ್ಟಹಳ್ಳಿ ಒಂದನೇ ಹೋಬಳಿ ನೆಲಮನೆ ವೃತ್ತದ ಗ್ರಾಮ ಸಹಾಯಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಶ್ರೀ ಕೆ.ಸಿ. ಶಿವಣ್ಣ ಗ್ರಾಮ ಸಹಾಯಕ ಇವರು ಉಲ್ಲೇಖ 2ರಂತೆ ಮನವಿ ಸಲ್ಲಿಸಿ ತಮ್ಮ ಅನಾರೋಗ್ಯದ ನಿಮಿತ್ತ ತಮ್ಮ ಮಗಳಾದ ಶ್ರೀಮತಿ ಕೆ.ಎಸ್. ಉಷಾರಾಣಿ ಇವರಿಗೆ ಕೆ. ಶೆಟ್ಟಿಹಳ್ಳಿನ ಹೋಬಳಿ ನೆಲಮನೆ ವೃತ್ತದ ಗ್ರಾಮ ಸಹಾಯಕರಾಗಿ ಕೆಲಸವನ್ನು ನೀಡಬೇಕೆಂದು ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿಯವರು ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಇವರ ಕುಟುಂಬದಲ್ಲಿ 3 ಜನರ ಹೆಣ್ಣು ಮಕ್ಕಳು ಇದ್ದು ಇವರ ಒಪ್ಪಿಗೆಯಂತೆ ಗ್ರಾಮ ಸಹಾಯಕ ಕೆಲಸವನ್ನು ಅವರ 2ನೇ ಮಗಳಾದ ಶ್ರೀಮತಿ ಕೆ.ಎಸ್. ಉಷಾರಾಣಿ ಅವರಿಗೆ ನೀಡಬಹುದೆಂದು ಕೆ. ಶೆಟ್ಟಹಳ್ಳಿ ಹೋಬಳಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ರವರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರದ ಆದೇಶದ ನಿರ್ದೇಶನ
ಏನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ?
ಅವ್ರ ಅಪ್ಪ ಇರಬೇಕಾದ್ರೇನೆ ಅವರು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ. When father was still alive, my lord, the compassionate appointment was granted. That is how the complaint states, my lord, narrates. But as can be seen from the appointment order, my lord, she was also interviewed, my lord. Subsequently, only based on the merit she was appointed.
ಮಗಳಾದ ಉಷಾರಾಣಿ ಅವರಿಗೆ no, it is not compassionate appointment. He's
exactly, my lord. Please, my lord, please.
Next. ಮಗಳಾದ ಉಷಾರಾಣಿ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಗ್ರಾಮದ ಸಹಾಯಕರ ಕೆಲಸ ನೀಡಬೇಕಂತ ಮನವಿ ಸಲ್ಲಿಸಿರ್ತಾರೆ. ರೂಲ್ಸ್ ಇರೋದೇ ಹಂಗೆ, ಅವ್ರ ಫ್ಯಾಮಿಲಿಯರಿಗೆ ಕೊಡ್ಬೇಕು ಅಂತ. ಅಂದ್ರೆ ಇವರು ಗ್ರಾಮ ಸೇವಕರು ಅಂದ್ರೆ ವಿಲೇಜ್ ಆಫೀಸರ್ಸ್ ಇರ್ತಾರಲ್ಲ ಅವ್ರ ಫ್ಯಾಮಿಲಿಗೆ, ವೆದರ್ ಇವರ್ ಇನ್ ವಿಲೇಜ್ ಆಫೀಸರ್.
Please, my lord, please. He has worked for nearly 40 years, my lord, as a village officer. That's what he stated, my lord.
ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಈ ಕಾರಣಕ್ಕೆ ತಹಸೀಲ್ದಾರ್ ಗ್ರಾಮ ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವ ಆದೇಶ ಕ್ರಮಬದ್ಧವಾಗಿರುವುದಿಲ್ಲ. ಅದ್ರಲ್ಲಿ ಅನೆಕ್ಸರ್ ಜಿಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ
ಇದ್ರ ಆರ್ಡರ್ ಇಂಪ್ಯೂನ್ ಆರ್ಡರ್
ಹೌದು
ಏನಂತ ಹೇಳಿದ್ರು? ಎಸ್ ಅನೆಕ್ಸರ್ ಜಿ. ಎಸ್ ಓದಿ.
ಇಲ್ಲಿ ಗ್ರಾಮ ಸಹಾಯಕ್ಕಾಗಿ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವುದಾಗಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. ಪರಿಶೀಲಿಸಲಾಗಿ ನೆಲಮನೆ ವೃತ್ತದ ಗ್ರಾಮ ಸಹಾಯಕರಾಗಿದ್ದ ಶ್ರೀ ಶಿವಣ್ಣರವರು ಜೀವಂತ ಇದ್ದಾಗ್ಯೂ ಅವರ ಮಗಳಿಗೆ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ಉದ್ಯೋಗ ನೀಡಲು ನಿಯಮದಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲ.
ಕುಡಕಲಿಕಪ್ಪ ಶ್ರೀಕಂಠ ತಾಲೂಕು ಇವರ ದೂರು ಮನವಿಯಲ್ಲಿ ಸಲ್ಲಿಸಲಾಯಿತು. ಸಹಾಯಕ
ಅದು ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಕೊಡಬೇಕು ಅಂತ
ಶ್ರೀಮತಿ ಉಮಾಶರಮಿ ಅವರು ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುತ್ತವೆಂದು ದೂರು ಸಲ್ಲಿಸಿದ್ದು ಎಂಬುವರು 40 ವರ್ಷ ಗ್ರಾಮ ಸೇವಕ ಸೇವೆ ಸಲ್ಲಿಸಿ ಆರೋಗ್ಯ ಸಮಸ್ಯೆ ಇದ್ದ ಕಾರಣ ಅವರ ಮಗಳನ್ನು ಸಹಾಯಕ ನೇಮಕ ಮಾಡಿರುವುದು ವರದಿ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. ಆಮೇಲೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಕಾರಣದಿಂದ ತಹಸೀಲ್ದಾರ್ ಅವರು ಗ್ರಾಮ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿರುವ ಆದೇಶ ಕ್ರಮಬದ್ಧವಾಗಿರುವುದಿಲ್ಲ. ಸದರಿ ಆದೇಶ ರದ್ದು ಮಾಡಬೇಕೆಂದು ಸೂಕ್ತ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿ ಸುತ್ತಲೆಯನ್ನು ಮಾನದಂಡಗಳನ್ನು ಪೂರೈಸಬೇಕೆಂದು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. ಶಿವಣ್ಣ ಜೀವತ ಇದ್ದಾಗಲೂ ಅವರ ಮಗಳಿಗೆ ಅನುಕಂಪದ ಆಧಾರ. ದಿಸ್ ಇಸ್ ನಾಟ್ ಆನ್ ಕಂಪಾಷನೇಟ್ ಗ್ರೌಂಡ್.
It is not on compassionate ground.
ಅದರ ಮೇಲೆ
ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ ಅಲ್ಲ, ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಮೆಡಿಕಲ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕೇಳಬೇಕು ಅಂತರೂ
ರೂಲ್ ಏನಿದೆ ಕೊಡಿ ಫಸ್ಟ್.
That is reflected in the copy that I have produced, my lord.
No, that gram sevakarad rule kodri.
There is no strict and fast rule with respect to appointment, my lord. Only Tahsildar has a discretion to, under the circular, to call for gram sahayaka when there is any absence of the gram sahayaka or the vacant post is created or he is internally. It's only a honorary post and they get only small handsome of salary of about 15,000 rupees. And
I think it should be only the family belongs to that grama sevaka.
No, my lord. There is a priority of about 5 things. In that prioritized was that the last
person who is Gram Sahayaka, and that family itself it will be given. Or else the family of ST, that community, if it is there, where their grandfathers and forefathers were working as a Gram Sahayaka, they will also be considered. In one case I have just read, last occasion this honorable court directed me, I have read that paper. There is circular one.
The circular is in fact reflected in the order that I have produced, my lord, order copy. Just now I produced, my lord, copy of the judgment. Page number 5, my lord, there is a circular.
Yes.
Point number 2, my lord. That itself, that circular I have already produced, my lord, as an annexure.
Yes.
Point number 2, my lord.
Instances above came to notice that government or the Tahsildar have misinterpreted that word used in the annexure A to the government order cited above, which described the method of recruitment. 16th September. Reference appointment analysis circular. The intention of the government is to restrict the scope of the.
May I read, my lord, that paragraph?
For of the families of the inferior village servants who are working in the case during the previous year. Deputy Commissioner of all these districts are therefore required to issue a necessary instruction to the Tahsildar to adopt the following procedure. In addition to that procedure mentioned in the two of GO dated. Where is that 16th September 1978 GO, Mr.
My lord, that is produced an annexure 69.
Where is that? That is that.
Your lordship will find that at ink page number 27, my lord, annexure C.
20?
Annexure C, my lord. Page number 27.
Yes, 16/9/2025, Bangalore, GO. Yes. In reference to that order issued by the government, 63, the government hereby mentioned that 80,900 post of the Grama Sevakas is here to be. The term of conditions of the appointment should be specified in that annexure. Where is that annexure?
Annexure.
No, Mr. How to appoint will be specified in that annexure to that order. That has to be produced, Mr. We'll see how it has. You see that annexure C, Mr. Raj.
Please, my lord.
This is the government order. There is this is that original order for appointment. Annexure C.
Annexure C itself, my lordship, that is some not legality. That is why, my lordship, we cancelled this appointment order.
No. See, annexure C, term and condition governing that appointment of the Grama Sheka shall be specified in annexure to this order.
But impugned order is, my lordship, not in compliance of this 1978 order.
Yen compliance illa, yen compliance.
You have taken.
No, 1978 order ನೋಡಿದ್ಮೇಲೆ ತಾನೇ ನಮಗೆ ಗೊತ್ತಾಗೋದು ಏನು ಕಂಪ್ಲೇಂಟ್ ಆಗಿಲ್ಲ ಅಂತ.
That is along with kindly, my lordship, kindly out next week statement of objection I received.
ಅದರಲ್ಲಿ ಇದನ್ನ ತರ್ಸ್ಕೊಳ್ಳಿ. ಈ 16/9/78 ಆರ್ಡರ್ ಜೊತೆಗೆ ಅನೆಕ್ಷರ್ಸ್ ಇದಾವೆ.
ಅದು ಮೆನ್ಷನ್ ಮಾಡಿದೀವಿ ನಮ್ದು.
ಅಲ್ಲ ಅದನ್ನ ತರ್ಸ್ಕೊಳ್ರಿ, ಇದನ್ನ ತರ್ಸ್ಕೊಳ್ಳಿ ಸರ್ಕ್ಯುಲರ್. ವಿಲ್ ಸಿ ವಾಟ್ ಇಸ್ ದಟ್ ಮೆಥಡ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಂಡ್ ಕಂಡೀಷನ್.
ಅದರಲ್ಲಿ ಏನು ಹೇಳ್ತಾರೆ? Helpful. As per the government order dated
term and conditions of the appointment of the Gram Sevak ಎಲ್ಲ ಇದೆಯಲ್ರಿ.
The Tahsildar of Revenue Taluk subject to general orders of the state government and deputy commissioner
method of Tahsildar of the Revenue Taluk subject to the general order of the state government and the deputy commissioner of the district may appoint.
Yes.
Temporary basis of period not exceeding 5 years, traditionally discharging the duties of the inferior village officer who has attained the age of 25 years but not attained the age of 65 years. Preference being given to the person who has a literate. What is the age of his father? Grama Sevaka shall be paid so and so duties of the Gram Sevaka. Aster iradu ಇನ್ನೇನಿಲ್ಲ.
There is no strict rule as per our instruction is also there.
ಅವರು ಫ್ಯಾಮಿಲಿ ಯಾರು ವಿಲೇಜ್ ಆಫೀಸರ್ಸ್ ಇನ್ಫೀರಿಯರ್ ವಿಲೇಜ್ ಆಫೀಸರ್ ಇರ್ತಾರೆ ಅವ್ರು ಮಾತ್ರ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.
ಇಲ್ಲ ಅವ್ರನ್ನ ಫಸ್ಟ್ ಮೈನಾರಿಟೀಸ್ thereafter their prioritize.
There is no such, Mr. Show me that.
There is a prioritized manner in that judgment circular itself. It is there, man. Eligible member of such families of the villages at page number 5 and 6, my lord, the circular is instructed. where second point, my lord, first is the selection of the Tahsildar should be confined to the members of the backward families of the inferior village officers of Talwar, Nirgunte, Terali, so and so, so and so. All the members will come in this, my lord. The second.
Village officers, sir.
ಅದು section 4 ಕೆಳಗಡೆ ಬರೋದು. Section 4 of village officer ಬರುತ್ತೆ 1961. Not this sir.
ಸಬ್ ಕ್ಲಾಸ್ 1 ನಲ್ಲಿ ಎಲ್ಲಾ ತಲವಾರಿ ನೀರ್ಗುಂಟೆ ಅವರು ಎಲ್ಲರೂ ಬರ್ತಾರೆ. ಸಬ್ ಕ್ಲಾಸ್ 2 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಫ್ಯಾಮಿಲಿ ಸರ್ವ್ಡ್ ಗೆ ಪ್ರಯಾರಿಟೈಸ್ ಆಗಿ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ ಬರುತ್ತೆ. ಲಾಸ್ಟ್ ಫ್ಯಾಮಿಲಿ ಸರ್ವ್ಡ್ ಅವ್ರ ಅಪ್ಪ ಆಗ್ಲಿ ಅವ್ರ ತಾತ ಆಗ್ಲಿ ಯಾರು ಸರ್ವಿಸ್ ಮಾಡಿದ್ರು ಅದು ಪ್ರಯಾರಿಟೈಸ್.
ಅದ್ರ ಪ್ರಕಾರ ಪಿಟಿಷನರ್ ಫಾದರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Otherwise their family members has to be given.
Yes.
What is wrong in that? They get that. Yes. Nothing wrong in that. ಅವ್ರು ಯಾರ ಕೊಟ್ಟರು DC on what basis he has issued, Mr. What is wrong in that appointment? It is not on compassionate ground. See, in his health condition, he is not there. Then next portion is advertisement ಮಾಡಿ paper publication ಅವೆಲ್ಲ ಏನಿಲ್ಲ. Tahsildar is the competent. He has given an appointment to the petitioner. What is wrong in that?
And that too interview has been conducted, my lord, and that is, and there was no objection even from the villagers as well. That has been recorded in the appointment order, my lord.
Yes, yes. That order is stayed.
No, my lord. Order is not
stayed.
stayed.
Yes.
Want to file objection because
We'll
we
stay
received
that.
the Paravit's comments.
Now somebody has to work. Let them work, Mr.
Please.
Who is there for Gram Singh? To appoint somebody, now you are making all these things. Yes. Stay of annexure. No, that is not cancelled, Mr. ರದ್ದು ಮಾಡಿ ಸೂಕ್ತ ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿ ಸುತ್ತಲೇ ಮಾನದಂಡ ನೇಮಕ ಮಾಡಲು ಸೂಚಿಸಿ.
Only communication.
Yes, stay of annexure G. Dated 7/1/2025. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದಾ?
Please, my lord. Please.
Yes. Till next date of hearing.
I'm grateful. Much obliged.
Yes.
Cell number 53, SB Mukkanappa for petitioner Shirish Krishna.
I appear for the respondent 2 and 3.
Yes.
The petitioner, my lord, is a company's secretary.
Yes.
Lord, he has challenged the rules, my lord, the objections first time it's come.
You want to file objection, Mr.
Yes, yes, my lord. I'll take instructions. It's a 2025 matter. I'll take instructions and file.
2 weeks. Yes.
Cell number 54, Satish K for petitioner, BL Sanjeev.
Suspension has been challenged, my lord.
Yes.
It has been revoked, my lord, because 6 months is over.
Revoked.
And he's been already placed, my lord.
And infructuous.
Yes, my lord.
Yes.
Becomes infectious.
Learned counsel for the respondents.
They have only filed a memo, my lord. They filed a memo with all the documents.
ಎಲ್ಲಿದೆ ಮೆಮೊ ಕೊಡಿ.
Memo on 10/2/2026.
ಮೆಮೊ before.
May I pass on?
10/2/20. Yes. Learned counsel for the petitioner has filed a memo.
No, my lord, this is as per interim order, my lord. He is revoked. On
ರಿವೋಕ್ ಆದ್ಮೇಲೆ ಒಂದ್ಸಾರಿ ಇನ್ನೇನ್ ರಿವೋಕ್ ಐತೆ ಇನ್ನೊಂದು ಒಂದ್ಸಾರಿ.
On interim orders, if he's revoked.
See, it is revoked. It's over.
Alla, if he's revoked on interim order, then my lord, it won't.
Why?
Alla, if he's revoked on interim order, my lord, then it be a problem.
ಏನ್ ಮಾಡ್ತೀರಾ ಈಗ?
Alla, ಈಗ suspension revocation ಆಗ್ಬೇಕು.
ಆಗಿದೆ. ಸಸ್ಪೆನ್ಷನ್ ಅನ್ನು ರಿವೋಕ್ ಮಾಡಿರೋದಲ್ಲ ನೀವು.
Alla, suspension is being stayed by this court.
ವಿಚಾರಣೆ ಕಾಯ್ದಿರಿಸಿ ಸೇವೆಯಿಂದ ಅಮಾನತು ಆದೇಶಿಸಲಾಯಿತು. ಮದರಿಯು ಸದರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಹೂಡಿದ್ದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಹೊರಡಿಸಿರುವ ಆದೇಶದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಅಂತಿಮ ಆದೇಶ ಇಲಾಖಾ ವಿಚಾರಣೆ ಕಾಯ್ದಿರಿಸಿ ಷರತ್ತಿಗಳು ಸದರಿ ಅಧಿಕಾರಿನ ಅಮಾನತಿಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಯಲ್ಲಿ ನಿರ್ವಹಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. Now it has completed 6 years.
6 months has already been completed,
Yes.
my lord.
Filed in a memo stating that the petitioner has already
Suspension order.
The suspension order is spent for more than 6 months. In view of that, which is that rule?
115 of.
Yes, yes, sir. तो निम्दे
Yes,
बेरे.
yes, sir.
10 rule 10.
10(5)(b).
10(5) A.
22(4).
Rule 10(5)(b).
10(5)(b). 10(5)(b) of CCA rules. That suspension order by operation of law, suspension order 5B. 5B and 11(5) ಕೊಡ್ತೀವಿ. ಏನಿದೆ? 10(5)B.
10(5)A.
Department-
CCA rules.
Yes, yes. 10(5)B illegal. You were giving some 10A. Yes. Decide whether revoke continue the suspension within a period that suspension have been revoked. As by section 10(5)B, the suspension order is deemed to have been revoked. And also, now by order dated 3/6/2025, the same has been revoked by that authority. In view of the above,
Subject
It is
to,
not revoked,
it is not
subject to
revoked.
outcome of this writ petition.
Lord,
There
this
was a
honorable
stay-
court granted interim order. Pursuant to the interim order, I have been reinstated. It is not revoked.
then what is this
Now,
merit?
my lord, after,
I'm not,
after
after
10(5)B, 10(5)B, my lord, the 6 months has been passed.
6 months elapsed, it is deemed to be revoked, I may be permitted to.
Yes, in this case, petitioner called in question suspension order dated 22/4/2025 issued by respondent number 2. Petitioner is an employee of respondent number 1. Petitioner is employee of respondent number 1 working as an first division. ಈಗ ಯಾವ್ದು ವರ್ಕ್ ಮಾಡ್ತಿದ್ರ?
Assistant Revenue Officer.
Working as an assistant revenue officer. When he was in service, the impugned suspension order has been issued by the annexure.
G.
By the
Page
annexure G
80.
on what is the date?
22/4/2025.
22/4/2025. As per, no inquiry has been initiated. So far as on today, there is no inquiry has been initiated. As per rule 10, subclass 5B, if the departmental inquiry is not commenced against the delinquent government servant within a period of 6 months from the suspension, the suspension shall be deemed to have been revoked from the date of completion of the 6 months from the date of suspension. Since 6 months is over from the date of impugned suspension order, the suspension has to be, order has to be, the suspension are deemed to be revoked, hence impugned order is liable to be quashed. Accordingly, writ petition is allowed, order dated so and so is passed. It is made clear that this order will not come in the way of the respondent to initiate departmental inquiry in accordance with law. Yes.
Please.
Yes.
Cell number 55, Vidyadhar M. Durgekar.
The last hearing, council agreed to settle the reimbursement.
Yes, who is your council? Maruti.
On Maruti.
Where is he?
He has
What is
never
that
turned up till date.
What is that settlement, Mr.?
It's about leave encashment of deceased person, my lord. It has been held up for long. Correspondence has been going because actually it is like this in that organization, they are lending money without any documentation, and before this class 3, class 4 retire, they hold their money and hold them responsible for this. So in this case, it was not proved. There was no inquiry. It was baseless, and they held up around 2.5 lakhs 5 years ago. With interest comes to around 5 lakhs, my lord. So last hearing, last week, someone else appeared and said they agreed to settle the.
The dues of the late Prakash Durkash within the interest license also amount to the 6 lakhs 1,320 as legal service.
There are plethora of Supreme Court and state coordinate bench judgments on this regard that they cannot hold this.
Where is that order of withholding your
It's there, my lord, in the annexures.
annexure?
Yeah.
Madam, you are appearing. Yes, Monday. Yes, release this matter on Monday. Yes, at the request of respondent. Yes.
Obligement.
Cell number 56, Sharat Kumar HN for petitioner, PP Rajendra Kumar.
There's an application. Application I have filed to bring the legal representative on record. The petitioner is died on 5/10/2022. 5/10/2026.
Petitioner is.
2025.
Who are the tellers?
Let the wife and the two children.
Yes, you have any objection? Yes. IA 1 of 2026 is filed for bringing LRs of deceased petitioner. Delay ಇದೆಯಾ?
ಅದಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ 16 ದಿವಸ.
There is a delay of 16 days in filing an LR application. Delay is condoned. IA 1 of 2026 is allowed. The LRs of deceased petitioner is permitted to come on record. Learned counsel for the petitioner is permitted to amend the cost title.
ಅಲ್ಲ ನನಗೆ ಅಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕಷ್ಟೇ ನಾನು amended cost title ಹಾಕ್ತೀನಿ.
Permitted to amend and also permitted to file an ಅದರಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ನೀವು ಮಾಡಿದೀವಿ ಅಂತ.
ಆಯ್ತು. But only one indulgence is covered by decisions ಕೆಟಿನ ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ ಅವ್ರು ಸತ್ತು ಹೋಗಿದ್ದಾರೆ ಪೆನ್ಷನ್ ಬೆನಿಫಿಟ್ ಏನು ಸಿಗ್ತಾ ಇಲ್ಲ.
Leave this matter on 11th.
Please.
Yes.
Cell number 57, Anjana CH for petitioner, BV Vidyulata.
Your Lordship, this matter pertains to appointment of the petitioners to the post of typist in the newly established courts. Now, Your Lordship, respondent number 2 in this matter in 2019 had issued a notification calling for applications to fill the vacancy of to the post of typist in the newly established court. Now, Your Lordship, the petitioners had applied. Interview was conducted, skill test was given. Subsequently, they were placed at serial number 20 and 21. They were selected, Your Lordship. However, out of the 24 posts, only 16 posts were filled. Now, Your Lordship, there is a vacancy in the existing court. Now, despite several follow-ups, they were informed that only when a new court is established, they can be considered. And the state government has not granted permission for the same. My specific grievance, Your Lordship, is that they have been selected 5 years ago. And there are 6 vacancies in the existing courts, Your Lordship. Now, the petitioners can be considered for the same.
Yes, Mr. Yes. ಆಯ್ತು ಇವ್ರನ್ನೇ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಏನಾಗುತ್ತೆ?
No, not the
Is there any bar? First you have to see ಅವ್ರನ್ನ ಈಗ ಹೊಸದಾಗಿ ಕರೆದು ಇನ್ನೊಬ್ರು ಮಾಡಕ್ಕಿಂತ ಇವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಕ್ಕೆ ಏನಾರ ಕಾನೂನಲ್ಲಿ ಬಾರ್ ಇದೆಯಾ?
No, Your Lordship, I have applied.
ಇವ್ರನ್ನೇ ಮಾಡ್ಕೋಬಹುದಂದ್ರೆ ಇವ್ರನ್ನೇ ಮಾಡ್ಕೊಳ್ಳಿ. ಹೊಸದಾಗ್ಲಿ ನಾಳೆದಾಗ್ಲೇನೆ ನಿಮಗೆ ವರ್ಕರ್ ಬೇಕು, ಎಲಿಜಿಬಿಲಿಟಿ ಇದೆ, ಇಂಟರ್ವ್ಯೂ ಆಗಿದೆ, ಸೆಲೆಕ್ಷನ್ ಆಗಿದೆ. ಸೇಮ್ ಪ್ರೋಸೆಸ್ ಫಾರ್ ನೀವು ಆಲ್ಸೋ. If law is not prohibited, why can't you appoint them and continue?
My Lord, I had filed for an RTI.
From last 5 years. No, they have no right. That is true. But still they have any hopes that if we are not recruiting any there, if we are recruiting somewhere there, you see that can be accommodated or not. Yes, you take it.
My Lords.
You apply ಮಾಡ್ಲಿಲ್ವಾ ಹೊಸದಕ್ಕೆ?
My Lords, no, my Lords, we have that age bar criteria as well, so we cannot reapply. However, Your Lordship, we have obtained through RTI the information.
Yes.
There are 6 direct vacancies apart from what they are mentioning, the 3 posts. There are 6 other vacancies, direct vacancies in the existing
That's
posts.
why I'm asking him whether Law permitted to accommodate or not verify. If law is not permitted, how
No,
can
your
they do
lordship,
it?
similar-
Tomorrow other person will come and challenge.
No, your lordship, in a similar case, I may be permitted to mention, in a similar case, in the case of peons, your lordship, 19 members were considered in the existing courts.
Where is that? You have produced
That's,
that.
yes, I have
You have
it.
to verify, Mr. Then there is no bar under the law. If you are considered for a peon, why can't this?
This,
Everybody on copy. Which court this is?
this is, this honorable court.
No, it's a, no, in the district court or here?
No, High Court only, your lordship.
This is appointment to
In
the
the
High Court.
Sorry, your lordship, no, that is for Mysore district courts.
That is what that I am surprised. Yes.
No, this is in the High Court. In the peons case, the memo that I have just passed on, your lordship.
What is this?
Lordship, in the second page, this was an oral order on an IA that was filed at if I can read out para 4 and 5, your lordship.
Yes.
Since the petitioners were all selected to the post of peon as per the notification dated 8/1/2019 and are awaiting orders of posting, and as the state government still has not approved establishment of new courts, the petitioner are left in a limbo and have to wait endlessly for the respondents to take any decision. In view of the fact that there are 16 posts where the petitioners could be accommodated, the respondents shall consider the case of petitioners and post them in vacant post in Mysore division, notwithstanding the eligibility criteria which is now fixed for new recruitment and notwithstanding that they were selected for appointment in new courts to be established.
No,
This
this
shall
is
be
not
considered.
High Court. This is also Mysore.
This is also Mysore. I mentioned that it was High Court order.
Court order only you can mention, madam. It is not that recruitment to the High Court. It is for Mysore only, Mr.
Mysore only.
Same. You verify, Mr.
Same courts, your lordship.
No, she is saying that other than that, six
posts
in
are
vacant.
available.
Yes, when will you get back? Yes, this matter on 16th. Yes.
Cell number 58, Nagaraj for petitioner HS Suhas.
Lords, I appear for the respondent number 1.
Yes. Yes.
Lord, I represent petitioner, Lord. The petitioner was appointed as a peon in the year 1982.
1982. Yes.
Lord, he was promoted as a SDA in the year 2006.
Yes.
Lord, he was deputed to the Mysore City Corporation.
Yes.
Where Lord, he was working as a special squad. He was heading a special squad for recovery of taxes, etc.
Yes.
Considering his honesty, Lord, he was given a car, etc. That was somehow Lord, jealous of the other officials. Lord, in fact, Annexure D may kindly for a while. Annexure D, Lord, is a commendable certificate issued to him. Annexure D, page number 56, Lord, kindly see, Lord. Appreciation letter issued by the city 56, Lord, issued commissioner 56.
That you have no instruction. That stay is subject to if there is no any appointment is made. That Gram Sevak. Yes, ಅದು stay ಮಾಡಿದ್ದು. Stay of annexure subject to that if there is no any appointment is made. After that DC order, if there is anybody's appointment is made, then
only Tahsildar is the authority who can appoint.
ಅಲ್ಲ ಆಯ್ತು ತಹಸೀಲ್ದಾರ್ ಮಾಡಿದಾರಲ್ಲ ನಿಮಗೇನು ಗೊತ್ತು ಅದಕ್ಕೋಸ್ಕರ if it is done then it will not. Yes, subject to if there is no appointment is made to that post. Yes.
Kindly annexure.
Otherwise, 2% will go and fight there. Yes. Yes.
Now, while he was working in the Mysore Mahanagara Palike,
yes,
the commissioner issued him, Lord, an appreciation letter. Page Lord 50C Annexure D.
Yes.
N Nanjun Swami, kindly see my yard line asked. Nanjun Swami, Dvitiya Darje Sahakaru, Ada New, 2004 5 Nagara, page 56.
Yes,
this is how it starts. ನಂಜುಂಡ ಸ್ವಾಮಿ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರು ಆದ ನೀವು 2004 2005 ಸಾಲಿನಲ್ಲಿ ನಗರ ಪಾಲಿಕೆಗೆ ಸೇರಿದ ಮಾರುಕಟ್ಟೆಗಳ ಮಳಿಗೆಗಳ ಬಾಡಿಗೆದಾರರಿಂದ ಬಾಕಿ ಇರುವ ಮೊತ್ತವನ್ನು ವಸೂಲು ಮಾಡುವ ತಂಡದ ಮುಖ್ಯಸ್ಥರಾಗಿ ಮುಖ್ಯಸ್ಥರಾಗಿ ದೋ ಹಿ ವಾಸ್ SDA he was appointed. ಬಹಳ ವರ್ಷಗಳಿಂದ ಇರುವ ಬಾಕಿಯನ್ನು ಬಹಳ ದಕ್ಷತೆಯಿಂದ ವಸೂಲು ಮಾಡಿರುತ್ತೀರಿ. ನಿಮ್ಮ ನಿಷ್ಠಾವಂತ ಸೇವೆಯನ್ನು ಗುರುತಿಸಿ ಈ ಪ್ರಶಂಸನಾ he was working.
Yes.
2007, my lord. My lord, one Padmanabha, my lord, claiming to be the sister, brother of one Pushpalata, my lord, filed a complaint saying that, my lord, the Pushpalata sought an application in a Vasastra certificate. There was, she has applied for it, and this petitioner has demanded 400 rupees. So saying, my lord, that allegation, my lord, a trap was laid and trap was successful, my lord, he was caught. No, my lord, in the year 2011, he was convicted and he was dismissed on the same day. Thereafter, my lord, again thereafter, my lord, government has entrusted 14A to the Lokayukta. Lokayukta conducted inquiry. Inquiry, my lord, he was found guilty, and the punishment earlier was granted, my lord, was continued. In the year 2023, my lord, he was acquitted by the dishonorable court in appeal, criminal appeal. Thereafter, my lord, he filed a submitted an application saying, my lord, the punishment of dismissal is disproportionate, shockingly disproportionate. Therefore, my lord, considering his service for more than 29 years, that can be modified, my lord, that is the only prayer. So that, my lord,
when the punishment has been imposed,
2011.
when writ petition has been filed.
No, because, my lord, in the meanwhile, conviction was there. My lord. Conviction was recently set aside. 23 conviction set aside.
No, now you are claiming only on the basis that in conviction you have set aside. Therefore,
Set aside. And 29 years, my lord, though maintaining charge, my lord, having regard to 29 years of service, my lord, that is some, he will get some pension.
No, that when that conviction has been set aside.
To 23.
No, you are that inquiry report you can challenge.
I have challenged. I have challenged.
You could have challenged when you have been imposed the
So
punishment.
long conviction is there, my lord, I cannot challenge the inquiry report. Only, my lord, I get over the conviction, my lord, I am challenging now. All the three. Punishment, punishment, as well as, my lord, the inquiry report, etc. So my submission, my lord, without even, my lord, assuming,
When
my lord,
that conviction order has been
passed conviction 2011, my lord.
So
It
when
was
that you have been acquitted.
acquitted, my lord, on the just annexer.
What is that acquittal?
Acquittal, my lord, on 17th November 2022.
By that appellate court.
No, by the Assembly court. Yes.
Yes. So, on merit or
On merit, my lord, Padmanabha, my lord, why I am saying Padmanabha? Padmanabha gave a complaint. He turned hostile. Lord, even without considering his application, his, my lord, court finds, my lord, the Pushpalata and his father, they have not examined. Therefore, demand has not been proved. That's the finding. Padmanabha, my lord, no way concerned to family, but he gives saying that, my lord, I am the brother.
No, now that law is that the departmental inquiry, witnesses in the departmental inquiry, witnesses in that,
same,
should be same, and that evidence given should be that similar, the consequence, everything, charges are similar, then it can be considered.
Same.
Yes, you
Same,
secure
Lord.
that records, Mr. Yes, Mr.
Lord,
Who is
this-
appearing?
Please, my lords, this I'm for respond number 1 board, my lords. I've passed the impugned order. Annexure A.
Yes.
My lords, this order is passed, my lords, may come to page number 34, my lords. My lords, it's passed on 17/9/2011. From
No,
then,
he has given a reason. You show me any law or the judgment saying that since he cannot challenge that, since he was convicted, whether if he is acquittal in that criminal case, in that appeal, can it be challenged? Can it be challenged later? It cannot be challenged. You place some judgment, Mr.
I will place it.
Yes. There is no bar for that 226. It is only depending upon that circumstances you have to be shown.
Please.
Yes. So place the judgment. Once he is convicted, even after that appellate court, he is acquitted also, it is immaterial. He cannot be discharged from that departmental inquiry. Then he is out. Or he is saying that he cannot be challenged later. Then also he is out. Otherwise, we will see on that.
Two things, my lord. One is, my lord, so long as conviction operates, my lord, I am not entitled for to reinstate, etc. But even otherwise, my lord, having regard to his service for 29 years, dismissal somehow, my lord, shocking. Shocks.
No, allegations are corruption.
Even otherwise, kind is Padmanabha, my lord. Padmanabha, my lord, kind.
You have to cross 2 hurdles.
Yes,
to come to that merit.
Yes.
After the 2 hurdles is crossed, then we will go to that merit in view of the Supreme Court judgment.
Yes.
What is that evidence? What is that evidence here? Charges are, what are the evidence given and all? That will come later.
That is one.
Two legal hurdles has to be crossed, then you will go to the merit of it.
One more, my lord. Considering, my lord, even otherwise, I am held liable, my lord. Then also, my lord, The punishment of dismissal shockingly is first.
No, that you can be challenged after this year.
Yes, my lord, otherwise conviction is operating. my lord.
That is what the first legal hurdles. You have to convince me with that judgment. That is what also.
Immediately after acquittal, my lord, by some court, I gave a representation. They passed the endorsement now because of the earlier.
Some judgments to convince the court. Yes. After how many years you have approached?
No, immediately after acquittal.
After convicting the dismissal from how many years you have?
I cannot challenge. So,
But it's not gone before the date.
2011, 2011.
Yes, after 15 years.
No, any date may be given, my lord.
Yes, leave this matter on 17th.
17th.
Yes, you get judgment on that point.
59 Sridharamurthy HR, Ramshita DJ.
Appear for the respondent 1 to 3, my lord. In the statement
Yes.
of objection is ready, my lord. We yet to receive the verifying affidavit from the department. I praise the 10 days time to file my statement of objection. my
Seeking for consideration of representation
For what?
for transfer from the post of junior engineer to assistant engineer.
Why?
All the
Transfer from-
applicants filed for similar transfer were considered. Without any reason, my application was not considered.
Issue mandamus taken with the respondent to consider the representative petitioner transfer to the post of assistant
engineer
with retrospective effect from the date of official memorandum issued by the respondent with all
My lord, I
Transfer
place
to
my
the post-
statement
Yes.
of objection in the
You are
matter.
in request.
There is guidelines to the transfer of junior engineer to assistant engineer.
Junior
The
engineer,
Junior engineer, deputy cell to assistant engineer.
assistant engineer.
Ah,
The
a notification was there. I have produced that annexure. Annexure D, annexure.
Yes, where is that notification? Annexure D is that is not a notification.
Earlier transfer.
ಆಯ್ತು ಲಾ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಫಸ್ಟ್.
Then that notification itself is there. Annexure E, annexure E at page number 26.
ಏನಿದೆ ಇದೇನ್ ಲಾ ಲೆಟರ್ ಎಲ್ಲಿದೆ? Yes, you file objection, madam. Yes.
Yes,
Short
madam.
Point.
Date may be fixed.
2 weeks time is granted to file objection. Leave this matter on 17th. Yes.
Cell number 60, SP Totat for petitioner, connected matter.
Appear for respondent number 2 and 3 in this case.
So I'm for the petitioner, Manoj. That's I filed an application seeking for direction, my lords. They are the contract employees, my lords. All these 4 are the contract employees. My lords, one application I filed for seeking for a direction to pay the salary, my lords. From May 2024, they have not paid my salary, my lords. Because I'm requesting them to pay it from the account of the treasury of the respondent number 3, my lords, because all these years from 2014, from the date I was appointed on contract, my lords, they were paying from their account, my lords. Now the respondent number 3, my lords.
You are appearing for whom, mister?
I appear for respondent number 2 and 3, my lords. My senior is on VC, my lords.
My lords, appearing for respondent number 2 and 3, my lords. The direction that they are seeking is, my lords, to release of salary, my lords, from a particular source. In fact, we have repeatedly given an endorsement and even orally instructed them that since you are on outsource, payments will be directly made from the outsource agency. In fact, we have dispersed the payments to the outsource agency. They refuse to take the amounts from the outsource agency.
Where is
in
your
view of this,
appointment order?
Lords, my annexure A, my lords.
Yes.
Annexure A, page 18, my lords. My lords, that is at 1/7/2014.
Yes.
H. Nagendrappa bin so and so. ನಿಗಮದಲ್ಲಿ ಖಾಲಿ ಇರುವ ತಾಲೂಕು ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳ ಹುದ್ದೆಗೆ ಸಂಪೂರ್ಣ ತಾತ್ಕಾಲಿಕವಾಗಿ 3 ತಿಂಗಳ ಅವಧಿಗೆ ಅಥವಾ ಖಾಲಿ ಇರುವ ತಾಲೂಕು ಅಭಿವೃದ್ಧಿ ಹುದ್ದೆಗಳನ್ನು ನೇರ ನೇಮಕಾತಿ ನಿಯೋಜನೆ ಮೂಲಕ ಭರ್ತಿ ಮಾಡುವವರೆಗೆ ಇವುಗಳಲ್ಲಿ ಯಾವುದು ಮೊದಲು ಅಲ್ಲಿವರೆಗೆ ಮಾಯದ ಕ್ರೋಢೀಕೃತ ವೇತನ ಸಂಭಾವನೆ ರೂಪದಂತೆ ನೇಮಕಾತಿ ಮಾಡಿ ಅವರುಗಳನ್ನು ಅನುಕ್ರಮವಾಗಿ ದಾವಣಗೆರೆ ಜಿಲ್ಲಾ ಕಚೇರಿ ಮತ್ತು ತುಮಕೂರು ಜಿಲ್ಲಾ ಕಚೇರಿಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಲು ನಿಯೋಜಿಸಲಾಗಿರುತ್ತದೆ.
ನೀವೇ ಕೊಟ್ಟಿದ್ದೀರಲ್ರಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್?
my lords, the appointment is not as per the catering and recruitment rules, my lords. In fact, the petition.
Permanent employee ಅಂತ ಕೇಳ್ತಿಲ್ಲ. They are seeking that temporary employee only.
My lords, in fact, the prayer in the main petition.
They are taking that, pay that salary. That's all.
My lords, we're willing to pay through outsource agency. We've in fact dispersed the amounts through outsource agency, my lords. They refuse to take
He
it
is
through.
not appointed. He is not appointed through outsourcers. You have appointed.
My lords, indeed, my
Who
lords,
asked you to pay
subsequently.
that salary to the
My lords, initially that error has been made, my lords, by the predecessor officer, my lords. Subsequently now, the petition and challenge is in fact to seek for regularization, my lords. Government has passed an order saying that they cannot be regularized. In view of so many financial implications, my lords, there was a payment that was supposed to be made through outsource agencies. That correspondence has been given to the petitioners also, my lords.
No, by annexure A, you have admittedly you have appointed.
Yeah,
When
my
you have
lords,
relieved petitioner from your service.
My lords,
After relieving only, he can be through that outsources.
my lords, there is a direct attachment, contractual attachment to the outsource agency, my lords. All the
No,
payments
Mr.
have been routed through because see, they're not direct employees, my lords. If they were direct employees,
No, you have issued an appointment order,
Indeed,
appointed
my
him
lords.
for 15,000. When you have terminated him or relieved him from service.
my lords, there is no per se relieving order, my lords. There is, we'll take instructions on relieving, my lords. If there is any document to show that they've been relieved and subsequently.
What time they have paid us?
My lords, till May 2020, from May 2024, they has to pay the salary, my lords.
No,
Now
from-
they're saying that we have given you to outsourcing. But my lords, my turn to Annex J, page 54 of my writ petition, they themselves admit
No,
that.
How you are you any connection with that outsources?
No, my lords, I have not received anything.
Our
my lords.
outsources, ಅವ್ರು ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಇವ್ರ ಹೆಂಗ್ರಿ ಅವ್ರ ಹತ್ರ ಹೋಗಿ
ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರಿಗೆ there is a correspondence in our objections also we state to discharge financial obligation, my lords, agency has been appointed, my lords, because in only if you are a government employee, my lords, it can be released from the treasury. These people are not directly attached to the government also, my lords. They're outsourced, they're temporary appointment. They themselves accept.
No, you have issued annexure A.
My lords,
if it is wrong, you can issue an order to relieve them from service. Till then, he is entitled for that salary.
My lords, if I may, my lords, kindly have it tomorrow or day after, my lords. I'll seek instructions whether they've been relieved and subsequent appointment has been.
From the last 4 occasions, because salary has not been paid from past 20 months, my lords. My lords, may kindly turn to Annex Jur C,
No,
their own.
We'll say recover from that agency and pay it to you.
Please,
that's all that.
My lords,
If it is there, you
kindly have it
record from
tomorrow,
the
my lords. I'll seek instructions on whether they've been relieved or not, my lords. With
by
respect to that.
fifth.
Obliged,
If they
my
are
lords.
paid their salary to that agency, you record from the agency and paid them.
Now they
then
say
you
that-
relieve him from the service, then it's a different.
My lords, I'll seek instructions on that, my lords.
Yes.
Cell number 61, Irfan
Interim order may be extended in all the 4 matters, my lords.
Extended till next date of hearing.
Okay.
Cell number 61, Irfan.
Lordship, appearing for the petitioner in this matter. Lordship, the KPT shall issued a movement order. Subsequently to that, your Lordship, BESCOM has accepted it and issued a consequential movement order. And abruptly, unilaterally withholded the same movement order, your Lordship.
That similar matter
Yes,
which we
your
are
Lordship.
argued on that day.
Yes, your Lordship.
that
The
is
submission
different.
may be considered, your Lordship.
No, ಅದ್ರಲ್ಲಿ ಯಾರೋ ಬೇರೆ ಅಪೇರ್ ಆಗಿರ್ಲಿ ಇವ್ರೇನ
ಅಲ್ಲ ನಾನು ಅಪಿಯರ್ I only appear for KPTCL, my lord.
Yes, sir.
That I'm not yet filed Vakala. BESCOM, somebody else
BESCOM has
appeared.
made a submission.
No, now that there is a division bench judgment.
Your Lordship, kindly come to the page number
Given
34, your
that
Lordship.
movement order is also is a
Yes.
transfer.
Yes, your Lordship.
Yes.
Your Lordship,
Yella,
kindly come
mane
to the
kotiದ್ರು
page
yella.
number 34, your Lordship.
Yes, where is your opponent? Yes, now you give that details. Yes.
Page number 34, your Lordship. Suchane.
Page number?
Page number 34, your Lordship.
Yes.
Suchane. This is the movement order which issued by the competent cadre controlling authority, your Lordship.
When?
On 27/6/2025, your Lordship.
Annexure?
Annexure C, your Lordship. Page number 29.
29.
Page number 29, Annexure C.
Yes.
Relevant page is page number 33, your Lordship. At the bottom,
33 na 30 na?
33, or double 3, your Lordship. More.
ಏನಿದೆ 33?
ಸೂಚನೆ ಈ ಮೇಲ್ಕಂಡ ಆದೇಶದಲ್ಲಿ ಚಲನವಲನ ಮಾಡಲಾದ ಸ್ಥಳಗಳಿಗೆ ವಿದ್ಯುತ್ ಸರಬರಾಜು ಕಂಪನಿಗಳಲ್ಲಿ ಆಂತರಿಕ ವರ್ಗಾವಣೆ ಆದೇಶ ಹೊರಡಿಸಿದ್ದಲ್ಲಿ ಸದರಿ ಆದೇಶವನ್ನು ಅನೂರ್ಜಿತಗೊಳಿಸಿ ಈ ಆದೇಶವನ್ನು ಜಾರಿಗೊಳಿಸುವುದು.
ಆಯ್ತು ನಿಮ್ಮನ್ನ ವೈಡ್ annexure C you have been transferred.
Transferred, your Lordship. Subsequently, BESCOM has accepted it in the annexure D, your Lordship.
ನಿಧಾನಕ್ಕೆ
Annexure D.
On 27/6/2025.
Yes, your Lordship.
You have been transferred. Where is that your name?
My name is found at a serial number 11, your Lordship, and respondent 6 is at serial number 12.
You are in serial number 11.
11, your Lordship. Manjunath H.
Manjunath, yes.
Yes, your Lordship. ಬೆನ್ಸನ್ ಟೌನ್ ಘಟಕದಿಂದ ವಿರೂಪಾಕ್ಷಪುರಕ್ಕೆ.
ಇನ್ನೊಬ್ರು ಯಾರು?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6, ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಅಲ್ಲೇ ಕೆಳಗಡೆ your lordship.
ಸೀರಿಯಲ್ ನಂಬರ್ 12.
Yes, your lordship. ಅವರು ವಿರೂಪಾಕ್ಷಪುರದಿಂದ ಬೆನ್ಸನ್ ಟೌನ್ ಘಟಕಕ್ಕೆ.
ನಿಮ್ಮನ್ನ ಅಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ ಮಾಡಿದ್ರು.
Your lordship. And subsequent to this, your lordship, Bescom has accepted the transfer order, your lordship. 2/7/2025, annexure D, your lordship, page number 35.
Yes. What is this?
Serial number 4. I found at a serial number 4, your lordship.
ಏನ್ ಓದ್ರಿ ಫಸ್ಟ್?
ಇದರಲ್ಲಿ ಸಹಾಯಕ ಇಂಜಿನಿಯರ್ ವಿದ್ಯುತ್ ಅವರುಗಳ ಚಲನವಲನ ಆದೇಶವನ್ನು ಸ್ವೀಕರಿಸುವ ಬಗ್ಗೆ.
ಆದೇಶದನ್ವಯ ಕೆಳಕಂಡ
ಆದೇಶ ಸಾರ್ವತ್ರಿಕ ವರ್ಗಾವಣೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಜ್ಯ ಸರ್ಕಾರದ ಸಿಬ್ಬಂದಿ ಮತ್ತು ಆಡಳಿತ ಸುಧಾರಣಾ ಇಲಾಖೆ ಸ್ವೀಕರಿಸಲಾಗಿದೆ.
ಆಮೇಲೆ
later on, your lordship, they abruptly withholded the same order on a 4th, your lordship, 4/7/2025, your lordship. That is annexure E, page number 35. ಸಹಾಯಕ ಇಂಜಿನಿಯರ್ ವಿದ್ಯುತ್ ಅವರುಗಳ ಸ್ವೀಕರಿಸಿರುವುದನ್ನು ತಡೆ ಹಿಡಿಯುವ ಬಗ್ಗೆ. Without there being any speaking order, without any order, a rule provision narrated in this order, your lordship.
Then what is your
in reference, your lordship, kindly Karnataka Vidyut Prasarana reference number 2, your lordship.
Aito, what is that rule which has been violated?
Rule, your lordship, the transfer guideline speaks about the rule 2 clause 3, your lordship, chalana valana.
Aito, adalla aito.
Yes, your lordship.
Which is that violation? Which is that condition is violation?
The competent authority, 2 clause 1, your lordship. My competent authority is KPTCL, who is a cadre control authority, your lordship, as per that provision.
Where is that your appointment transfer order is issued by whom? KPTCL.
KPTCL.
You are appearing for the KPTCL.
But I have not yet filed wakalat in this matter.
You are appearing for a KPTCL. You are the transfer.
And one more submission, your lordship.
Who is that? Where is that impugned order? Annexure.
Annexure E, my lord.
Annexure E, your lordship.
39, page 39.
Page number 39.
By whom?
Bescom.
Bescom, your lordship.
How can they alter that? That too without within 2 years. That is what that your contention.
And one more thing. One more thing, your lordship. It's a
Movement
mature
order has been cancelled, my lord.
How can that cancel? Once it is transferred, you have no jurisdiction. Again, it should be by a
transferred. Then, my lord, Bescom has a right to accept, my lord. That is what it is, my lord. That I will seek instruction because he's an employee of Bescom. He was employed with Bescom. So Bescom has cancelled it.
No, he is an employee of the Bescom.
He is working in Bescom, my lord.
Yes. But appointing authority is KPTCL.
Appointing authority is KPTCL, but working in Bescom.
ಆಯ್ತು, Bescom ಮತ್ತು ನೀವು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋದು ನೀವೇ ತಾನೆ?
I'll just seek instructions how Bescom has done this.
How Bescom?
Bescom has cancelled the order, my lord. KPTCL has passed a movement order. Then, therefore, after which, my lord, Bescom has accepted it. After acceptance, my lord, Bescom cancels it.
They have no right. That's what last occasion they have accepted it. Only thing is, I have noted that there is a reference. Chalana valana is not in a.
That they have not challenged, my lord. They have only challenged the cancellation order.
ಹೇಳದಂಗ ಕೇಳಿ.
ಸರಿ.
ನಾನು ಹೇಳಿದ್ದು ನಾನೇ ಅವರು ಒಪ್ಕೊಂಡು ಡಿಸ್ಪೋಸ್ ಅಲೋ ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ನಾನೇ ಹೇಳಿದೆ ಚಲನ ವಲನ is not a transfer ಅಂತ. Then some other council has said, in division bench said, this is also in a transfer. Therefore,
writ appeal 1146 of 2020.
That they have not challenged here, my lord. They have not challenged that transfer order which is made by KPTCL.
No, they have not.
They have only challenged the cancellation order of the Bescom.
Yes.
No, Bescom, they said.
My lords are right in that. My lords are right in annexure C.
In the last time.
Annexure C, my lords are right.
I will dictate you here.
ನಾನು ಬೇಡ ನಾಳೆ ಹಾಕೊಳ್ಳಿ.
No,
ನಂದು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
I will permit you to file, Mr. I am about to allow this writ petition.
Please.
Even that Bescom council has also argued 2 times and agreed. I only make out in a point saying that, see, this point has not been notified. Then she is also realized, yes, she came. She said that, yes. Then other council has
assisted.
Given that there is a division bench order.
Yes, your lordship.
That Chalana Valana is also in a transfer.
In reply also, your lordship.
Yes, madam. Yes, that's all. You have argued last time, only that is the point. Now that division bench judgment is there. Yes.
That was the momentum order, but wherein during the course of the argument, the judgment was referred in so far as writ appeal 1146 of 2024.
Hmm.
But so far as that, my lord, the only distinction which I can just make, my lord, the transfer guidelines which was imputed in this writ petition was not in question before the before in the writ appeal. So the transfer guidance here, my lord, was in.
No, that is not transfer. Their law has been explained.
Please.
Chalana valana is also a transfer.
ಅದನ್ನ ಅವ್ರು
ಅಲ್ಲಿ
ಟ್ರಾನ್ಸ್ಫರ್
deep-
ಮಾಡಿಲ್ಲ,
ಅಲ್ಲಿಲ್ಲ
ಅದನ್ನ
ಸ್ವಾಮಿ,
ಕ್ವಶನ್
ಅಲ್ಲಿ-
ಮಾಡಿಲ್ಲ ಅವ್ರು.
ಯಾರು?
ಇವರು ಅದನ್ನ
No, mister.
ಅಲ್ಲ my lord, I am only saying this. My lords are right. If at all there is a movement order,
That
then it
movement
will
order
results
is
to
a-
transfer.
ಅವ್ರು ಅದನ್ನೇನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ
Yes,
ಇಲ್ಲ.
my lord.
ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ, ಏನು
ಇಲ್ಲ.
ಮಾಡಿಲ್ಲ. ಮೂವ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದಾರಲ್ಲ,
Yes.
ಕಾಂಟ್ರರಿ ಟು ದ ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್ ಅಂತ ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು. ನಾನು ಹೇಳಿದೆ ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್ ಅಪ್ಲಿಕೇಬಲ್ ಆಗಲ್ಲ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಎ ಮೂವ್ಮೆಂಟ್ ಆರ್ಡರ್. Now it is clarified that movement order is also transfer. It is my mistake. I have shown that, mister. Otherwise I could have been disposed of. What is this? Yes. I just brought to her notice that
Please, my
ಇಲ್ಲಿ
lord, please.
ಚಲನವಲನ ಅಂದ್ರೆ ಚಲನವಲನ ಪ್ರಕರಣಗಳು ವರ್ಗಾವಣೆ ಎಂದು ಪರಿಗಣಿಸತಕ್ಕದ್ದಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್
Then
ಅಪ್ಲೈ
this
ಆಗಲ್ಲ,
judgment.
ನೋಡ್ಕೊ ಬನ್ನಿ ಅಂತ ನಾನು ಹೇಳಿದೆ. ಅಷ್ಟೊತ್ತಿಗೆ some counsel has assisted saying that this has been considered, said that this is also transfer.
Mal-
I said I want to see that judgment. I have gone through that judgment in
Yes,
my
ma'am.
house. It said that it is in a transfer. It is by the division bench.
Okay.
I have no other voice to say.
Yes, my lord.
My lord,
And
only,
one more
only
submission, your lordship.
one submission, my lord, one submission, may I just permit, my lord?
Yes.
So far as the judgment, my lord, the division bench's judgment, it was under the transfer guidance of 2004, my lords.
Hmm.
2013 additionally, there was a definition of transfer and deployment. So what
Oh,
can,
madam. ಚಲನವಲನ is also the deployed. In English ಅಲ್ಲಿ it is deployed. That's what that is answer.
another submit, my submission may be recorded, my lords, so far as, my lords, this transfer.
Saying that deployment is not in a ಚಲನವಲನ.
Well,
What is that?
that is my contention is that, my lord, the transfer, in the transfer guidance which was impugned in the.
You take that English translation.
ಅಲ್ಲ ನಾನು ಏನ್ ಹೇಳಲಿಕ್ಕಂತ ಇರೋದಂದ್ರೆ ಸ್ವಾಮಿ, so far as the transfer guidance, this is dated 12/5/2025.
You can argue with this thing. I will stay that order. Which is that impugn order is stayed.
Well, it's already stayed, my lord.
It was stayed, but
My submission may be recorded, my lord.
What is that your submission?
Well, my submission is that, my lord, I just wanted to draw a difference, distinguish the judgment of the writ appeal to the effect, my lords, the transfer guidance.
What is the division bench judgment? ನಾನು
Please,
ಅಲ್ಲೆಲ್ಲ
ma'am.
ಚೇಂಬರ್ ಇಟ್ಟು ಬಂದಿತ್ತು. Yes. Yes, madam.
Please, my lords. But so far as this judgment, my lords, this judgment refers to the transfer guidance which was impugned, my lords. It was transfer guidance 2024, my lords. In this judgment, my lords, there was an argument which was laid that one person who has been transferred within the same headquarters, it comes under a deployment and the same similar, my lords. Transfer does not mention. But my contention was that, my lord, this guidelines was never challenged, my lord. As on today, this guidelines is in force, my
No,
lord.
madam, it is not challenged. Guidelines has been explained by the division bench.
Please.
See, deployment is also in a transfer. What is mentioned in the
Page number.
explanation is not in a law. That is what that court said, madam. That is what that court. He
I
need
bow
not
down,
challenge.
I bow down, my lord.
Here also
Only-
not challenged. Here said
Yes.
that it is not, it is in a deployment, therefore it is not in a transfer. That is that argument. Court has accepted.
This judgment also was, my lord, premature
My order to the
transfer.
division
No, my lord, premature, and my submission may be recorded, my lord. It can.
Yes, yes.
The question was, lord, it was like premature transfer and that was interpreted by the division.
That is, he is also arguing that premature because.
ಇಲ್ಲ
transfer-
ಇದರಲ್ಲಿ premature ಇಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. They are working after, as per the group D,
No,
4
madam,
years
after KPTCL transferred, within 3 months or 2 months you have transferred. Therefore, he is saying that premature.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇವ್ರದ್ದೇನ್ ಅಂತದಿಲ್ಲ ಇವ್ರದ್ದು. This petitioner, my lords, they were serving group D, my lords, after 4 years it's not a premature question here, my lord, only the withhold.
After that KPTCL has transferred, you have cancelled.
Withheld on an administrative purpose,
What
my
is
lords.
your right, madam? Once it is transferred,
The same
can
question.
be, see, after that only you can be transferred by that order. You have to be that transferring authority has to cancel. What is your role in that?
One more submission, Your Lordship. In their own statement of reply, Your Lordship, they have stated it was a pure administrative action and after concurrence with the respondent KPTCL.
Yes.
Without the appointing authority recall the same order, they cannot withhold or modify, Your Lordship.
In this writ petition, petitioner called in question. Order dated. Annexure.
Annexure C, Lordship. Annexure C, dated 27/6/2025.
Annexure CL renewed.
Annexure email.
Impugned order, Annexure E, Your Lordship.
Order dated 14 July 2025.
4 July. 4/7.
4 July 2025, whereby transfer order issued by KPTCL void annexure D, na?
Aim.
Please,
Yes.
Malad.
C.
Annexure
D
C,
additionally.
C.
Annexure C.
Annexure C dated 27/6/2025
2025.
has been kept in abeyance.
Next.
Petitioner working as, what is that, Mr.?
Assistant engineer.
Assistant
Engineer.
Engineer
Engineer.
in where?
Benson Town, Your Lordship.
No, in KPTCL or BESCOM?
In BESCOM, Your Lordship.
Working in BESCOM by order dated 27/6/2025. Who is that?
Respondent number 6.
Respondent number 3, na?
6, Your Lordship.
Transfer order ಮಾಡಿರೋದಲ್ರಿ ನಿರ್ದೇಶಕರು ಡೈರೆಕ್ಟರ್. Respondent number 3 has passed a transfer order petitioner has been transferred from Benson Town
to Virupakshapura.
Benson Town to
Virupakshapura.
Virupakshapura. Gataka. In place of
Respondent
number
6, Your Lordship.
Respondent number 6. Thereafter, the respondent number 4 by impugn order
Annexure D.
The transfer order has been kept in abeyance, being agreed by the same. Submitted that the transfer order is passed by that second respondent corporation by annexure C. The respondent number 4 has no authority to kept in abeyance of the transfer order dated 27/6/2025. He further contended that once the petitioner has been transferred, he has a term of 2 years.
Please, Lordship.
As per the transfer
guidelines
produced as annexure B dated 12/5/2025.
Please.
Before completion of the term, the transfer order has been withheld or kept in abeyance. Learned counsel appearing for the respondent 3 and 4 and 5 your 4 and 5 has submitted that in the public interest the transfer order has been kept in abeyance. The order passed by the KPTCL is only the movement order. And it is not a transfer. Therefore, he cannot seek any defense under the transfer guidelines dated 12/5/2025. ನಿಮ್ದೇನಿಲ್ಲ ಇವ yes learned counsel appearing for the KPTCL ವಕಾಲತ್ ಹಾಕಿದ್ರಾ yes BL Sanjeev counsel undertaking for respondent 2 has submitted that respondent number 2 has passed a transfer order by annexure C in accordance with law since petitioner has as on 27/6/2025 petitioner has completed his term of 5 years. Heard the learned counsel for the parties peruse read papers. It is not in dispute by order dated 27/6/2025 petitioner has been transferred. Petitioner has transferred to the place of private respondent, that is from Benchan town to Virupakshapura Gataka 2022, Virupakshapura Gataka 2022. Once the transfer order has been given effective, the fourth respondent has no authority. Once the transfer order has been passed by the KPTCL, the respondent number 4 has no authority to keep that order kept in abeyance. Even as per the transfer guidelines, the Group D employees has a term of 2 years. The transfer order has been passed by KPTCL on 27/6/2025. Within 1 month, the impugn order has been passed. Secondly, this court is also, division bench of this court has in writ appeal number 1146 of 2024 disposed of on 3rd September 2024 has considered that deployment is also a transfer, and explanation given under that transfer guidelines in respect of deployment cannot be
ಇಪ್ಪತ್ತೆರಡನಲ್ಲಿದೆ ಸರ್.
The transfer guideline governs the office memorandum transfer office. The impugned transfer posting is regional head office. Detail of the posting contains and regarding deployment is traceable. Yes, deployment is in a mandate subject to the conditions stipulated in transfer guidelines. So and so. Is the case deployment so and so respondent. It is that explanation cannot be read as in a part of law ಅಂತ ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ. Following note definition of the transfer.
Page number 19, Your Lordship.
Note
15 ನಲ್ಲಿ
note
ಬರುತ್ತೆ ಸರ್.
to
Para
definition of the
15
transfer state that movement government order within the same unit for one post another desk same head office shall not be treated as a transfer. Office note, the scope of the note, all for consideration before this court held that posting of a government servant one office to another office, transfer definition level agreement so and so. As consider this aspect in so and so, the relevant paragraph, para 26, 27, 28 extract matter. In view of the above, the impugn order annexure E is passed without jurisdiction and contrary to transfer guidelines. Accordingly, impugn order annexure E is quashed. Yes.
Direction may be given, your lordship, to report the place.
Annexure E is quashed. You go and file a representation, they will give a report.
Please, your lordship.
Manoj, my apologies, Manoj.
No, that's
Please.
okay. I also noticed that there is an explanation there.
Please, Manoj.
ಇಲ್ಲಿ ಸೂಚನೆ ಅಂತಾರೆ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ಕನ್ನಡದಲ್ಲಿ ಏನದು ಚಲನವಲನ ಅಲ್ಲಿ ಡಿಪ್ಲಾಯ್ಮೆಂಟ್ ಅದು. ಯು ಸಿ ದಟ್ ಇಂಗ್ಲಿಷ್ ವರ್ಷನ್ಸ್ ಆಲ್ಸೋ. ಐ ಆಫ್ಟರ್ ಸೀಯಿಂಗ್ ದಟ್, yes, that day therefore I took that judgment and I gone through that, then this is that. Since division bench has held, we can't do anything.
Please.
Oblige. 62 adjourned, 63 Anusha L for petitioner, Siddhartha Babu Rao.
Yes,
My lords, appearing for R3, my lords. Objections are ready, my lords. We will file it in registry.
Page 22, my lords. Is an order of appointment as Morarji Desai, mathematics teacher. That she has applied it, and then, my lord, the district verification committee of Chikamagalur, page 94, my lords. Divya, page 94. ದಿವ್ಯಾ ಆರ್ ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ಅಲ್ಪಸಂಖ್ಯಾತರ ಕಡೂರು ಇಲ್ಲಿ ಗಣಿತ ಶಿಕ್ಷಕರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಾ ಇದ್ದಾರೆ. ಇವರ ಸೇವಾ ಅವಧಿ 1/6/2010 ರಿಂದ ಸೋನ್ಸೋರವರೆಗೆ ವಿಜ್ಞಾನ ಶಿಕ್ಷಕರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದು 16/8 ಸೋನ್ಸೋರವರೆಗೆ ಶಿಕ್ಷಕರಾಗಿ ಕೆಲಸ 1/4/2001 ಶಾಲೆಯಲ್ಲಿ ಕರ್ತವ್ಯನಿರ್ವಹಿಸಿದ್ದಾರೆ. ಸೇವಾ ದೃಢೀಕರಣ ಪತ್ರಗಳನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ಗಣಿತ ಶಿಕ್ಷಕರ ಸ್ಪರ್ಧಾರ್ಥಕ ಪರೀಕ್ಷೆಗೆ ಹಾಜರಾಗಿದ್ದು ಪರೀಕ್ಷೆ ಬರೆದ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ. ವಿದ್ಯಾರ್ಥಿಯ ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ವಿದ್ಯಾರ್ಥಿಯ ಮೂಲ ದಾಖಲೆ ಪರಿಶೀಲಿಸಿದ ನೇಮಕಾತಿಯಲ್ಲಿ ಕೃಪಾಂಕ ಪಡೆಯಲು ಅರ್ಹತೆ. My lord, the district verification committee said I am entitled for a weightage.
Yes.
Now, my lords, meanwhile there is a judgment by this honorable court, by the learned single judge, my lord, page 100. By reading the regulations, it is not the concerned subject. It is calculated on the basis of the year of service, page 102.
Yes.
The said submission is to be rejected on the ground notification does not discriminate between applicants who applied for teaching one subject and taught some other subject. They are entitled for the weightage on the basis of number of years of service as per the plain reading of the notification.
Yes.
The number of years is to be the only ground on, not on the subject taught. Now, my lord, this was taken up in appeal.
Yes.
If your lordships kindly take page 104.
Yes, we are also part of that bench.
Yes, my lord. Paragraph 4, my lord, page 107.
Yes.
I think by this time your lordship must have read this.
Yes.
Some others must have taken to your lordship.
Yes.
Then paragraph 4 of the learned single judge.
Yes.
Then, my lord, there is a direction to extend it. The matter went to Supreme Court.
Yes.
On 23/2/2024.
Yes.
The SLP came to be rejected.
Yes.
Now, my lord, the endorsement which has been issued to me is in 2001, after the district verification committee.
Yes.
They say that I was appointed as a Ganita, that is mathematics. They say Vande Shaleyalli, page 113. This is an endorsement in 2019,
Yes,
page 113, my lord.
yes,
From the bottom, my lord, the second paragraph,
yes.
right side. ಒಂದೇ ಶಾಲೆಯಲ್ಲಿ ಫಿಸಿಕ್ಸ್ ಅಂಡ್ ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ ಮೆಥಡ್ಸ್ ನ ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ ಇಬ್ಬರು ಗಣಿತ ಶಿಕ್ಷಕರನ್ನು ಒಂದೇ ಅವಧಿಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ನಿಯಮದಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನೀವು ಗಣಿತ ಶಿಕ್ಷಕರಾಗಿ ಒಂದು ಪೂರ್ಣ ವರ್ಷ ಸೇವೆ ಸಲ್ಲಿಸಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ನೀವು ಸೇವಾ ಕೃಪಾಂಗ ಪಡೆಯಲು ಅಲ್ಲ. Now 1 year Ganita Malad is admitted by the director. Some other teacher has been appointed in physics. They say that we can't give you the weightage. Now Malad, then 2021, I gave a representation, Malad, saying that all my originals have been given to the department.
Yes.
Until now, no steps have been taken. Now, Malad, this is exactly recently the Honorable Supreme Court, I think this has been seen by your lordships. This is the judgment of my Lord Justice Veerappa J.
Yes, that has been confirmed.
My Lord, 6 ತಿಂಗಳು ಒಂದ್ ವೇಳೆ, that is how my Lord Justice Sujata J. my Lord said, even if it is 3 months, it has to be proportionately. Now, my Lord, there is a direction that the entire list has to be reviewed within 2 months. That's the position. This is for 2010 and 11 selections.
Yes.
Now, my learned friend has raised, just now a copy has been served, that there is a delay. There is no delay in this case, my Lord. I have explained. In 2019, the endorsement has been issued.
Yes.
I was waiting. 2019, the judgment has come. Then it went to the division bench in 2023.
Yes.
2025, the Supreme Court said. So far as my personal difficulties are concerned, 2022, I got married. Then, my lord, a child was born, and I could not able to reach the Bangalore, my lord, is the explanation given. COVID, so many factors I have stated, my lord. This is the explanation given.
When that
Now,
endorsement is given?
Pardon, my lord. 19, my lord.
2019. 19, yes. Then COVID.
My lord, at that point of time, the division bench, my lord Chief Justice Woka J. judgment was pending, and again SLP was pending. That SLP was disposed of in 2024. That these are all from village people. They were waiting whether the Supreme Court would grant relief or not.
Yes.
My lord,
I have
yesterday,
stated,
the
my
similar
lord,
matter has come up, my lord, 36350 of 2025. 5-3 is the date given on the objection of Srinivas, my lord. Here in R2, Baburav is appearing, my lord.
Now, the thing is that
Yes.
here endorsement is issued 2019. In cases where division bench said 15 or approach agila yellow.
my lord,
Yes, 15, 19, 19, 20 till 20 they cannot approach because of the COVID and all. 21 to 22.
No, up to, my lord, 1/4/2022, based on the Supreme Court judgment, COVID limitation.
Yes.
Up to 2022.
Yes.
In fact, here we have stated 2022, we have been received the papers from the party.
Yes.
In the explanation. Then she also got married in the same year, got a baby in 2023. And meanwhile, my lord, there is an.
Who is appearing for other side?
Srinivas.
For R3, I am appearing, my lords.
My lord, in the
Weight may
accounter,
be
he
fixed, my
says
lord.
14 years delay anta one judgment kottidare.
Adu-
That is not applicable here.
No, there after 15 years, no, 2015, they have not done after the disposal.
No, all my original records were given. That is how in the
That's
explanation I
difference-
said.
Difference for your case to that case. Here they have not approached after 15. But his case is that endorsement is issued 2019.
19.
Then 19, 20, 21, 22 exemption.
22, 1st April.
ಅಲ್ಲ 21ರಲ್ಲಿ ನಾನು ಏನ್ ಹೇಳಿದ್ದೀನಿ ಅಂದ್ರೆ ನನ್ನ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಇಂಟರ್ವ್ಯೂ ಕಾರ್ಡ್ಸ್ ನಿಮ್ಗೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇದುವರೆಗೂ ನಾನು ಏನು ಕಮ್ಯುನಿಕೇಶನ್ ಪೇಜ್ 114 ಮೇಲೆ
Not similar to that matter. Yes. Where is that? Where is Babu Ram?
My lords held up some inconvenience, my lords.
held up
Date may be
5:30.
fixed, my lords.
Which court is, yes. Yes, ಆ matter ಯಾವತ್ತು ಹೋಗಿದೆ?
5/3, my lord, 2026.
Yes, leave this matter on 5/3.
And it is filed by that junior, means colleague of Sir itself, my lord.
Which one?
In the extra days matter, my lord.
Yes.
Same ground, same.
My lord, day after tomorrow.
Ground they are raising is
Delay.
Yes. But in other cases also, even that we have directed to consider.
Yes.
Other bench has said, I have also directed to consider. We'll see this, what that objection they will raise.
5/3, my lord.
5/3.
My lord, delay is not applicable, only one submission. In 2019, my lord, Justice Veerappa,
Even if they're not approached from 2015, in that one matter, court has directed to consider. Therefore, I am also following that. Your case is something better than that. Let us see what is this.
my lord, Friday, your lordship have it.
No, that other matter is similar to you. It's posted on
5/3.
5/3.
Thursday.
We'll have it on 5/3. Yes.
Cell number 64, Viray Remote for petitioner, BL Sanjeev.
Dr. For the petitioner.
Yes.
My lord, in this matter, the government has to file objection to this petition.
Yes. Government advocate praised 2 weeks time to file objection. You want to say anything, Mr.
My lord, I'll also have to file objections in this.
Yes.
Date may be
He
fixed.
himself is support to you. Why do you want? They take that. I'm already in 6 years. Correct. 2 weeks. 2 weeks.
Serial number 65.
65, date may kindly be fixed, my lord.
Yes.
For respondent number 1, my lords.
Yes. On 17.
Except 17, after 17 or before that, my lord.
24th.
Please, man.
Yes.
66, Vijay Kumar.
Appear for respondent numbers 5 to 16.
Appear
Yes,
for
leave
respondent
this
number
matter
3
on
and 4, my lords.
23rd.
Grateful.
Great.
67, Sunil KN.
For petitioner in this.
Yes, what is
Lord,
this?
without an inquiry, my lord, the order has been passed, my lord, removing the petitioner from
Who is
service.
your opponent? Nagarajappa. Is government or panchayat?
Panchayat.
No inquiry is conducted.
No inquiry has been conducted.
Where is that order, Mr.?
My lord, Annexure E, my lord. On 38/2025, my lord, the petitioner, my lord, has been removed from service.
ಹಾಸನ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಅವರೇ ಮಾಡಿದಾರಾ? Where you are working?
My lord, I was working at my lord, Arsikere Taluk, Hassan district, my lord, as a Taluk nodal officer.
ನೋಡಲ್ ಅಧಿಕಾರಿ ಗುತ್ತಿಗೆ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಅರ್ಚಕರು ಇವರನ್ನು ಕೂಡಲೇ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿದೆ. ನೋಡಲ್ ಅಧಿಕಾರಿ ಗುತ್ತಿಗೆ, you are on contract basis.
On the contract basis, my
There
lord.
is an FIR registered against you.
My lord, on the same day itself, my lord. Avattene shokas notice has been issued on
ಆಯ್ತು,
29/8/2025, my lord.
ಇನಿಷಿಯೇಟ್ ಆದ್ಮೇಲೆ then what is that to inquiry?
On the next day, without giving an opportunity of
What
filing an
opportunity, what explanation you are given? Is it not true that FIR is registered or not?
My lord, wrong FIR has been registered against me, my lord. Only
ಅದು ಯಾರು
1.5
ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು? ಕೋರ್ಟ್ ಅಲ್ಲಿ ತೀರ್ಮಾನ ಆಗ್ಬೇಕು ತಾನೆ, which is wrong or right?
only 1.5 month, my lord. Only
Yes,
1.5
we'll
month
see.
I have worked there, my lord.
File an objection, yes. We'll see, yes.
My lord, without an inquiry, my lord, I has been
Let
removed
us
from
see, it
service,
is
my lord.
required for an inquiry for these cases, we'll see that, yes.
Lord, till then, my lord, I am permitted to work there, my lord. My lord.
Criminal case has been initiated against.
Let
yes.
the departmental
For an
inquiry be continued,
temporary
my
on
lord.
contract basis. Yes.
68, Varun
Lord,
Sai
date
Y.
may be fixed.
Yes, leave this matter on 23rd.
68, Varun Sai.
Matter, my lords, where I have retired in the year 2022. Till date, my lord, my settlement and the benefits is not dispersed, pension is not being paid. It's a matter of livelihood, my lords. And no due certificate code as per Annexure D.
Mandamus there responded to disperse the retirement benefit. Petitioner given by the, we have given a representation.
Please, my lords.
Who has to give?
The respondent number, my lords, 1 and 2 collectively, my lords.
Government.
I appear for the respondents, my lord. My lords, we
yes,
will
Mr.
consider
Lee.
it in accordance with law, my lords.
Yes. In this writ petition, petitioner sought following relief. The case of the petitioner that he was joined as an daily rated employee.
Daily rated employee, afterwards regularized.
Daily rated employee on 19/4/1984. Thereafter, his service has been regularized when?
That's service, my lords, was regularized on. Just a minute, my lords.
Regularized as an attender. Attender,
Please, my lords.
Thereafter, he was promoted to that laboratory assistant.
Please, my lords, I retired as a laboratory assistant.
And he was retired as a senior laboratory assistant on 30th/9/2022. After that retirement, his retirement benefit has not been settled. Therefore, he has submitted a representation
As per Annexure A and A series.
Annexure A series on 1/9/2025. The same is not considered. Therefore, the petitioner is before this court. Learned counsel appearing for respondent. Error ಕೊಟ್ಟಿದ್ದೀರಾ?
2 and 3, my lords.
Respondent number 2 and 3 has submitted that. If this court grants some reasonable time, representation submitted by the petitioner will be considered in accordance with law. In view of the above writ petition is disposed of, directing the respondent to consider that representation in accordance with within 3 months from date of receipt.
It's 2 months because 3 years ಆಗಿದೆ.
Yes,
Much
2
obliged, my lords.
Number 69 adjourned, cell number 70, Aditya R. Chakragiri.
My lords, I appear for the petitioner, my lords. This is the case pertaining to promotion, my lords.
Yes, we'll require hearing.
For R3, my lord.
Yes, leave this matter on 23rd. Yes.
Please.
Cell number 71, Maitreyi Krishnan.
Yes.
Lord, this is the matter in respect of the arrears that are due to the D group employees.
High Court employees. Yes, why it's on your request it is posted? Where is AHE? It is only because yesterday to today it is urgent.
Even on Saturday, my lord. In
No,
fact,
we are
it was-
provided to appear through VC also, mister. Where is that? No, yesterday also it is urgent today, mister.
It was on Saturday, my lord. From Saturday it was actually.
Saturday to today.
Please.
Yes, mister.
Tomorrow, my lord.
No, what is that instruction? Why it is cannot be paid, mister? Tomorrow.
Inform him.
You get that instruction, mister. If it is, you can take the instruction and make submission.
Lord, their objections also I had pointed out on the previous occasion.
Yes.
In their objection itself it is clear.
Tomorrow, we'll see. Yes. At the request of government advocate, leave this matter tomorrow.
Cell number 72, Andita Chakraborty for petitioner, TP Rajendra Kumar Sangai.
Your Lordship, it is for payment of the pension by UVC. We have received information that yesterday they have received
Really,
the
my lord,
amount.
there was no fund. It appears yesterday they have received some fund from the state government. We'll consider, my lord, within 2 to 3 weeks, my lord,
Your
time is
Lordship,
granted.
my humble submission is the petitioner's case may be considered first in payment of pension.
Your case has to be considered first.
Your Lordship, it is because of the legal recourse taken by the petitioners, they are under force and means arrange this amount.
Now that they have received some money, let them settle. Yes. Then the writ petition, petitioner sought following relief. Petitioner is working, he was working as an instructor in the Department of Electrical Engineering.
4 petitioners. Sir.
There are 4 petitioners are there, my lord.
4 petitioners are. Ellaru ಏನು post ಮಾಡಿದೆ? The
Different-
petitioners are a retired employee of
Non-teaching staffs of UVC.
respondent one university. After, when they are all retired,
They have retired from 31st/5/2023 to 36/2025 in between.
they have retired from the service from 31st/5/2023, in between 35.
See 36/2025 in between.
30,
36
Page number 4, my lord, list
Page
of
number 4.
dates ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಅವರು.
yes. No, they are retired from the
ಅದೇ
service
ರೀತಿ, ಹಾ.
and they have submitted their application for settlement of pension as per annexure E series. Since their pension has not been settled, therefore the petitioner is before this court. Learned counsel appearing for the university has submitted that the petitioner request for settlement of the pension will be considered in accordance with law if this court grants some reasonable time.
Your Lordship, they are saying as per seniority it will come. But
They have not said anything, my lord. That's only oral.
that is what they are sending and they have
No, can
indirectly
I
pressurizing the.
decide that on the basis if they are discussing with you, unless there is any records on that?
That's true, my lord.
We'll let them give, then we'll see. Yes. In view of the above, without expressing any opinion on the merit of the case, respondent number 1 is directed to consider the case of the petitioner for settlement of retirement benefit and the pension in accordance with law as expeditiously as possible, not later than 8
And
weeks.
also, Your Lordship, interest, there is a government order, if there is a delay after 3 months,
Yes.
12%
including
interest.
interest. Yes.
Serial number 73, Vaishali Agrawal for petitioner, Sinchana MR.
Yes.
I appear for the petitioner, my lords.
Appearing
Yes,
for
ma'am.
respondent number 1, my lords.
What is this
In this
matter? Required hearing.
My lords,
Yes.
it requires hearing, my lords, and the KPSC will have to file its objections, my lord.
My
Has
lords,
challenged the
not the KPSC, the government has given the circular, my lords, to withdraw the notification in view of the roster point which has been changed in the SC/ST on the reservation categories, my lords. That was the
No,
reason
but
the
I think division bench has directed to go ahead with that as it is existing earlier.
which has been particularly mentioned by learned AG, my lords, on particular notifications, not on everything, my lords. Here they said clearly instruction given to the KPSC, my lords, to withdraw the complete notification. So it has
That
been
has been
withdrawn.
challenged in that PAL. I think division bench has directed to go ahead with that, but not to that that order. Kodi, you get that order.
Please,
Will see.
I'll make
a date may kindly be fixed, my lords. There is some urgency in
Yes,
this
yes.
matter.
Yes.
10th.
Please.
Much obliged, my
Number
lords.
74, PN Nanjareddy for petitioner.
Yes,
Appearing for the
Well, this-
respondent, my
and
lords, a
must-
week's time may be granted to
There
file
is
the
simple
statement of
case, my lord,
objections.
What is this, Mr.?
There was he was promoted to the tax assessor. My lord, thereafter it was withdrawn on the ground that my lord, the criminal, that there is a case pending, inquiry pending anta. ಆಮೇಲೆ after completion of this my lord, inquiry, he has been exonerated from charges. Even after my lord, they have not given
No, what is that they have withheld?
promotion to the post of my lord, tax assessor.
My lord, I have
That
received the
dishonorable court
documents
direct, last
yesterday.
time they had taken time.
Now that if there is no any other law
Yes,
asks you to promote, you give a promotion.
Yes, correct. That's
My lord, I have just received the documents yesterday, my lord. I'll file my statement of objections within the week. Kindly
And,
grant.
Notice has been issued, madam.
Yeah, last time they have taken notice.
It is not that you have received yesterday, I have to grant,
Yes.
but it's their duty to supply. On 19/12/2025,
Yes.
notice has been issued, madam.
2 months are over.
Yes, my lord, I have not received the
The
instruction.
request of counsel for the respondent as a last chance. Read this matter on 9th.
Yes, my lord.
Otherwise, we'll proceed. Yanilla adralli, see, now whether is there any bar for
Yes.
considering his case or not, you have to say.
That's
If you
the
show any that law, then we'll not permit.
Yes, my lord.
Yes.
Serial number 75, Tirthappa.
I appear for respondent number 1 and 2, my lord.
Yes.
I pay for short accommodation. Kindly have it
Request.
immediate.
Respondent number
My lord, this
one
is,
and you are
my
appearing.
lord,
in this.
this is a case where last time my learned friend has produced the stay granted by the secretary.
My lords, we are engaging a senior counsel. Kindly have it tomorrow, my lords.
ನಾನು
one minute
ಮಾಡ್ತಿದ್ದಾರೆ,
ಹೇಳ್ತೀನಿ.
facts ಕೇಳ್ತಾರೆ.
My lord,
Concerning that matter also, I will hear the facts in that urgency of that matter.
Please.
my lord, we
For
filed a,
urgency, I will grant longer time. Therefore, I'm even then after 6 o'clock, adjourning also, I will hear because of that reason. If
My
there is any
apologies.
urgency, if I given a wrong date, then party will be suffer.
My
Yes.
apologies.
my lord, we have filed a writ petition for a mandamus to implement the order passed by the authority under the act. Respondents have been served. After putting an appearance here, they took out the earlier order, not the main order. They moved an application before the state government and the stay granted, then until disposal by this authority or High Court. In the next date of hearing, I will also check whether this court or the High Court can hear. Who is this authority, my lord? Whether parallel proceeding. Under the Contempt of Courts Act,
No, what is this matter? Who is that?
my lord, there is 4 years, my lord, his salary has not been paid. He was kept under suspension.
Yes.
They under the act, my lord, under section 32, before a person kept under suspension, prior approval is required,
Yes.
including the termination.
Yes.
Nothing has been done. Then, my lord, he has been directed to reinstate, pay the back. That is an order, annexure G5.
By
That
who?
has not been stayed.
Who has passed this order?
That is a joint director
This order is, you are seeking for implementation of this
of
order.
this order.
Now
My
what is
learned
this?
friend has been notified. He has come before this court, and after putting appearance here, they went to the secretary. Now the secretary says it is a parallel proceeding. I will decide. Who is that authority, my lord, to
Where is that
decide?
order? Secretary.
My lords, I've produced it by a memo.
This is a
on the last
contempt,
date.
my lord. Parallel proceedings is nothing but a contempt. There are more than 20 judgments on this.
Yes, what is this order he has passed?
My lords, they are seeking implementation of order dated 13/11/25 produced via annexure G5. My lords, this order we had challenged it, my lords, before the Secretary of the Higher Education.
Yes.
Which order came to be stayed on 13/2/2026. My lords, in fact, I had, when the matter was listed before this honorable court for the first time, I had made a submission here telling that there's a matter pending there and I'll address my arguments there and let this court know. And on the last date, I produced the certified copy of stay order, my lord.
Interim order of reinstatement of the petitioner doesn't allow AT to hear the appeal.
Lord, what they have challenged is 30th August 2025 order, not this 13/11/2025.
30th August order.
That is direction, my lord, to pay page 384, last paragraph. ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಾನ್ಯ ಆಯುಕ್ತರ ಪತ್ರದ ಸೂಚನೆಯಂತೆ ಶ್ರೀ ಜೋಸೆಫ್ ಮಾರ್ಟಿನ್ ಗೋವಿಯಾ ಸೆಕೆಂಡ್ ಡಿವಿಷನ್ ಕ್ಲರ್ಕ್ ಇವರನ್ನು ಈ ಪತ್ರದ 1 ವಾರದೊಳಗೆ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಸಿಕೊಳ್ಳುವಂತೆ ವಿಳಂಬಕ್ಕೆ ಆಸ್ಪದ ನೀಡದೆ ನಿಯಮ ಬಾಕಿ ಇರುವ ವೇತನ ಇತರ Now, my lord, forget about this order, my lord. But when a person is kept under suspension without the prior approval of the authority, my lord, I should be paid wages for 4 years.
No, that is true. Now that there is
This order is not stayed. What has been stayed is earlier there is a direction by JD to the management secretary that is on 30th of August 2000.
Where is your appeal memo, Mr.
So they'll produce it tomorrow, my lord.
What is your challenge before that?
My lord,
I think last occasion
initially I challenged the order dated 38/25 asking me to conduct a re-enquiry, my lords. When the matter was not even listed before the authority, a subsequent order came to be passed by the joint director asking me to reinstate the employee. That which order I have challenged before the same authority, the same petition by an amending application filed there, and I sought an interim stay of that order as well.
Interim order is granted.
It's granted, please, my lord.
No, my lord. Interim order is granted subject to the whether I should hear or High Court should hear.
No, ಓದ್ಲಿಲ್ಲ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಅದು. Where is that?
ಅದೆಲ್ಲ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ.
Yes.
ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಅಲ್ಲಿದೆ.
Stay granted until final disposal is either given by this authority or High Court. Another, what is that meaning?
My lord, all that the authority would
No
say,
proper procedure.
I will also take a decision on the next date appearing whether parallel proceedings can be continued or not.
ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಆ ತರ?
Last ಅಲ್ಲಿ ಇದೆ, last ಅಲ್ಲಿ.
Dismissed order. No
Last page ಅಲ್ಲಿ
opportunity
ಇದೆ.
was given.
Last 2 lines.
Next hearing, I will also check whether this court or High Court can hear the parallel proceedings.
Now he has put in appearance after the petition. Now the very same relief which I am seeking here, he goes and challenge the first 30th of August 2025. Then, my lord, he doesn't give, there is no amendment of prayer. He also, my lord, now according to his
Now
submission.
he has said they have filed an amendment.
That is a different matter, my lord. How can he goes when he has put in appearance here?
No, why can't? There is an appeal provided under that. He can challenge that.
Pardon, my lord.
No, you are seeking implementation of this order.
Yes.
He has filed an appeal to challenge this order under statutory appeal.
I am only submitting, once he has put in appearance here, he should have sought for permission from your lordships. That is one aspect of the matter.
Yes.
This is nothing but, my lord, a person who comes here, files a vakalatnama, then the same subject matter, he takes up in appeal. This is nothing but a parallel proceeding.
See, statutes has given a.
Yes,
right to
my lord.
appeal.
Statute must have given him a right.
Yes.
But in a circumstances of this nature, he has no power to initiate a parallel proceeding. He has to seek the permission of this court.
I don't think it is parallel because there, here, you are challenging the same order. If he is also filed there, then it is a parallel. There, statutory appeal, you are seeking for an implementation.
Well, that is why I said I will forget all the order.
Yes.
But without an approval of a suspension, without approval of an order of termination, where is the question of
No, now you can file an amended petition challenging that proceedings initiated there.
My lord, that
Then
is
we
why
can-
I suggested in the afternoon.
Then we can say.
I will have to, in fact, My lord, under the Contempt of Courts Act,
Yes.
there is a chapter parallel proceeding. When parties are, my lord, have been arrayed as in respect of a particular session in a particular forum, then the parties cannot invoke some other forum. That is a parallel proceeding. That is a very serious contempt.
Let us see. Let us
My
see. I
lord,
don't
one-
think they have seeking the same relief there. Their relief is something different.
In fact, I filed it there on 2011-25.
No, only thing is that you need not go there. You can challenge that proceedings initiated by filing an amendment. We can examine whether it is necessary for the appeal. That order can be confirmed here itself. That can be
Correct,
done also.
correct.
That can
In
also.
fact,
You can file an amended petition also. That, yes. When do you want?
no, I will have to
Immediately.
challenge it, their appeal before the government.
Yes.
Then both the matter can be
Can be
clubbed
heard.
together.
Yes. Yes. Leave this matter on 16th.
But this conduct of going, my lord, after,
Commission, my lord, it was filed before the honorable authority in 2011-25, way prior to this petition being filed. In fact, it was not disclosed by the petitioner before this honorable court.
Yes. Let us see that. Yes. Yes.
Bill number 76.
I appear for the petitioner in this case.
Yes.
I appear for the petitioner, my lord. This is the case pertaining to payment of subsistence allowance, my lord.
Where
The
is
petitioners,
Sanjeev? Who has to answer? You have to answer.
One respondent 1 and 2 wakalat has been filed, my lord. Please to delete BL Sanjeev's name, my lord, for respondent.
Who is appearing? Tara Guinea. Who is Tara?
He has filed wakalat, not BL Sanjeev.
ಆಯ್ತು ಅವ್ರು ಯಾರು ಬಂದೇ ಇಲ್ಲಲ್ಲ ವಕಾಲತ್ ಯಾರು ಫೈಲ್ ಮಾಡಿದಾರೆ ನೋಡಿ ಇಬ್ಬರದು ಇದೆಯಲ್ಲ ಹೆಸರು ಎಸ್ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಡಮ್
my lords, it's almost 20 months, my lords. They have not paid the subsistence allowance. The order was passed by this honorable court, my lords, in the month of September 2024, my lords. Kindly, the order, it states that, my lords, the respondents are directed to strictly comply at page number 69, my lords. Kindly refer page number 69, in page number 69. I have sought for direction to the respondents.
No, you are under suspension.
Yes, my lords, I'm still under suspension and payment has not been made, my lords, and inquiry has already been initiated against us, my lords. And
Yes,
page number 70.
Allowed hereby past respondent director strictly comply with this so and so until the respondent shall pay the substance allowance to the petitioner as provided. Now, after quashing, you have not been directed to reinstatement.
Yes, my lords, I have not been directed to reinstatement, my lords, but
In this petition, petitioner
and
sought.
my lords, one
Following
submission.
Yes,
I
I am
have
granting
also-
relief.
No, my lords, I have also sought for reinstatement in this case, my lords, based on the in the prayer, my lords, based on the judgment passed by the division bench in writ appeal number 261, my lords, 261 of 20.
Yes, 2 weeks time is granted to.
My lords, kindly a short date may be fixed, my lords, because this is covered under 261, my lords, where all the other petitioners.
Earlier writ petition court has not granted that you have not challenged. Now I cannot grant it. Yes.
My lords,
If you
at
want,
least
you have to challenge by filing an appeal and get. See, earlier quashed, this court said you were only entitled substance allowance. Now I cannot grant, madam. It is
My
contrary
lords,
to
at
the
least-
judgment.
At least
Yes,
payment
we'll
of
see.
subsistence
No,
allowance, my lords, interim prayer, my
No,
lords.
if you are, no, that will hear. If your prior is there, I thought that it can be disposed of.
My lords, at least till the date of the till today, at least they may be directed to pay the subsistence allowance, my lords, because the petitioners are not employed since for 20 months, my lords. It's been
18th,
already
yes.
20.
18th, yes.
In that matter, BL Sanjeev name may be deleted.
ಅವ್ರು ಯಾರು ಇನ್ನೊಬ್ರು ಕಾಣಿಸೋದಿಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಇವ್ರು ಬರ್ತಾರೆ ಯಾವಾಗಲೂ ಒಂದ್ಸರಿ
I will inform.
ಎಸ್ ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ BL Sanjeev ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಎಸ್
77 Andita Chakraborty for petitioner.
Your Lordship, here the petitioner has retired on 72, Your Lordship.
yes will dispose of same.
Say, yes, Your
Yes.
Lordship. Only, Your Lordship,
Sought
this regarding interest, Your Lordship, I am just producing the government order.
I said that consider for all. Yes. Yes, yes. Yes, in this writ
Yesterday
petition.
they have released the fund, Your Lordship.
Yes, in this writ petition, petitioner has sought following relief. The petitioner is retired employee of the respondent university. After retirement, petitioner has submitted their application for settlement of pension and retirement benefit. So far, their request has not been considered. The petitioner is before this court. Learned Counsel appearing for respondent university has submitted that if this court grants some reasonable time, the application submitted by the petitioner for retirement pension will be considered in accordance with law. In view of the above, without expressing any opinion on the merit of the case, respondent is directed to consider that petitioner application for commutation of pension in accordance with law as expeditiously as possible, not later than ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದರಲ್ಲಿ
4 weeks, Your Lordship, because amount has already come.
8 weeks ಹೇಳಿದೀವಲ್ಲ ಅದು 8 weeks
Amount has already come, Your Lordship, now. Yesterday it
ಆಯ್ತು
has been
ಕನ್ಸಿಡರ್
deposited.
ಮಾಡಬೇಕಲ್ಲ ಅದರಲ್ಲಿ 8 weeks ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಮೇಡಮ್ ಎಸ್
Connected two matters are also there, Your Lordship, which has not been listed.
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ ನಾಡಿದ್ದು ಬರ್ರಿ
Cell number 78, Nitin M for petitioner, A. Chandrachud.
For petitioner in this.
Yes.
My lord, in this, my lord, movement order has not been issued, my lord. My lord, annexed E, my lord, on 1/1/2026, my lord.
Transfer is passed and movement
Passed, my lord. 1/1/2026, order has been passed, my lord. Transferring me from Kamakshi Palya to Kengeri, my lord. And movement order has not been issued, my lord. I have submitted a
transfer order.
My lord, annexed E, my lord. Page 34, my lord.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ
From Kamakshi Palya to Kengeri, my lord.
who has to issue movement order
Movement order has to be issued by the respondent number 4, my lord, the assistant executive engineer, Bescom,
petition
K4 subdivision.
sought following relief. The case of the petitioner that was initially appointed as an station attendant grade 2 in the year 2007 and thereafter he was promoted as a junior engineer and posted to Kolar, later transferred to Hassan on 3/7/2023. ಈಗ ಯಾವಾಗ ಎಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ ಯಾವುದು ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್
My lord, on 3/7/2023, my lord.
ಆಮೇಲೆ ಈಗ ಎಲ್ರಿ
My lord, on 25/7/2023, my lord, annexed B, my lord.
ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಯಾವ್ದಪ್ಪ ಈಗ
Annexed E, my lord, impugned order, my lord.
ಅದನ್ನ ಹೇಳ್ರಿ ಬೈ impugned order la by annexure E you have been yes by annexure E petitioner has been transferred from which place to which place
N6 subdivision Kamakshi Palya to K4 subdivision Kengeri, my lord.
ಬೆಂಗಳೂರಿಗೆ ಯಾವಾಗ ಬಂದ್ರಿ
My lord, as per annexure B, my lord.
ಯಾವಾಗ ಬಂದ್ರಿ ಹೇಳ್ರಿ ಡೇಟ್
On 25/7/2023.
on
25/7/2023.
ಹಾಸನಕ್ಕೆ ಹೋಗಿ ಮೂರೇ ತಿಂಗಳಿಗೆ ವಾಪಸ್ ಬಂದಿದ್ದೀರಾ
On 25/7/2023 from Hassan to Bangalore, my lord.
on 25/7/2023 he was been transferred from Hassan to Bangalore by annexure E on 1/1/2026 petitioner was transferred
from N6 subdivision Kamakshi Palya to K4 subdivision Kengeri.
K4 subdivision Kengeri. Thereafter, the respondent who has to issue?
Respondent number 4, my lord.
Respondent number 4 has not issued movement order. Therefore, petitioner has given a representation by the annexure
F, my lord.
Annexure F. Since the representation of the petitioner is not considered by the respondent number 4, the petitioner is before this court. The petitioner has been transferred by order dated 1/1/2026. Thereafter, the movement order has not been issued. Under these circumstances, it is suffice for directing the respondent number 4 to consider that representation of the petitioner annexure F in accordance with law, not later than 2 weeks from date of registered copy.
Even, my lord, salary has not been released, my lord.
ಅದು ಆಮೇಲೆ ಫಸ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್
Please.
Yes.
Serial number 79, Rahul S. Reddy.
My lords, I'm appearing for the petitioner, my lords, in this matter. My lords, it may have it in the next week, my lords.
Read this matter on 11th, Mr. Rajit. Yes.
Cell number 80, Prithvish M.K.
Yes. Yes.
My lords, this is the exam matter, my lords. The issues are covered in the other matter, my lords.
Same.
Similar matter, your lordship have reserved for orders, my lord.
Yes.
This is a similar matter. And
Yes.
my lord, may I make a submission, my lord?
No, there is no any, it is fully covered in that, or you have any?
Similar matters. All
We'll
facts
have-
and laws same.
Yes.
Yes, we'll have it tomorrow.
Tomorrow, my lords.
Tomorrow that matter is coming.
One submission, my lords. They have already issued final selection list, my lords.
Day after tomorrow, yes.
They have already,
tomorrow, yes.
respondent one.
No, maybe tomorrow or day after tomorrow I will pronounce it, yes.
Yes, my lords. Oblige, my lords.
One more, I need to submit a memo, my lord.
What is that?
With respect to petitioner number 8, we are withdrawing only with respect to petitioner number 8.
Yes, on that day only we can make the submission, day after tomorrow.
Is it?
Yes.
Oblige, my lords.
Oblige.
Passed over date code.
Yeah. No, this matter day after tomorrow.
ಎಲ್ಲ ಫುಲ್ ಆಗಿದೆ ಇಲ್ಲ ಅದು ಹಿಂಗೆ ಮೇಡಮ್ ಒಂದು ನಮ್ಮ ಇದರಲ್ಲಿ ಇರ್ತದಲ್ಲ ಸ್ಪೆಷಲ್ ಆಗಿ